And Barnett has one. I couldn't. Well, the yogurt problem, that's.
I want to see what I
Yeah.
I usually work with them. That's the right job is we just sit down. We're studying.
What's that?
It's like what really is they just move so fast. So you can't even tell them to do a good. What's going to
We can we.
So I don't know.
I got it. No, I agree.
Yeah.
You gotta make a move, you gotta move to another part of the country. It's way.
But I don't think that is.
Sure you know. No, most of that. They call it like a senior, not a president.
Well, so now it's like you usually do.
Oh, it's every week, every week, every week. Yeah, so I get two in high school.
Audio check. All right, good morning, everyone, and welcome to the Thunderdome, also known as docket number 251213, application of the Connecticut Light and Power Company, DBA Eversource Energy to securitize 2018 through 2023 catastrophic storm costs. My name is Tom Wheel. I'm the chairman of the Public Utilities Regulatory Authority. I'm joined today by my open-minded colleagues, Vice Chairman David Arconti, Commissioner Jan Beecher, Commissioner Holly Cheeseman, and Commissioner Everett Smith. We're here today for oral arguments. I'm going to give a little overview and a mini speech before we actually start. But before I do that, I want to pause and see if there's any public comment. Hearing none. Does anyone have an administrative matter? I am going to kind of cover. Okay, I'm seeing no. Okay, I will commence with my little speech. I first just want to give a background, as I've been trying to do lately, for anyone who may be watching who's less familiar with PURA processes. For general background, this past winter, Eversource submitted an application on this docket seeking a prudence review of somewhere around $1.4 billion in incurred catastrophic storm costs, inclusive of carrying costs incurred from the date of payment to the expected date of recovery. That kicked off a proceeding consisting of discovery through interrogatory requests and several days of evidentiary hearings. Parties filed briefs, and then PURA issued a proposed final decision on June 29th. The parties filed exceptions to that proposed decision, and we are here today for oral arguments where we essentially talk about those exceptions before PURA issues a final decision on July 29th. I want to try to set the tone for today by just talking a little bit about how this panel of commissioners views the process of coming to a decision, sort of procedurally. When we issue a proposed final decision, it really is our first opportunity to engage in the discussion that's been developing throughout this or any other proceeding. And we view it as a communication rather than an edict. We are really trying to say, hey, here's what we think, here's where we think we're landing on these issues. But the whole reason we're issuing a PFD, as we call it, is to invite everyone to weigh in and respond to us. The PFD is not a decision. We should probably do something about the title of the PFD. It isn't voted on. It doesn't necessarily reflect a consensus view of the commissioners, and it is literally just a draft. And we expect that the final decision will change as a result of your exceptions and arguments. Sort of an aside, but I always felt like PURA has been sort of hampered by the format of a PFD. It's structured exactly like a decision, so there's this tendency among the public and the press and even the parties to view it as sort of a commandment, as I referenced before. I'd actually love to have a side discussion one day in the right forum about our options for changing the way we communicate at these later stages of the proceedings. I would personally much prefer to be clearer that we're entirely open to feedback. I have to say I'm a little disappointed when I see press reporting about PURA draft decisions that authorized X or Y, X or Z, because we haven't authorized anything yet. We're just trying to communicate our best analysis of the case using a somewhat ineffective, maybe a communication tool. But anyway, back to the present case. We are very much here to hear from you today. I personally have many prepared questions for Eversource, OCC, and EOE based on exceptions. I have, just as a heads up, like 15 pages worth of questions for all the parties. So I imagine we might be here for a while. I think my fellow commissioners have questions too. And that is why I suggested to Robin, the case coordinator, that we invite folks to sit at the table rather than the kind of traditional format of the people approaching the podium for oral arguments. I do want to have a quick note about questions. Speaking for myself, my questions are intended to be probing and even to challenge some of the assertions in your exceptions, but that is not because I'm trying to prove that you're wrong or fight with you. It's because I'm trying to figure out what the right answer is. So I know that emotions can run hot in this room, and that's okay and sometimes necessary, but I hope everyone understands that at least our questions are really for the purpose of testing the validity of the arguments, meaning we are just as open to deciding that you're right as we are to deciding that you're wrong. So anyway, in terms of format, our regulations allow for the petitioner to open and close our proceedings, meaning Eversource will be offered the first and last word today. We allow any party representative, whether an attorney or subject matter expert, to participate. So please, you don't even need to ask permission to call up anyone you need to call up. I also am going to leave it to every party's preference, whether you prefer to begin with like the recitation of a prepared argument, or if you want to just invite our questions and treat this more like a conversation. Entirely up to you, although I do admit my personal preference for the latter. And as usual, commissioners are going to jump in and interrupt people we will try to wait until there's a natural pause in the conversation. And I plan to go in the following order, which will be Eversource and OCC, because OCC proactively requested argument. Then we'll turn to the parties who didn't proactively request but asked for the right to participate, which would be EOE and the Attorney General's office. And I did get a note for that Deep's not going to participate today. Okay, so we'll go in that order. If time permits, we'll try to do 2 rounds in that order. We might only have time for 1 round, but as I said before, Eversource will have the last word after we're done with those rounds. So unless there are any questions or administrative matters based on everything I just said.
Thank you, Chairman. I do have one administrative matter. I appreciate the case coordinator's advance notice about the format of the hearing this morning and welcome the contributions of subject matter experts. However, we would just like to state up front, to the extent the comments of subject matter experts reach an area of new testimony that is not already in the record, we would reserve our right to object, given that the administrative record is closed. However, we recognize that those experts can help to clarify, the evidence that already is in the record for the authority's understanding. So I just wanted to flag that up front.
Sure. I mean, certainly I think any party can object. And frankly, even if a party doesn't object, we aren't going to consider new evidence if it's offered here today. So,
Thank you.
but sure. Attorney Pace, do you have?
I did just one clarifying question. First of all, thank you for having this format, which we think is helpful in terms of being efficient and also encouraging dialogue. I do have prepared remarks, but I want to make sure I provide what the commission is looking for. So I'm happy to go with the approach you mentioned as your lateral approach, which would be if the commissioners have questions, I can put aside my prepared remarks and go right into your questions, because that's what matters to you. That's the information that you're trying to grapple with to help you deliberate over the draft decision. So without waiving my right to raise arguments later, I'm more than happy to start with hearing your questions and to do my best with Attorney Kimball to respond to those.
Sure, absolutely. And I'd extend the same option to anyone. So if anyone wants to kind of start with our questions and then move on to prepared remarks, totally fine. So is that what, unless there's any other administrative matters, is that how Eversource would like to start?
Yes, we're comfortable with that approach, Chairman.
Okay.
Thank you.
Everyone else good? Okay. So I'm going to start with my questions, and my fellow commissioners, please feel free to jump in with follow-up or just interrupt me. So Eversource, most of my questions for you pertain to the portion of your exceptions discussing retrospective carrying, what we called retrospective carrying costs in the proposed final decision. And I'm going to try to go in order. Your exceptions raised sort of 6, I think it is, sub-paragraphs where you kind of have headings. So I'm going to kind of try to address each of those. The first one's on page 28, which is subparagraph 1. The heading says the draft decision incorrectly characterizes carrying costs as profit. My question on here is, your exceptions are citing to page 149 of the PFD here, but that section of the PFD is discussing what we labeled as prospective carrying charges, which is like what the PFD would ultimately award as allowing WACC, the weighted average cost of capital, to be applied to the ultimately determined prudent cost, like as of the issuance of this decision. I was just kind of confused of why this argument is here, like why you're addressing the kind of the note about profit in that part of the decision but you're talking about it with respect to the retrospective carrying costs.
Sure. Thank you for the question. And I can start. Attorney Kimball can add if she wants to. I think the concern we wanted for you to consider when you looked at this would be, we do not see any portion of carrying costs, either historical or prospective, as involving profit. It's simply a recognition that when we incur costs, we have to finance those. In this case, with a mix of long-term debt and equity. And the carrying charges recognize that cost of financing. And so therefore, we respectfully disagree with any effort to characterize both forward-looking and historical carrying charges as profit. I mean, as the authority is aware, General Statute 1619E(a), subsection 4, authorized the company to recover our cost of capital and our operating costs. And carrying charges are a legitimate recognition that it costs us those funds to finance. And Attorney Kimball, would you like to add anything?
I just want to make it clear that we're not saying it doesn't get recorded as equity when it's collected. We're just saying that there's a cost to finance, and the utility uses both equity and long-term debt, especially as things get bigger and longer. And so in a way, it's just replacing what has been lost. That was the point.
Thank you. I did understand that. I think I just wanted to make sure that our PFD is clear that, at least as I read we kind of did this thing where we bifurcated the two kind of classes of carrying costs that have been discussed in this decision. And with respect to the first one, which we called retrospective carrying costs, I don't think we ever even reached the question of the rate that would be applied, because at least as the PFD stands now, we didn't recognize the cost at all. I just want to make sure that that was clear, like that wasn't like a basis for that part of the decision.
That is clear. And I'm just laughing a little bit because our upfront piece, if we had spoken first, we were not even going to talk about this because we didn't think that you would want to talk about it. So thank you for the questions. But no, we agree. You did not talk about the rate going backwards.
Okay.
Or really, well, you did going forward, but we have the opportunity to ask in the rate case. Thank you.
Sure. Okay. I think that was the only questions I had about that sort of heading 1. So I have some questions about the next heading, which is on page 31, labeled subheading 2. It's the one that says the record evidence is uncontroverted in establishing that Eversource incurred a cost to carry the deferred asset equal to the weighted average cost of capital. And actually, I'm reading the question I had. It was the same question I had before, just to make sure that the company wasn't suggesting that wasn't misreading, in my opinion, the draft decision to be, I'll back up. There is a discussion that is correctly cited in section 1, where I think the PFD is sort of like opining, I think, as I read it, sort of saying, like it's an interesting question what the correct carrying cost weight should be to apply to a regulatory asset moving forward. But ultimately the PFD says, but you know what? As I read it, you guys expected to recover the weighted average cost of capital when this was deferred, so that's fair, and that's what makes sense to us. I guess just to be really clear, did Eversource sort of was Eversource sort of picking up anything other than that in the language of the PFD?
I think the point we were trying to make is that we tried to put evidence on the record to support, which is also a policy decision. So we just tried to put evidence on the record as to what the actual cost was for the company, and Pura takes it from there. So we're just calling attention to that point.
Okay. So I had kind of a broader question, just to sort of that's to address I think the point of contention. Well, one of the kind of central points of contention that Eversource is raising. I just kind of want to make sure that we're sort of conceptually thinking about this in a way that makes sense, acknowledging that Eversource disagrees with sort of what the PFD arrives at. But I think the PFD sort of discusses the concept of a deferral having like some boundaries around it, like the idea that there's that a deferral is sort of like a bucket of costs, and there's ultimately a question before us in this case and any other where we're talking about a regulatory asset is sort of what's in the bucket and what isn't. And I recognize Eversource disagrees with the PFD's at least preliminary determination about what's in the bucket, but does that framing, does the company have an issue with that sort of just general concept that there's sort of what's allowable to be a deferral and what isn't?
Not at all. I mean, I think one of the problems we're all struggling with here is that the situation is so unprecedented, right? Up until 2009, up until the 2011-12 storms, there was never any kind of deferral. If you go back and read those rate orders, you're talking about $5 million. And sometimes it was even that the utility owed customers that because the storms weren't happening the way they were. We weren't all dependent on electricity the way we are now. Like there's so much that's new here. And then we have this whole situation arising against the backdrop of so many different things, law, all kinds of situations going on. So no, I don't think anybody disagrees. I don't even, as a lawyer necessarily, I could see how the commission could find its way to where it is. It's almost like it has to be solved. There's not like a big rule or statute out there. There's so many questions to be answered. So I don't think anybody disagrees that there's a bucket and how are we treating the bucket,
I think one other point we'd like the commissioners to please consider as you evaluate the written exceptions would be, we think the history and context are important in that we explained is the authority is aware the prior approach had been, while you did not allow historical carrying charges, once we determined prudence, we received rate-based treatment with a return on that, which compensated us for the cost of finance. Now with the elimination of that rate-making treatment and the securitization statute, it raises the issue, and in light of those changed circumstances, the statute in 1619 EA4 recognizes you can recover your cost of capital. How are we recovering the company's cost of capital to finance through long-term debt and equity those historical expenses?
Thank you. I did see that, and I had some questions about that argument also. I think like maybe relatedly that when getting back to the sort of bucket idea, I think I'll just throw out there another general question to see if there's disagreement on this. The question broadly, the question that we need to answer with respect to whether something's in the bucket or not isn't necessarily, I mean, a cost isn't in the bucket simply because it was incurred, right? Like, so just using a completely, like Eversource couldn't come into this case and say, hey, we had depreciation expense in excess of what's in base rates because we built a bunch of new stuff. So now we want to recover that as a deferral. Would you agree that that's, unless hypothetically, Pura originally said, yeah, you're going to build the new thing, you can defer the depreciation expense on that. Does that make
Okay,
sense?
just to unpack that a little bit. I think that when you look at that OCC2 case, what it says is that under accounting principles, a utility can defer. Now, a smart utility would want to ask and say if it's a substantial cost, like, can I defer? Because undeferring has very significant ramifications. It means if you've deferred 100 million without permission, and you have to undefer it because you don't get recovery in the end, you're taking a hit for that all at once, right? So if you're smart, you are going to want to get quote unquote pre-approval, but sometimes that's not always possible. And so, but now if you're going to go defer depreciation, and I actually had a client one time ask that, and the flat answer was no, because that's part of the normal rate making process. And if something abnormal was happening, what if, for instance, there was a wildfire and you had to go pour a whole bunch of investment in and you weren't getting, the return or depreciation? Yeah, you might want to approach the commission and say, hey, I need some help here. I'd like to defer that revenue requirement. But you could do it on your books as an accounting matter, but then you have to assert to the independent accountants what's your basis for probability of recovery, and you just get yourself into a pit. So I would say no, you can do it as an accounting perspective, but you would probably not want to do it without that pre-approval. Now, just to carry that one step further, on the carrying costs, I don't see that. I don't think we see that as the same. It goes with it. And that's what the court has said. It goes together with it. It's not an independent cost. And I think that's where some of this has gotten off a track in Pura's world.
Okay. I understand all that, and I understand like the Pura can't tell, the company can defer a tuna sandwich if it wants to, like independently, like on its own books. But I think like is it wrong for us to be thinking about this as like running up in some degree in conflict with the prohibition against retroactive rate making? So like, because let's say the company says, I don't know why I always use this example. Let's say the company says like, oh, we had expected payroll. There's payroll imputed in rates of $20 million, but we had to hire a bunch of new people. So that payroll, our actual incurred payroll last year was $25 million. So we independently deferred that without asking permission. Now we're coming in and asking to get that $5 million back. Like, wouldn't that be kind of classic retroactive rate making?
Classic retroactive rate making. Like you absolutely cannot expect, because that goes to the probability of recovery. What's the probability of recovery that the regulator and their rate making procedures are going to allow you to capture some overrun in payroll, depreciation? No, that is 100%, unless there was some specific reason that caused something to happen and there were incremental costs that you would consider. But that's why you would want to approach the regulator.
And I would like to add, we think the principal distinction here would be that unlike the example you gave, which is something that's dealt with in a base rate proceeding to which you can't change rates retroactively, here we have an explicit recognition, in this case, in the 2017-2018 rate case settlement agreement, that we continue with a reserve for catastrophic storms. All events above $4 million will be deferred, and therefore we have a basis to be able to raise that issue along with the associated carrying charges, because as Attorney Kimball points out, from our perspective, they're not severable. There's an expense we're allowed to defer, and part of that expense is the cost of finance. They're not severable from our perspective. Again, when the statute recognizes we're allowed to recover our cost of capital.
Okay, if I may?
Yeah.
So you've touched on a bunch of things. So I'll try to work backwards. So you said there's a basis, but obviously that decision did not anticipate where we are today. It didn't, it could not have necessarily conditioned what the case we're in now.
So nobody can see the future. So I'm not exactly sure what piece of today you're referring to. But I guess I would just go back to, at the time, in 2018, the precedent was that PURA would, when you went in for recovery in a rate case, it would go into rate base and it would be treated as a rate base item. Am I speaking to your answer or?
Yeah, I just wanted to pick up on that there wasn't something established that would somehow constrain PURA in addressing the facts and circumstances of this particular case.
I think we feel that there are some settlement provisions without getting into all that. Well, I'll let you ask that question when you're ready. No, I think there are determinations that are open to PURA here. That's why we tried to put in evidence, because you can only make decisions with evidence. And so that's why we tried to support the case. But there's definitely many questions that PURA is able to answer here. There's nothing that is exactly set in stone.
I would like to add, you asked a very specific question where you said, are there restraints or constraints? And I would answer, yes, there are constraints in the sense that the settlement allows for a deferral.
You just gave a different answer than me.
But I just want to clarify, and 1619 EA4 also imposes limitations.
Okay, so I mean, there's in both accounting and rate making, there's permissive and there's restrictive, right? And there's normative, there's suggestions. So I'm going to be coming back to this a few times, but you said earlier, Attorney Kimball, that it'd be good to have an agreement. And I think in the accounting world, and so I want to talk a little bit about this word probable. Probable is not certain.
It's not certain.
Probable is not a guarantee. And the guidance in this area, first of all, recognizes over and over again that regulatory determinations prevail. That guides the accounting, not the other way around.
100%.
We're in agreement on that.
Yeah.
And that guidance in the accounting literature is actually quite elaborative on this issue of probable. And it lists, they list, including PwC, which you recognize as an authoritative source. They list all the conditions that make something probable. And it's a pretty long list, and it's a complicated list, and it's a very subjective area. So, and I think at one point or another, they say something about, a rate case is a really good place to settle this, because you get that clarity of recovery going forward, because you're imposing that cost on customers going forward. So, and I think you even kind of alluded to that, but there's also some implication of other things that might make something a little more probable. Could be it could be a letter of something or some, I don't know. I'm not a lawyer, so I don't know what PURA would use, but some sort of communication that would give a higher degree of probability while still not guaranteeing anything, because you haven't reviewed prudence yet. So I guess, so I think that's where what I keep coming back to is I actually think, and by the way, these accounting guidance also recognize that something that was considered probable might not actually come to fruition.
Absolutely.
Okay,
So you've said a whole bunch of things here, so I think we have to, no, it's all good. I think we have to differentiate between the storm costs and the carrying costs. So all of the things you're talking about in terms of probability of recovery would, and I'm speaking probably in trouble now with we can let, I call him the accounting controls guy talk. But I think that from a legal perspective, the deferral is the storm costs. And so the probability of recovery is the probability of recovering the storm costs. And they had that probability of recovery because the reserve was created. So that gave them not the guarantee, because of course you can disallow costs, and you have. And so just because they're deferred doesn't mean they can't be disallowed. And that's what OCC 2 says. OCC 2 says PURA can disallow deferred costs, no doubt about it. So the expectation of probable is that you're going to have a fair chance. So when they talk about a rate case being the right time to figure this out, when you think about what the company did with the carrying costs, so the reserve is saying we can put the storm costs aside and go through the protocols for recovery for that. The rate case would be the chance to sort out the carrying charge recovery, which is why when we first filed the storm costs, we didn't worry so much about asking for the carrying charges, because that would follow from the deferral at the time that we had the rate case. But then all these events started to transpire, including the UI case where things were getting changed. And then when that happened, and the claim is here, well, you didn't defer the cost, so you're not allowed you didn't defer the cost. Well, you can't defer the costs if you don't have a probability of recovery, which you don't have the minute PURA issues that UI 2023 decision, because now you no longer can look at that and say to your independent auditor, oh, PURA's rate making allows for this rate-based treatment that will give us, under rate-based treatment, the utility is recognizing the carrying charges as you collect them through rates.
Yeah.
when they're put into rate base. But once that changed, in the UI 2023, you no longer can then you can't then try to start recording carrying costs, because now there's no probability of recovery. So now you're waiting to figure this out. So that is what triggered the company to get its cost filing in, and recognizing that there wasn't going to be actual recovery of either the costs or the carrying charges till that rate case. We would present all of our evidence about carrying costs in that rate case. And we asked for replenishment because we wanted to, in the meantime, reduce those carrying charges for customers, but that got rejected. So I think the idea that somehow the deferral and the probability of recovery would apply to the carrying costs, and the sequence of things is important, because the probability was lost as soon as that UI decision was issued.
Okay, I appreciate that. But I still would come back to the idea that that regulatory accounting and rate making prevail, and that means over all costs, And in other words, a cost that is going to be imposed on ratepayers is up to us to decide.
100% with evidence.
And agree. And what I worry about, one last thought, is that, and I saw it in your brief at page 38, this idea that you're sort of proposing of incorporating, kind of viewing them together. That sounds like self-regulation to me. And I don't think that's how, that's not how we do it, right? So in other words, you, like, just by deciding to book that tuna sandwich a certain way, with the cost of the extra things you got on it or whatever, that's something ultimately we get to decide.
I mean, I 100% agree with you. And I think that's why the company wasn't booking carrying charges at the beginning, because PURA's rule and rate-making rule was that it would be taken care of in this rate-based process. And so that was PURA's process. Then that got changed. And then the thing about that UI decision. And had we started off with our initial comments, the only thing we were going to say is Pure is relying very heavily on that decision in reaching its decision on the retrospective carrying charges. And there's a lot of problems with that decision. And one of them is it has this whole discourse on accounting rules where it says our policy depends on the accounting rules, which is not correct. It's Pure's policy depends on Pure's policy and rate-making policy. So I agree with you. The company cannot like self-regulate itself through application of accounting standards. 100% correct there. But as the company looks at what Pure's policies and procedures are, and that guides, that's what we're saying happened here. That's where the mix-up is here. And so when we get to this proceeding where you do have some options as to how you treat things, it's about the evidence. And that's why we tried to produce the evidence here to assist in your decisions on all the things you're saying. So nobody's trying to self-regulate. We're just trying to follow Pure's precedent in its rulemaking, in its decision-making, and come behind that.
And add one very brief point, and that is, I agree with Attorney Kimball. That is, the commissioners have a significant amount of authority to be able to make adjudications based on the record evidence. But again, I'd respectfully point out that's constrained by the relevant law. And the piece, again, we'd like you to please consider would be, when you evaluate the request for carrying costs, how does a denial of carrying costs that we've demonstrated exist, they're in the record supported by record evidence, comports with the statutory obligation to ensure we're allowed to recover our cost of capital. There was a cost of finance, and the rate making being proposed here provides no mechanism through which that cost of finance can be recovered. It just says we're following precedent and we don't think you're entitled to historical carrying costs.
Isn't that what happens between rate cases when you build something?
Isn't the distinction here, though, that we have a reserve? And so the reserve specifically said you're allowed to defer these costs. So that's an exception in our view to the prohibition on retroactive rate making, and also on the issue that you bear expenses and manage the business in between rate cases. The reserve was set up for that purpose, to be able to recognize these are extraordinary events with very significant costs. We agree we're not entitled to recover. We have to show prudence, which we believe that we did. But we think, in all due respect, again, the draft doesn't take into consideration the statute recognizes the ability to recover the cost of capital, and this provides no mechanism to be able to do that.
Thank you, attorneys. Thank you, Chairman.
Sure. Attorney Kimball, you've mentioned the OCC2 case a couple of times, and I saw that. Then moving on to subparagraph 3 on page 35 of your exceptions, which is the heading, the draft decision does not apply binding legal precedent or provide a valid legal basis for the conclusion the carrying cost must be explicitly authorized in advance. I saw that the exceptions say that the PFD omits any meaningful discussion of that case. We did cite to that case a bunch of times in the PFD, and I'm just a simple retriever. But
No, you're not.
does that case? There's another line in your PFD that says that case unequivocally rejected the proposition advanced in the draft decision that recovery of deferred costs depends on prior regulatory authorization. Does that case say that?
What it says, and I think what that sentence is trying to say is, it doesn't say and I don't have the PFD in front of me, sorry. The one thing that case did is establish two things. You do not need pre-approval. You do not, is it wise? Yes. But that can't be a reason that we lose, right? It can't be a reason that the company is stripped of carrying costs is that you didn't get pre-approval, because that case expressly says that you don't have to get pre-approval. That case said that that case was about whether or not a deferral had been created, and the court found it had been created, even though Pura didn't issue the magic words. And then Pura tried to say to the court in that case, well, it didn't get called a regulatory asset. It was only a deferred asset. And even there, the court said, potato, potato, right?
Yeah.
And so I think all we're trying to convey there is that this is more specifically targeted at this idea that the carrying costs are lost because there wasn't pre-approval. And that's one of the premises from the UI 2023 decision, which is kind of like you need to have pre-approval. And I think there's even a footnote that kind of acknowledges in that decision Well, maybe OCC 2 does stand for the fact that you don't need pre-permission, but a wise utility would get pre-permission. But a
Yeah.
utility is not going to get pre-approval if the standard at the time things are being deferred is that you get it in rate base in a rate case. Okay?
Yeah, I agree with what you said that case was about, but I think I disagree. I don't think that case says you don't need pre-approval. I think what it says is that there doesn't need to be a magic word. That Pura's indication on the facts in that case that sure I think what that case, just remembering, paraphrasing, I think what Pura said in the underlying case there was like, yeah, sure, you can seek to recover these costs in a future rate case. I think that was like the initial indication from Pura. And then I think OCC, the crazy people they are, appealed at that time. And then Pura, the basis of that appeal was OCC said, hey, that wasn't permission to pre-approve. And I think what the court said there was, well, no, they don't need to call it a regulatory asset. They don't even need to, I don't think that it says they even need to use the word, you can defer this. But I think the court recognized saying you can come back and try again for this in a future rate case. That was enough. But I don't think that decision says Pura doesn't have to say anything. Is that?
Oh, I agree with that. And I agree, if I hear what you're saying, I agree with the principle that the court was going from the fact that Pura did say something to begin with.
Yeah.
In the rate case, they said Pura recognized there's going to be a difference here.
Yeah.
And they definitely had some language that kind of intended that there wouldn't be a loss there. But how is that really any different here, where when the reserve was created, the principle was that in a rate case, you got the rate-based treatment. So I agree with you there, but I don't see any difference between where the facts are for the company in that the Pura's precedent was what it was, its treatment was what it was. So the whole approval of the deferral is in line with that expectation.
Do you think it's wrong to think of it as sort of akin to like, I got a B in contracts. It was my best class, but the kind of contract notion, the fundamental notion we all learned in law school that there aren't magic words in contracts,
Right.
that it's about the intent of the parties and that it's the court's job to examine the circumstances in place and basically just try to figure out like what was everyone's understanding at the time that this was initiated. Do you think it's wrong to think of OCC 2 as sort of applying that same sort of concept to the concept of a deferral?
I'm hoping you asked this question of them, but I would say from the company's perspective, there wasn't any promise by any party in that settlement as to what was going to happen. I would be happy to agree to that. The expectation was that the actual recovery would happen in a future rate case, and we've never said that's not true. Right? All we ever asked outside of the rate case was for the prudence review. So no, we have never suggested that actual recovery or the discussion about carrying charges wouldn't happen in a rate case at the time rate base is set, because and so I would be happy to agree that none of the parties there agreed to anything on the recovery of carrying costs.
Sorry, and that wasn't even really I was being more kind of spacey and conceptual. Sort of what I was referencing more is sort of like, is it right to think of the standard that OCC 2 sets as sort of equivalent to like, well, what matters is what did Pura probably mean and what did the company probably think Pura meant when a Pura initially says like, sure, you can seek recovery of that. And getting back to like, there doesn't need to be a magic word, that it's not about the words, it's more about like so the analysis for us to perform then maybe is what do we think what do we think the expectation was at the time of 171046?
Yeah, I think I completely agree with that. I think where we may disagree is that everything changed when UI 2023 came out. Everything changed. So while we can say there doesn't have to be magic words or whatever, there is Pura precedent, there is Pura practice. And so when that just changes after settlements have been written and approved, and in a case that doesn't even involve the company, and then somehow says, oh, there does have to be a magic word. There does have to be a magic word that it has to be expressly pre-approved. That's when things go off the rails.
Okay. I had a question about 220808, and you referenced, I also read in the exceptions, I think it's in the same section, the perception that the PFD relies heavily on 220808. I guess my question was, well, I can get into that more in a second. My overall question, though, is I didn't know if, I was curious what the company's thoughts were on footnote 94 in the PFD, which you don't need to look at, but footnote 94 says, it says something to the effect of, you know, we see the company's point of view about 220808 in the brief. And because I believe like the briefing issue is essentially like this, I think it said there's an issue of first impression in part because you can't rely on 220808.
Right.
I think our footnote said, you know, we looked at 220808 and at least portions of that decision that are, I think, captioned in the PFD do make sense to us. But I think ultimately what I'm getting at is, I think we also cited to the Superior Court's ruling on appeal. I was just curious how we should view the Superior Court's finding that appears to have upheld that decision's treatment of carrying costs and deferrals. Like, how do we look at that in light of Eversource's view that 220808 shouldn't be compelling to us?
Okay, so I'm not sure I caught the whole question, but if the question is that basically that decision's already been validated by the lower court, I think it was validated way before a lot of stuff happened. And I think it's on appeal to the Supreme Court. And so there still remains argument to be made. And I think that is something that will likely get raised at that level. So I don't place a lot of emphasis on that decision because I think it's across the board, that's a flat decision of just complete deference, knowing it's going to be appealed up, knowing that it's a big, thorny, complicated issue, knowing that you know, that when you go upstairs, you have to winnow down the number of issues. So it forces the utility to kind of pick. So what issues they're going to fight for. So I don't necessarily place a lot of weight on that.
I would just like to add one additional point, and that is when I looked at that decision, so it's a March 13th, 2025 decision at 2025 Westlaw 842228. I looked at Westlaw page 13, which is captioned Regulatory Assets Deferred Expenses. And it only devotes one paragraph in that decision where they lump in together deferred expenses for vegetation management, carrying costs for storms, and also the Bridgeport Avenue facility. And the conclusion is, it says that PURA's decision is supported by substantial evidence in the record and PURA's reasonable factual conclusions. And in all due respect on that point, it doesn't address the legal points that we made in our written exceptions. And in particular, it doesn't address the issue of 1619 EA4. Now it says that PURA's authority is limited by 1619 EA4, but it doesn't actually have an analysis of that. So our view is, and again, I'm very respectful of the court's decision, we don't think it gave very full analysis of all the issues that we'd like the agency to please consider as you look at our request in front of you.
Okay. Thanks. And yeah, I think you're right that decision doesn't say out loud, it doesn't address this issue. But do you think it's appropriate for us to acknowledge that a very similar issue was briefed by UI before the Superior Court? Like that this UI brought this very issue before the Supreme Court in its brief, I mean, the Superior Court in its brief saying, hey, we think we should get carrying costs, that should have been part of the deferral for storm costs. And presumably having read that brief, the decision says what it says. Is it?
So I will just say different company, different case, different facts. They were deferring their carrying costs as well ahead of time. So I just don't see any analogies. I kind of go back to where Commissioner Beecher was, I think, which is this is kind of a case of first impression here. There's so much water under the bridge. And so as an attorney, I can only go back to basics, which is we're in front of a new commission who's looking at the evidence. So we present the evidence and then decisions get made. And this is kind of a case of first impression here. And yes, I actually think, fine, you want to take that case, Pura can consider almost anything it wants and give it the weight that it's due. And so if that's one of the things that Pura wants to look at, nothing wrong with that, but give it the weight that it's due. And I think a different company, different facts, different evidence, different commission ruling on it, so many differences. I don't know what it says about this record.
Okay. One last question about this, and this is actually maybe I have more than one question about the UI Gray case, but this is another kind of just making sure that the PFD is clear, because it seemed like maybe it wasn't based on, so this same section, I think on page 41, according to my notes, there's a discussion in your exceptions about 220808 criticizing that decision, and it kind of gets into, as you might remember, that decision kind of got into sort of the discussion we were having before about magic words in a way about like the semantic distinction between a regulatory asset and a deferral, and the PFD, I think intentionally, the portion of that decision that's kind of quoted isn't that portion of the decision. So I guess, was it clear to the company that the PFD isn't relying on that portion of that discussion within 220808 about, whether something counts as a deferral just because it's not called a regulatory asset?
To take that question and say, does the company think that, I think you're asking, does the company think that the PFD relies on that accounting analysis? Is that the question?
Yeah.
I think I agree that the PFD does not wear that accounting analysis, no.
Okay.
And I don't think that's what we were trying to say. I think we're trying to say, but the outcome of that analysis is this idea that something had to be pre-approved, so I think it's more that we're focused on the outside, the outcome, and therefore we're going in to talk about the assumptions that were drawn in that order. But no, I don't think we read the PFD to wear that accounting. In fact, I think the PFD says, exactly like Commissioner Beecher said, rate making it does not have to adhere to accounting, and 100% we agree with that. So
Okay.
I don't think we read that PFD that way.
Okay. I was confused by, there's a kind of long quote on page 43. I'll read it out loud. Of your exceptions. It says, both the UI 2023 rate decision and the draft decision conflate two distinct regulatory concepts: the prospective setting of rates and the historical costs upon which those rates are based. While rates are set prospectively, they reflect costs already incurred. The company's request for retrospective carrying costs is entirely consistent with that framework. CL&P is not asking Pura to retroactively reconcile previously approved rates. Rather, it seeks to include prudently incurred financing costs in the revenue requirement used to establish rates going forward. I guess I read that a couple times and I was a little confused about, are you saying that because the revenue that you'd receive to recover this historical cost will be received on a prospective basis, that makes it prospective rate making?
Well, the whole thing about a deferred asset is that it's taken out of the rate making process, right?
Yeah.
And the court has said three times, they've said that the deferred asset goes together with carrying costs. So if the deferred asset is taken out of the rate making process, so is the consideration of the cost to carry it.
Okay, so that's what you're saying.
Yes.
I was confused about that. I thought this was sort of saying the opposite, because I read, especially, I think the clearest indication we've got from the Supreme Court on like that particular point, on the particular point of sort of what is a deferral as distinct from prospective rate making, is the Aquarian decision that just straight up calls it an exception. It says like, there's this thing, they call it, I think, test year model, but I think what they're talking about is the prospective rate making model. And they say one exception to that is a deferral. And I think I agree with everything you just said. That's what we're doing here, is we're, for lack of a better word, correct me if you disagree with this misunderstand or this framing, but it's sort of like allowed retroactive rate making preliminarily. It's sort of saying, we don't do retroactive rate making, but we're making an exception here because we recognize in the context of storms, these are unpredictable, really material costs. It doesn't make sense. I think Mr. Horton kind of testified about this in the hearing a little bit here. Like, there are certain kinds of costs that you don't want to put in base rates because you're either going to vastly overset base rates, or from one year to the next, you might end up with massive over or under recoveries. Anyway, I'm going on and on. Do you agree with that, though, that just the concept, like this is an exception a deferral by its nature is purposefully an exception from the prospective model of.
100%. Yes, absolutely. And I think that, yes, it's just, it's an animal unto its own, for sure.
Okay. Commissioner Beecher sort of asked a question about this, but I'm going to ask it again anyway. Your exceptions point to the report from Sean Riley from PricewaterhouseCoopers that is in the record. I read that. I actually found that report really interesting because in my mind, it emphasized, or at least drew out the similarities, really conceptual similarities between a deferral and the model of the traditional rate-based model, but specifically the idea that I think Commissioner Beecher was just getting at, and I did hear Attorney Pace's response to this, the idea that the idea of regulatory lag, like the idea that a company, as we all know, in the context of like a plant addition, incurs capital costs, but then risks the chance of never recovering those capital costs if there's enough regulatory lag between the incurrence of those costs and the recognition of that asset in rate base. So I guess my sort of broader legal question, which I guess maybe Attorney Pace already answered, is if that's legally permissible, if regulatory lag is legally permissible, what's the distinction in response to Eversource's argument here, which is essentially, well, we incurred these capital costs, so 1619E gives us the right to recover them.
So I'll let Mr. Pace answer, but I think this is very interesting, and this was something that Commissioner Beecher raised. So our job is to put the case on and request, right? Our job is to make the demonstration. We have the burden of proof, we have the burden of persuasion, so we put the evidence on. We prove that this is an actual capital cost, that it's part, and what it is and how much it is. Does that mean that PURA is without its own power and authority to make judgments about what is recovered? We've learned over the past several years from the court cases, PURA has the power to make judgments about the recovery of the cost. No doubt about it. I don't think we're here arguing that the law says you must. It's an all or nothing proposition. We are not arguing that. And nor would that be proper under the law. You have discretion, you have balancing. So I don't think anyone here is going to say PURA must do something because we're saying it is a capital cost and we do recover our prudently incurred costs and the storm costs were prudently incurred. We are not arguing that PURA isn't without its judgments as to how that translates to customers. You have power to determine that.
Mr. Chairman, if I may. Oh, I'm sorry.
I was going to say,
Sorry.
one additional point in response to the chairman's question is you talked about the differences between the approach we're talking about here and also traditional regulatory lag for capital plant additions. And isn't one distinction right now, and I think we all agree that for prudently incurred capital plant additions, while there is regulatory lag, if we demonstrate prudence, it goes in rate base and we get a return on that. That had been, as we pointed out, the authority's traditional approach to provide us with the functional equivalent of a recognition of our cost of capital to finance these expenses. And now it's been eliminated by the 2023 UI rate case decision to which we were not a party. And as Attorney Kimball pointed out, we're now raising our concerns with that approach in this venue. And do you want to add anything else, Attorney Kimball?
I just want to say that Mr. Horton has an excited utterance he would like to speak to you about.
Thank you so much and good morning. I've never had to sit that long listening to such an intelligent conversation about carrying charges without being able to talk. I almost passed out. And I'll be very brief. So just with this discussion on regulatory lag, I only wanted to chime in to offer my thoughts on how storm costs are explicitly and specifically not applicable, as I think about it as a rate-making wonk. When we think about base rates, and we put this into our testimony, there's this notion, as it relates to storm costs, out in the ether and in the order, that carrying charges on storm costs become real only once the prudency determination is made. And so we went to great lengths in the testimony to provide examples where that is not true. In the base rate framework, Commissioner Beecher, as you referenced, does account for the fact that there's always going to be lag. There's never going to be perfect recovery, but that the base rate framework is intended to set up rates so that we cover our costs of service, and what is left over is enough to provide equity investors a return on their investment so that we can continue to attract capital. But what we tried to show and explain is that for catastrophic storms specifically, they are taken out of that framework, both the principal and any carrying charges. So in traditional capital investment that we do every single day, that would not be appropriate for us to, Chairman Wheel, as you mentioned, like get a deferral or expect to get a deferral of depreciation expense because we've invested more capital. That's accounted for in traditional rate making, meaning the traditional, in base rates, we have a working capital allowance where we go to great length and explain essentially what is the cost of capital that we need to incur to finance differences in the amount of capital that we have to invest in the system and when we collect that through revenues. And it acknowledges that lead lag study, which is a piece of our testimony that I'm sure no one really reads as much as I do, but it's a piece of testimony that we always put on to show that there's a real cost of capital. And we tried to put on a demonstration to show storm costs are held separately. And PURA's precedent in the past did not acknowledge carrying charges on that balance from the date that they were incurred. But there was a compensatory framework by putting that balance into rate base prospectively forward that would give a modicum of recovery for the past carrying charges that are incurred. Once the UI decision altered that framework, that's when, and we put this in testimony and talked about it at length, that's when we said, hey, something else needs to change. No longer can we count on that prospectively. Plus, we have now this excellent tool, securitization, same thing. We're now going to have $1 billion of costs that we are carrying, the storm costs, the principal, and we'll have no ability to recover the carrying charges that we've actually incurred to finance that with this new framework. In the base rate making model, explicitly and specifically also does not account for that. The notion of regulatory lag, in my mind, as a rate practitioner or whatever, doesn't take into account the carrying charges on that storm balance. We don't include it in our working capital allowance. And we showed the impact of what would happen to that balance if we did. It would substantially increase base rates. We don't accrue allowance for funds used during construction like we do on traditional capital investment. We don't do that for storm costs. But both of those things acknowledge in PURA's world and in every regulatory environment that I am familiar with, acknowledge that there is a cost of capital that the utility incurs and has to incur in order to have that regulatory lag framework work. Thank you so much, Commissioner, Attorney Kimball, for letting me stand up.
Mr. Chair, if could I follow up? Thank you, because since the chairman brought up Mr. Riley, I had a couple questions, backing up to page 42, so we're in the ballpark. So you have in your brief, nothing in ASC 980 excludes debt-related carrying charges, but nothing in it prescribes carrying charges either. Is that correct?
That's correct. And they're the point that we were making, and here I could maybe tag Mr. O'Brien, but the point that we're making, or what that is showing, is that for ASC 980, I agree with everything that has been said about sort of what goes into the bucket. If the bucket is what's deferred for accounting, it's based on the company's estimation of what's probable, and ultimately it's PURA's obligation to determine what is recoverable. So we account for things that are probable and estimable, but what ASC 980 says is that you can only defer the debt-related carrying charges if those are probable. It specifically also, though, says that you cannot defer the equity-related carrying charges unless there are certain parameters that exist. Meaning that even if PURA had, in the past, allowed for explicit carrying charges at the weighted cost of capital on the storm balance, ASC 980 says you can only defer the debt-related portion of those carrying charges.
Because it's an expense.
Because it's an incurred expense.
Right,
exactly.
and there's no ROE on expenses. Is that correct? I mean, is that the logic behind that?
Well, I think here I'd tag in the real accountant.
I'm going to jump in with just a quick unrelated update. We are getting the sense from the building folks that there may be a surprise fire drill at some point today. I don't think I'm supposed to be announcing that because otherwise it's not a surprise.
Nope.
But I did just want to say that because if it happens, I don't want anyone to think, no one's pulling the fire alarm. It has nothing to do with this proceeding. So I'm just throwing that out there. Sorry, go ahead, Mr. O'Brien.
I'm glad the camera zoomed in on me with the potential for a potential fire alarm.
But yeah, just to pick up a little bit on the ASC 980 conversation. So just to dial it back a little bit to, ASC 980 is very prescriptive on what the company can defer. And there is a specific set of requirements in order for us to have any deferral. So Chairman, you mentioned, the deferral of depreciation or payroll, like we would need from an accounting perspective, the bar of probability is quite a high bar. It's not a more likely than not 51, 49%. Probability is really an 80% likelihood from an accounting perspective based on your own interpretation and evaluation of historical precedent like we have with storms here, that it's likely that those costs ultimately will be recoverable. And as you mentioned, Commissioner Beecher, ultimately the final decision determines what is and is not recoverable, and the accounting would follow. But I think the point we were making from an ASC 980 perspective is just going back to the 220808 decision. In that decision, there was a distinction that carrying costs are not an incurred cost, and under GAAP, therefore they don't meet the criteria to be able to be deferred as a regulatory asset. And in that decision, I think what Puro was using was separating, again, going back, Chairman, to what you mentioned, the distinction between a regulatory asset and a deferred asset, and that because it doesn't meet the definition under ASC 980 as a regulatory asset, that you couldn't therefore defer carrying charges or incur them. And so our point there was really simply to highlight that from a GAAP perspective, a debt-based carrying cost is an incurred cost. And as Mr. Horton referenced, from an accounting perspective, an equity cost or a cost for ROE is eligible for recovery, but from an accounting perspective can only be recognized when it's realized and recovered, unless it meets a very specific set of individual separate standards in ASC 980 under the revenue recognition criteria. So that was simply our point that Mr. Riley, obviously as a GAAP expert, supports in his report as well.
Okay, so you're following GAAP to meet your obligations for financial reporting to the SEC and your investors, correct?
Yeah, and just again to kind of walk through the process, we have to go through an individual set of standards ourselves to determine from an accounting perspective what can and cannot be deferred. And that really is a high bar that we need to meet from a probability perspective under GAAP.
Okay.
And from a storms perspective, like I mentioned, given all the historical precedent that we've been talking about here, that's how we're able to meet that criteria in terms of an accounting perspective. In the process, as it plays out, that's not only our determination. An independent auditor comes in and evaluates and scrutinizes our determinations and conclusions from an accounting perspective to determine that those costs are ultimately eligible for deferral. So there really is an involved process from a GAAP perspective to go through and evaluate and ensure that what we're reporting is correct. And I think as we've been talking about, when you talk about the carrying charge perspective here, historically, as Attorney Kimball referenced, historically, and I think dating back to 171046, is that what it is? The previous rate case, we were given rate-based treatment from a perspective of storm costs. So given that rate-based treatment, that is not something we would actively be deferring. It would wait till the next rate case to be included in rate base and you'd recover carrying charges. And in between that point and now, there's a decision, from PURA outlining that treatment no longer is acceptable. From an accounting perspective, at that inflection point, now the company's faced with, well, the rate-based treatment's not there. Can we defer historical carrying charges dating back to the point incurred? Because to recognize those, that would be your other way to accrue carrying charges. And based on the determination in the 220808 decision from a GAAP perspective, there wasn't an ability to make that conclusion based on that historical precedent that was outlined in the 220808 decision.
Okay.
So-
If I,
Sorry, just it's not necessarily an objection. It's hard for me to determine whether that was testimony or supporting their written exception. So I just, I'm that sounded like opinion that would maybe more appropriately be in, the underlying case as opposed to this response, which really sounded pretty testimonial to me. That's so just noting that. Thank you.
I think the response we'd like you to consider would be, our goal is to answer your questions. We'll do our best. And if you decide that any part of that crosses the line, then you can decide not to rely upon that. But again, our goal is to make sure you have answers to your questions, and it was offered in good faith to be responsive. Thank you.
Thanks. I am going to sustain the objection, but with the same caveat that you just said, Attorney Pace, that sustained as to we can't accept new testimony today, but we won't apply, when we're reviewing the transcript of this and analyzing the final decision, we can only take what anyone here says today as sort of explanatory for the positions that have already been taken in the record. But thank you.
Thanks. So just to try to bring it back to earth, we agree that GAAP and regulatory are different bases of accounting. Or do we?
Could you explain that a little bit? Just
So there's an IRS has its rules, GAAP has its broader framework for all regulated corporate, like certainly publicly traded corporations and so on, under FASB, by FASB. But then regulatory accounting has its unique elements. So it really, there is a distinction. In other words, I think we've already agreed on this, that regulation prevails over GAAP.
yes, I totally agree. Sorry, I was
Okay.
confused.
Yes.
When I hear regulatory accounting, I think FERC, USA,
Yeah.
but
Fair enough.
understand like.
And in some ways, 980 is the expression of the separate basis of accounting that regulators rely on.
Yes, I
Yeah.
was just going to make the point from a FERC and GAAP perspective, they really are aligned and there's very few FERC and GAAP differences.
Sure. Okay, thank you. And then I just want to go back to Mr. Riley. So he's with PwC. He did not testify in this case. Is that correct?
In this case,
But his testimony was adopted.
It was
by the
adopted.
Witnesses, yes.
Okay.
They were available for cross-examination.
Okay.
Yeah, and I just want to reinforce that point. So Attorney Kimball is correct, and that is the information that was offered in the PwC Report of Independent Accountants was attached to the pre-filed testimony of John G. Griffin and Leanne M. Landry, both of whom are CPAs and both of whom were produced as witnesses. They adopted their pre-filed testimony, including the PwC reports, and were available for cross-examination. And so an example would be Exhibit ES ACT 5 supplemental, where Griffin and Landry attached to their pre-filed testimony the PwC Report of Independent Accountants.
Okay. So I'm looking specifically at his report dated December 21st, 2023 on cost deferral and regulatory accounting. And that was which I believe you cite, I've got my references correct, on page 42, you're citing that from docket number 2408, or sorry, 0330. Does that sound right?
Well, correct, Commissioner. I see the citation you're referring to. So you're on page 42, the exceptions, and I think in the third to last line, there's a reference to Exhibit ES RP2 Supplemental 3, pages 9 to 10.
Okay. But he did not appear in this case personally. His report was adopted. Is that correct?
Correct. His report was adopted by 2 CPAs who were available for cross-examination.
Okay. One thing I found interesting is, I looked through it and 16 times he first of all, he has appropriate disclaimers at the beginning of his report. And 16 times he says, in my opinion or in my view. So this report has your name on it. So it was prepared specifically for you, correct?
It was, and I guess what's so ironic here is if 220808 did not include those 4 pages trying to say that the rate making has to follow accounting, you would never be hearing from us about the accounting, right? We would have never come into this case and asked for carrying costs and even mentioned accounting rules, because accounting rules do not dictate rate making rules. The commission makes decisions based on its rate making policies, procedures, and our evidence. And that's what the commission has done here. We ourselves would have never brought it in. The only reason it exists, and we did have him prepare that report, and we filed it in several different, is because those pages in that 220808, they were not even in the draft decision. If you go back, they only appear in the final decision. So there was no way for anyone to answer Pura in this whole complicated accounting analysis that was put in that final decision. Neither UI nor Eversource have had the to address that. So we did have Mr. Riley prepare this report. We've used it in many things. It is his opinion. It's still based on all his knowledge of accounting, across, but it is accounting. Like, you're so completely correct. I hope that answers.
Thank you, thank you. I mean, because it does, again, I don't want to cross any lines here, but it's very specific. And he's very, as a professional would be, he's very careful in how he crafts his advice.
Right.
Because he works for a company that also gives general advice, that takes on some of these issues in other ways and in more detail. I do notice he says, and now we are being redundant, I apologize, but he says, I fully recognize and acknowledge that a utility commission has the ultimate decision-making authority as to whether a cost is recoverable from ratepayers, period. He has that, and he also follows that up with the accounting, follows the rate making. Then later, just on another issue we've talked about, he talks about there's a disincentive for utility to delay the request for a prudency review for the purpose of maximizing the accrual of carrying costs, in my view. So he also touches on that point that there's sort of a built-in, he talks about regulatory lag a little bit, but he talks about that built-in incentive that you have to get to that decision so you can move forward. Isn't that correct?
Yes, I mean, I think we actually did address this. I think we actually did redirect exactly on this point. No one is looking for carrying charges as the benefit out of any of this. The recovery of costs is the premium thing that a company wants to get to. They need their money back, right? So I think that's the thought there. I just want to summarize this whole accounting thing up as we're not resting on the accounting to recover the costs. If the whole accounting thing went away tomorrow, that would be fine with us. But what we're doing, the reason we have to address it is that is the idea that you're going to Pure or whatever, take away the carrying costs on some sort of accounting basis. That's why we've addressed it, because that's what 220808 did. It took it away on the basis of the accounting. So we've addressed that. But we would not be depending on the accounting for our main case if it wasn't that Pura had come out in that decision and said you lose because of accounting.
Do you see that in this proposed draft?
Well, in this, again, I think this goes back to the chairman's question. Quite clearly, and very happy to see it, this decision said rate making stands on its own. Like, not that accounting is irrelevant, of course, but rate making drives the car here, drives the truck. And that was very clear, and very happy to hear that, because that took 220808 and turned it right side up, right? It fixed part of what 220808 was doing. I think the reason we're continuing to address it is some of the conclusions in the draft decision came back to the 220808, you lose because of one reason or the other. And I would have to acquaint myself again with exactly what we said. We just don't think we should be losing on the basis of 220808.
Thank you, and thank you, Mr. Chairman.
Sure. I had some questions about the rate-based treatment and Eversource's expectation of rate-based treatment at the time of 171046. And kind of like we talked about before, I feel like coming from a place of, it sounds like what we need to be considering partially is what did Eversource reasonably expect at that time. So what I've heard, there was testimony during the hearing that mirrored, I think, what Mr. Horton said today, something to the effect of, well, that treatment provided a modicum of recovery of carrying costs, right? And also, is it fair to say that Eversource can't know at the outset and couldn't have known at 171046, for instance, the term over which storm deferral might be allowed to amortize? So I guess my question is, how can we be convinced that Eversource expected to recover its full weighted average cost of capital via rate-based treatment if the record seems to reflect that it expected at best a modicum of recovery? And also, like, how could it have had a reasonable expectation of the degree of recovery given the volatility of how PURA might ultimately amortize a cost in rate base?
I mean, I think we completely agree with you that, think about that rate-based recovery, and all the way through the testimony, we made it clear that it would have given it would have been reasonably compensatory. Those are the words we tried to use. No one has asserted it would have given 100%. Just even think about it this way. What if the company had only stayed out for 4 years instead of 6 years? Well, then rate base would have gotten reset. And that buffer of extra carrying charges goes away the minute rate base is reset. But so it's all about reasonable level of recovery against the total, which goes back to the question Commissioner Beecher is going to, which is, but when we come in, we have to present our case to recover the cost. Then knowing PURA is going to make some decision about how much, from what point, at what rate. All of these are PURA's. We're never going to argue, us, Vincent, Mr. Pace sitting here and I, that you don't have the power to make decisions about those things. Our job is to put the case on, it's to ask for the number, and then to meet our burdens of demonstrating it, and then PURA comes back. And you're completely correct. Knowing that was PURA's treatment, you almost would not have gotten 100%. I think we would agree with that, but we would have gotten something, not nothing.
And the only piece I'd like to add, because Chair Wheel, you asked her the question about what were your expectations coming out of that rate case. And I think what we'd like you to consider would be your draft decision cites to the 2014 decision in 130323, which did allow for rate-based treatment amortized over 6 years with a return. And then 1 year after the rate case, a rate case was resolved in April 2018, your draft decision cites to the April 17, 2019 decision in 181112, which again allowed for rate-based treatment amortized over 6 years with weighted average cost of capital. So at a minimum, those are decisions that inform our expectation in terms of what the rate-making treatment would be for prudently incurred future storm costs.
Thanks, but I mean, not to get too finicky, can we just infer that from the record? Like, I can't take your testimony on that now. Is there somewhere in the record here that speaks to like that was the company's expectation at 17-10-46? Because that's what I'm frankly struggling with, is like how can we know that that was when the if our job here is to determine, okay, there was an authorized deferral. We talked about like that the standard set forth by the Supreme Court is sort of like, well, what was a reasonable expectation of recovery as sort of set at the time of 17-10-46? Like, how do I substantiate what you just said as being the company's expectations?
So we can check the record between round 1 and round 2 if we can give you a citation, but I would submit at a minimum, it is reasonable for a company to expect that the agency would follow its prior decisions. And so the fact that decisions exist, the fact that they're cited to in the agency's own draft decision, recognize that that was the rate-making treatment accorded to CLMP in essentially identical circumstances. There was a deferral of catastrophic storm costs, and the determination was the rate-making treatment would be rate base amortized over 6 years with the return at weighted average cost of capital.
I want to move on to subsection 6, which is on page 55. The caption, the draft decision incorrectly concludes that CLMP could have mitigated its exposure to financing costs by simply filing a rate case, and that failure to do so was a business decision for which the company should bear the consequences. What I want to ask here is, and I think Attorney Kimball, you sort of referenced this before, and the draft decision sort of speaks to this. It sounds like that the company agrees that in the history of the attempts to recover these costs, as outlined throughout this record, the company was only ever asking for a prudence review and not a rate adjustment, right?
That's correct, 100%. And we did see at the time, based on PURA's precedent, that the recovery and the issue of carrying charges was going to be a rate case issue. So we didn't have the expectation at that time when we filed for the cost review that that was an issue that had to be sorted out then, that the first step is just the prudence review.
Yeah. So I guess I'm having trouble kind of tracking the company's argument in this section because it seems like the argument is, well, we incurred this financial harm as a result of the delay in the prudence review. But hypothetically, if the former, even if we accepted the notion that the former chairman's bias and misconduct violated Eversource's right to a timely prudence review, even if that hadn't happened, even if hypothetically the former chairman had immediately provided a prudence review, if you hadn't filed a rate case between then and now, wouldn't you be in the exact same financial position that you are now?
I don't see it that way because as soon as, or we don't see it the same, because as soon as the prudence review, just like Mr. Pace was reading you the language out of the 2018 storm decision, correct? Which said that the company can start accruing the carrying charges on the prudent amount. So if we had had the prudence review in time, you would get that order, and then the carrying charges would start accruing. You wouldn't recover them until the rate case. And how you recovered them or what they even were wouldn't have happened to the rate case, but that point of start would have been that day.
Yeah, well, I guess my question was sort of like asking, I guess part of my, baked into my hypothetical was if the company got everything that it wants here, which would it be inclusive of carrying costs as of incurrence up to the point of the determination of prudence, and then thereafter be able to continue to accrue at the same carrying cost rate at the weighted average cost of capital. That's what I'm not getting, like in those two hypothetical. So in the situation where the company got exactly, as I understand, what it wished it had, which was a prudence review 2 years ago, or 3, whatever the number is, and a determination, but that prudence review would have recognized carrying costs between incurrence and the issuance of that decision, then there'd be the continued accrual of carrying costs up until last week or whatever when the company filed the rate case. Like in that circumstance, aren't you in the exact same financial position as you are now?
I'm just a little bit struggling to follow that, but let me try this one. I think that the company's proposal for recovery of carrying charges changed because of the circumstances, right? So if there had been a prudence review that was fairly, imagine that you make this legitimate filing that you've worked very hard on. You witness the 220808 decision come out. You're like, wow, okay, everything just changed. Put the thing together. You put it in, kind of recognizing what you're dealing with, and you're trying to be very alert to like what Pura might receive something, and you try to fit it into an envelope, and then you get back the ruling on motion number 59, which is complete mischaracterization of what was even happening. So I don't think it's really fair to kind of go back and say, why didn't the company do this or that or this or that? Everything has changed and been really uncertain. Like all we can do is take Pura, that's all we could ever do was take Pura's orders, read them and try to assess what's the best to protect the company's interests and the company's ability to keep funding storms in all the expectations. What do we do to handle this situation? And it was completely changing. So I'm not exactly sure how to answer the question today that seems to be saying, how do you reconcile all this with where you are today? I guess there's so many twists and turns. We finally came to the conclusion we need to put a case on to recover the total carrying costs. We've experienced this harm. This is a real case to the company. We're going to put the evidence on. We're going to argue on the law and the evidence, and we're going to see where that gets. And there's a lot of discretion that Pura has in coming to that answer. And we kind of throw ourselves at the mercy of Pura and see what happens, knowing that Pura has to make decisions based on law and evidence, but also has discretion, and we see where we get to. And I think what we are trying to saying is, above all else, one thing that did happen is the prudence review that should have happened did not happen. And at a minimum, that would have established some point in time before today where potentially there would have been some carrying costs that was allowed to recover. I think that's where that's the summary of where we are.
Okay. Thank you. I think I think I'm finally done with my carrying cost questions, unless anyone else has any. I had some other sort of random questions about non-carrying cost part of your exceptions, but way fewer than I've had about carrying costs. Sure.
Can I
Commissioner
just
Cheeseman.
jump in? And again, we may have beaten this dead horse to death, but I'm not quite sure whether in my mind anyway, a direct answer to the chairman's question. How are you worse off today? In
Then,
terms of how this is played out from a financial point of view.
thank you. So we are worse off because if Pura had followed, we at least had a right to a prudence review and to a determination potentially before this point. Although no one can know what could have ever happened if things had been treated fairly and in accordance with historical Pura practice. No one can know that. However, we are worse off because if things had been done the right way from the time we filed in December of 23, the first time, the company would have either been able to come into its rate case and get the rate-based treatment that was historically allowed and gotten some level of compensation through that, or we would have at least had a prudence determination at an earlier point. So those are 2 points where we are now worse off today than we should be. Does that answer your question?
So it's in effect a lack of certainty as where you stand. That is where you see the harm.
I see the harm is that Pura changed the rules and Pura did not follow, in our opinion, Pura, number one, changed rate-making rules and set kind of retroactive requirements for pre-approval that we could never go back and get. So the rule had changed, telling us that rate-based treatment was no longer allowed, which definitely meant we were losing some amount of money. I don't know, I think we quantified it in the record as $140 million. Or we would have had a prudence review and gotten a prudence ruling at an earlier point in time than now. Either way, you're talking about some amount of carrying charges that would have been recoverable that now are not under this decision. Under this decision, it's zero. Under either one of those, it would have been some amount. It wouldn't have been the full amount. It would not have been the full amount. The question is, would it have been reasonably compensatory to the company for, given everything it's over the past 5 years that's happened? That would be a question to answer that we can't answer without the amount, but there is some amount of money that the company has lost and should not have lost because of the change in Pura practice and the refusal to do the prudence review. Those are the 2 things that went wrong.
So that's where you see the perceived harm.
Correct. Thank you so much.
Thank you.
Yes.
All right. Thank you, Mr. Chairman.
Sure. So on page 73 of your exceptions, this to completely switch gears, so it has nothing to do with carrying costs. This has to do with the compensation policy. There's a provision, the part of the PFD discusses that there was a prior Pura order for the company to work with OCC to kind of revise its compensation policy. And then the PFD discusses how like there was a change to it. And the response from Eversource, as I understand it, is, well, that compensation policy that was ordered by Pura was filed as compliance in a proceeding, but wasn't ever, Pura just never did anything with it. And I understand the argument in the exceptions to mean, well, since Pura never explicitly approved that policy, we could just change the policy, like that, we could change the policy so the PFD is wrong. Am I understanding that right?
So the key thrust we'd like you to please consider when you look at this argument would be the fact that we established a policy as of a point in time. It was a compliance filing in 1811-12. We filed in 2019. Wasn't approved by the authority, and we'd like you to please take it in consideration as a management running storms. We have the ability, within reason, to be able to make adjustments where the facts justify it to ensure that we can run the business efficiently and prudently, and recognize that there are appropriate adjustments that can be made to the compensation policy to be able to provide appropriate compensation to extraordinary efforts that we see during storm events. And so we're pointing out that the fact that we elected to change the policy is not in and of itself imprudence. We'd like you to please look at, was the decision to be able to pay out the compensation reasonable under the circumstances based on what the company knew at the time it made those decisions? Again, knowing that we're dealing with people who are humans and they're being called into extraordinary situations to be able to drop what they're doing with their families and respond to storms. And so was it appropriate? And we think the answer is yes, for the company to see what was going on in the workforce, to make adjustments to the compensation policy, to recognize extraordinary efforts. And the fact that we just simply decided to change it doesn't mean the fact that you change in and of itself is de facto or de jure imprudence. We'd like you to please apply the prudence standard. And we think when you do that, the evidence shows it was a reasonable decision under those circumstances to provide that compensation to hardworking men and women who went above and beyond to support storm efforts.
Thank you. I guess I was just, I guess my question is it wrong to am I getting hung up on the part of the argument though that that notes that PURA didn't explicitly authorize the compliance filing? I mean, because that's it's an argument you're advancing, and as I read it, it's saying, well, since you never approved it, it was, as you point out, the original compliance order was submit for PURA's review and approval. The company did submit it, then PURA never did anything with it. And it seems that the argument is, well, that means it didn't count or something. I mean, I don't want to make your argument for you. I guess it sounds like from everything you just said, though, that the more important argument is what you just said. So am I getting too hung up on that part of your exceptions?
It's very helpful to get your input because when we, as attorneys, draft work product, we don't know how the audience is going to receive it. And really, as a person who worked on the work product along with another team of attorneys, our goal was to say, if you look at that section in its totality, we'd like you, the key takeaway is, while we point out it wasn't approved by the authority, that's not the most important point we'd like you to take into consideration. It really is the points I made before, which are, when you apply the prudence standard, it was reasonable and appropriate for management to make an adjustment to a 2019 policy to reward and also to incent extraordinary efforts and recognize how hard people are working. And a way to recognize that is through providing appropriate compensation following the parameters of an updated policy.
Okay. Thank you. I have sort of I have a question about, I don't know if you read OCC's exceptions, but I have a question about an argument they make, and it's with respect to the ongoing review by revenue. It's hard to say those words together. I can talk to OCC about this later. I don't want to speak for them, but my understanding of their argument generally is, hey, there are these costs that but the company is telling us on the record are being audited. Like there's some reason to suspect that these costs were sort of overbilled, but we haven't finished the review of those costs yet. As I understand OCC's argument, they're saying you can't, PURA, you can't allow recovery of those costs that are in question, even by the company's own statements. I was just curious what the company's response to that argument is.
Of course, I can start and Attorney Kimball can add. So as I understand it, and again, OCC can clarify it, I understand their position to be that right now, the auditing firm revenue that we hired to look at specific vendors' activity and determine whether or not, when sometimes there's ambiguities in the contract, if there's an opportunity to be able to say, we'd like there to be an acknowledgement of an ambiguity in compensation or adjustments going forward, come back to the company. They appear to say that because the company has a pending audit and settlement discussions with 3 of the vendors, they appear to be saying all costs incurred by those vendors are therefore imprudent and should not be recovered. And the reason why the draft decision got it right is that, first of all, the draft decision recognized you want to encourage public service companies to utilize these types of techniques to ensure that we're vigorously looking at the expenses we're being asked to approve, and that's what we're doing. The other reason why the draft decision got it right is you say that on page 119, when the audit is completed, when the settlements are achieved, any money coming in the door will be a credit to customers. But there's no basis just because an audit is going on. And in particular, we explained that these audits tend to focus on ambiguities in the contract. So the fact there was an ambiguity in the contract, there's a dispute, and we're trying to obtain some money, doesn't mean the work wasn't done, doesn't mean the costs were imprudent. We've provided all the invoices. We've demonstrated the value they provided. And so the approach taken by the authority is appropriate. You encourage us to continue pursuing on with the audit and the settlements. Any monies we recapture go back to the customers in the form of a credit.
Okay. Thank you. Sorry, I don't know why I'm talking with my hand over my mouth. I had a broader question that's sort of related. I just really am curious with the company's response, and I did read your exceptions and your reply brief, which I think is probably the better source for the response to this. But generally, I understand, and again, I can talk to both of them later today. I understand OCC and EOE to both be broadly arguing that PURA can't find that storm costs are prudent while simultaneously acknowledging that there are parts of this record that no one's been able to vet yet, and that we think, as the draft decision indicates, we think there probably are more undiscovered errors in there. My understanding of the arguments from the other parties is, well, if you think there are other unidentified errors in there, you can't allow those costs. Like, how can you find that those are prudent and also recognize that the total costs that you're allowing as prudent are probably not fully prudent? So, just from a broad sort of like regulatory perspective, like, what are we supposed to do with this? Like, what are we supposed to do in a situation where there's so much evidence that everyone, including Eversource, as I understand it, like I'm referencing like the original PricewaterhouseCoopers audit, which had to kind of extrapolate across your own data, because there's just so much that even the company like can't really independently verify every dime. How do we approach this from a regulatory standpoint? Like, how can we legally find that costs are prudently incurred under 1619E and therefore allowable for recovery if we don't know?
Yeah, that's such a good question. And that's one of the things we were going to address up front if we had started first. I mean, the two statements that they point to are, it is more likely than not that further yet identified erroneous charges may exist in the company's request. And it shares EOE's concern that similar improper standby billing issues may be pervasive throughout the storm cost recovery request. Those are the two statements that they bring up. And so then from there, the argument is kind of made, so you found imprudence and yet you're including it in rate recovery. And this kind of goes against exactly what the Supreme Court, and then the Superior Court kind of said to PURA from the past, no, we don't really think that you can allow imprudent costs, and you don't have that much discretion to allow imprudent. But I think the issue here is, what is the prudent standard? And PURA got this, and I know this completely appears self-serving, of course, given the outcome, but PURA got the prudent standard exactly right here. And the reason that PURA did is that it focused on the actions of the company. In other words, there's always going to be, even if it hadn't been $1 billion, even if it had been 200 million, we're in Massachusetts, we have a much more cyclical process there. They look at things much more routinely. And so the most we ever have might be 200 million at a time, but they still do all the same stuff and they still find stuff because you're never going to not have these invoice things. But that doesn't mean that there's imprudence. PURA says, I think on page 61, and this is the benefit of what PwC brought, PwC does not prove prudence. There's no doubt about that. PURA said that they're not here to prove prudence, but they are here to look at the rigor of the company's controls. And it's the company's actions that cause costs. And I think that's one thing that's happened here. It was so valuable what EOE and OCC did. They did this heroic work, which I've never seen done at the level that was done here. of asking so many detailed questions. I think the issue is for every mistake they found, there was actually 10 answers that were actually validated. So were things wrong? And Pura's acknowledging that, yes, there's gonna be mistakes embedded in here that haven't been found. But where Pura stands is that the company's overall handling of both the storm restoration, but also the tracking, compiling, the reporting, the auditing, the validating of costs, all these processes, it's really that you're finding prudent. And I just want to refer people, I did look at this, in the ECES decision, says a lot of things about a lot of things, but one thing it did say is in terms of the prudent standard is it says this, and this is around page 13. It says a finding of imprudent management may result in the disallowance of cost recovery by the utility. Specifically, the costs or additional costs arising from an imprudent decision or action are not recoverable by the utility. And it said also further, and this is also on page 13, the burden of proof is applicable not just to rates, but to the utility's actions giving rise to the costs and rates. Rates are a mathematical determination and in isolation are neither prudent nor imprudent. It is the strategy, decisions, management, and execution by the utilities which has become manifest through rates that are subject to the prudent standard. So I think the thing we have here is they did find mistakes, but the mistakes themselves are not imprudence. They're not. It's the actions of the utility to try to minimize those mistakes, to try to control, to try to validate. And I think what Pura's decision does right is it focuses on the actions of the utility. So there's nothing in Pura's decision that is putting imprudent costs into rates. It's the costs are the function of prudent management, efficient management conduct, that's the finding that you're making. And those costs are then follow as being prudent and put into rates. And that's legally what is actually happening here. And I think this kind of gets to the issue of extrapolation as well, because in order for extrapolation to be something that Pura can adopt, that's a factual proposition. That needed some evidence to support the method. That's not something lawyers can come along and argue at the end. And that goes for company lawyers or any other lawyer. This is the methodology of extrapolation and how PwC went about its extrapolation and its audit. These are all factual issues. And so there has to be evidence for Pura to make that decision. So I don't think it's correct that you're putting imprudent costs. I think you found the actions of the utility to be prudent and the costs that come from that action are therefore acceptable for payment by customers.
Can I say that back to you?
I don't know.
Kind of.
Can you?
I don't know. I'm gonna try just so I'll zero in on order number 8 from docket 200803.
Yes,
So just saying kind of everything back at you.
yes,
In
please.
one sentence. So when the company makes an attempt to fulfill all the requirements in order 8 from that final decision, that is a prudent action by the company, the mere attempt to follow that order.
You exactly said it right. You have exactly got it. And when Order 8 came out, and it came out like at the end of the proceeding, it didn't come out in the beginning. I knew then, frankly, that this is what this case was going to be about. Did the timesheets get filled out perfectly? That was almost like the trap of that whole requirement, that then all kinds of costs were going to get disallowed if there wasn't perfect timesheets. Now, perfect timesheets is a great thing to do, and the company should be striving for the best information it can possibly get to. So you just said it exactly right. What prudence would count for, and that's why we tried to put so much evidence in here as to what they did with the timesheets, is it goes to how does the company take that order, how does it implement it, how does it try to get to the aspiration of perfect timesheets? How did it try to get there? Did it do enough? It has to have some level of rigor. The standard is reasonableness. What's reasonable? It's not just reasonable to like pass out the timesheets and hope you get something back. That's not going to be reasonable for a utility. The utility has to have some rigor behind that. So I think that's the decision that Pura has made here, is that there was sufficient rigor undertaken in relation to the timesheets to constitute prudent conduct. And so you have just said it exactly right.
Thank you. This conversation actually leads right into something I keep thinking about, and that is, I have my cheat sheet of regulatory standards. I think I've like a dozen, top 10 or something like that. But anyhow, right at the top is use and useful,
Right,
prudence.
right.
The third one I have at the top is operate with all reasonable economies. And I was interested in people, just all of you discussing today, if you can, within the confines of the record and the case and the law. Do you regard prudence and by reasonable economies, that's a fancy way of saying, efficient.
Yeah.
Does prudence subsume efficiency or vice versa? Or could you have something that was regarded as a prudent response, a reasonable response, but that's not particularly efficient? In other words, not meeting that standard.
I think that's such a good question. I don't know how. I think prudence requires efficiency, and it does under the law. That's Connecticut law, right? The Connecticut law says that you have to demonstrate prudent and efficient management. So in Connecticut, specifically in Connecticut, not same law in other places, joins these two things together.
Yeah, I mean, and I asked this because I actually searched some these briefs and some of the record, and I think we tend to conflate them, which I think you just did, and I'm not sure that that's correct. And I think some of the frustration when you hear about the auditing, the extrapolation, the disallowance struggles, right? The burden of proof struggles. Some of that may be due to a problem with efficiency as much as a problem of prudence. I mean, there's a reason why we call it out separately. And so, but I guess to get this to a question, you're saying, I mean, you did mention, sorry, I'll back up a second. You mentioned controls. I think that's a great example of prudence. But efficiency is something else. And again, we're talking about ratepayer dollars. And so, I think there really has to be that separate consideration of efficiency and economies in the management, even of catastrophic events, which perfection is not the standard. But, prudence and efficiency, especially given the tools available today, and we talked about that a little bit in this proceeding, didn't we? We talked about, the evolving tools that we have, thank goodness. And so some of those really aim toward both prudence and efficiency, but I'll let you just comment a little bit on this issue of efficiency.
I'm think that you've stated it well. I think you can show prudence without being efficient. I think there can be cases where the prudent thing to do may not be the most efficient thing to do. I can imagine a whole series of examples of how that might be, where a utility is proving that it had to incur the costs that might not have been the most efficient thing, but for whatever reasons, circumstances existing, and maybe controls is such a good example of that, because the more controls you have, that's one of our concerns with the timesheets. The more controls you have, the less efficient it gets. And so if we're looking to run crews efficiently, having them line up when they come across the state line and teaching them how to use an app on the phone so that we can grade them within 24 hours as to how well they use the app. I don't know that that's tending towards it gives us definitely better information in the regulatory review, no doubt about it. Who wouldn't want to walk in here with perfect information? I would. But is that going to be efficient for the teams out in the field that are really trying to get people out working, get them back in, get them fed, slept, but there's a balance. We always have to be trying to strive for these balances. So I think that they are different. You can prove prudence. Maybe it is prudent to have everybody doing the timesheets perfectly. Maybe we would say that is how we would get to cost prudence here. It may not be the most efficient thing, but it may be what we want in order to validate the cost. So to me, a utility can prove to be prudent without being efficient. However, in Connecticut, where you have this, also this standard to show that it was efficient management, I would not want to walk into this room without also being able to argue that it is efficient, that it was efficient, even putting aside the prudence. So I think they overlap like a Venn diagram, but they're not exactly the same thing.
I understand. Thank you. But some efficiency takes some investment. And so yes, and that might even be a bit of time or a bit of training or so on. But the whole idea is that it pays you back.
Right.
By better management through the process. So, so my thinking is I can imagine prudent solutions that are inefficient and efficient solutions that are imprudent.
Right.
So I just think here and going forward, I think it's worth investing some thought
Yes.
into the difference and how, again, I think there's an expectation on the part of ratepayers that given our role as substitute for competitive discipline, right, that efficiency is part of that.
Absolutely. And I think that as painful as it was, all the questions from the parties that came, the 1,700 questions, what I saw is that what took some time is that the teams would go back and they would research everything. They'd go try to trace it all the way back to find out what happened so that they could explain it, so they could maintain credibility into why something went wrong. But also what they took out of it is how to improve for the future. And so I think that all this level of detail has done a lot for improving. And I think we're going to see a lot of improvement going forward. Like, I think this is a kind of a bump of history, but going forward, things will improve going forward and going through these reviews, because we'll be talking about smaller amounts, smaller filings with all the benefit of what we've all learned from a process and demonstration, perspective. And I think it will get more efficient.
Thank you. Thank you, Mr. Chairman.
Sure, and I'm out of questions. So I think Attorney Pace, if you want to proceed with, I meant to say also, like I said before, we're ending with the company as well. So if you want to reserve whatever statement you want to make till later, it's up to you.
Thank you. After conferring with my colleague, Attorney Kimball, we're fine with holding our remaining comments until round 2. So thank you, and I'm glad we could start with your questions.
Sure. So it's OCC's turn. It's 11:53 a.m. though. So I guess I'll ask OCC, would you rather start and break for lunch in like half an hour, or do you want to break for lunch now? And I have maybe a slightly smaller number of questions for you than I had for Eversource, but still a lot. What do you think?
We can keep going.
Okay. Well, and first I'll also extend the same option. Do you guys want to provide a statement first, or?
We'll proceed with your questions and then can do any wrap up that we see appropriate.
Okay. My first question was sort of out of order, but just because we're just talking about it, I had a question about the revenue argument, the revenue, the name of the accounting firm, not. How do you respond to Eversource's point that whatever adjustments revenue ultimately finds will be credited back to ratepayers? Does that resolve the concern that you raise in your exceptions?
Thank you for the question, Mr. Chairman. I don't think it does. As the issue is being discussed further, I couldn't help but think to myself, would you eat a half-cooked chicken? I would not. And that's what we have here, that, this resolution of those particular costs isn't done yet. And so to put them into the pool of costs that's approved and say, well, we'll just credit ratepayers back later for that amount that does ultimately get tossed out. I think that's a risky precedent to set. It puts the risk on the ratepayer and having to fund costs up front that may later ultimately be deemed costs that they are not responsible for legally. And I just don't think, and our office doesn't think, that's a good precedent to set in this case or really in any other.
Okay. Thank you. I read this argument in your brief and also in your exceptions, and I understand the argument to be that Pura should remove all the costs, like the total costs that are currently under review. I just couldn't find, and maybe it's just me, I couldn't find anywhere in your brief or exceptions that identified like what that dollar figure is. Do you know if you have a proposed numerical adjustment to the allowance based on this?
One moment. We can get back to you on that because we have to pull up one of the interrogatory responses to verify the actual number, but we can do that during the break. Thank you, Chairman.
Sure. Going back to sort of the order of your exceptions more naturally, I had a question about right at the beginning of your exceptions on page 2, there's a table and a related argument. And you say disallowing only 3% of storm costs as imprudently incurred is drastically lower than any prudency allowance in the authority's storm reviews over the past decade. And the table shows us the results from the prior storm reviews. Can we consider, is it appropriate for us to consider that? Like as we're analyzing a particular case, should we be saying to ourselves, should we have said to ourselves sort of at the end of the PFD, like, uh-oh, this doesn't look like a lot compared to prior Pura decisions, we should probably go find more cuts. Like, is that what you're saying?
I'm not saying that there should be a hard and fast rule of, oh, we always have to find 10% or something because that's what we've done in the past as the authority. But I think we pointed that out more just to emphasize that the way the proposed final decision approaches the review of these costs and the ultimate proposed approval of them does depart from sort of the overall trend of the level of approvals that the authority has deemed appropriate in the past. Now, obviously, each of those dockets involves distinct factual situations that are different from those that are in the large record in this proceeding. But I think we talk about this all the time, the importance of consistency in regulatory, in the regulatory sphere. And this would be the outlier among those in terms of the levels of approved. So I'm not saying there's a hard and fast rule that Pura needs to apply when it looks at storm costs and say we have to allow this much or disallow that much. But I think just in the spirit of being consistent, and I think really the level that was arrived at here that we calculated around a 3% reduction is reflective of some of the issues that, in the proposed final decision that I imagine you probably have questions about that, and I can tie that back in when we get to those.
Okay. Thank you. In the same, I don't have the page number in my notes, but in the same part of your exception, you referenced the decision in 200803 RE01, which is the Isaias related NOV proceeding, where Eversource is penalized. And I understand the argument, I don't have a quote, but I understand OCC's argument to say Pura can't find, since Pura found that Eversource engaged in imprudent management in that case, Pura can't, I think it might even uses the frame, can't like turn around or reverse course now or fold, as our Attorney General likes to say, and decide that there are costs that Eversource actually acted prudently here. Can you just talk more about what the argument is with respect to that Isaias decision?
Sure. I think that was what surprised us because, those Isaias costs are in the many costs that are in this proceeding, and sort of looking at how those costs were treated in UI's case. And in that investigation into Isaias, as I'm sure the chairman recalls, Pura at the time made the determination that UI had performed substantially better than Eversource in its response to that storm. So I think in our expectations of what we had hoped to see in the proposed final decision, we would have expected a greater chunk of disallowance associated with Isaias based on what PURA did find to be insufficient storm response and adherence to standards in that earlier investigation. So that's, we raised that for that reason. I think, many consumers, even though it was 6 years ago now, that incident still looms large in the minds of many ratepayers. And I think if we have to explain to a ratepayer that Eversource recovered much of, the vast majority of the expenses associated with a storm response that the public at large and many policymakers deemed to be completely insufficient, I think that would raise some questions in the mind of the average person paying their bill every month.
Yeah.
I'm sorry, Mr. Chair. Are you on the same thread?
Yep.
Okay, keep going.
Oh, okay. Isn't the finding and wasn't that NOV finding though related specifically to like the municipal liaison program, Eversource's makes protocol, timeliness and communications? Like, what's the connection between those findings and the recovery of the costs for restoration?
So I think we agree with you that the factual circumstances are different and the imprudence findings were based on, a set of actions or inactions taken during the storm. But what it does is provide context. And I think we thought it was important to remind the authority of that context because we felt like the PFD consistently gave Eversource the benefit of the doubt when it was a close call about whether a cost was prudent or they tried hard enough or we've talked a lot about their controls. Their controls, they tried hard, but implementation may have lacked at the end, the analysis ended up not disallowing and giving Eversource the benefit of the doubt. So it's important to recall that there have been imprudent actions, in storms that are within this docket. And we think the perspective the authority should take is protecting customers.
Okay, maybe I'm thinking of this like too myopically, but help me like navigate this because I sort of see it as it feels to me like the prudence determination from the NOV proceeding. Like one of them was essentially that Eversource didn't secure enough resources in response to that storm. So doesn't that mean that they probably underspent? Like, which means that they should probably I don't see how the relationship to that determination and like, well, we're determining that they spent the right amount of money, or we should be recognizing that they spent too much, which is the inference of like that there should be more findings of like disallowances based on prudence. I think I understand the policy. I think like if we were politicians, I think I would understand like, oh, Isaias was bad. People didn't like that. We shouldn't give them a bunch of money for that. But I don't. Can you help me reconcile? Like, in a way, it seems like what PURA determined back then was that Eversource didn't spend enough money on that storm. So how is it that we should be disallowing more recovery costs?
That's right. And I don't think the ultimate question is whether enough was spent or too much was spent or too little was spent. It was how it was spent. And that's what gets to the heart of the prudence inquiry, which is a fact-based question. I think the criticism from PURA at the time in response to that particular incident was that, Eversource had insufficiently staged and prepared for the magnitude of the impact on the state. But that's almost irrelevant to the prudency inquiry because you're stuck with a pot of money that whatever was spent was spent. So how was it spent? Was it spent reasonably at the time? And that's really the locus of the inquiry.
Okay, so would the question how it was spent, but looking at your exceptions, it appears in many cases it was not so much how it was spent or that we can't find in the record there are flaws in the record. So it was not actually the areas in which it was spent. You just can't prove that you can back this up with stuff we have here.
Yeah, thank you.
So I'm trying to reconcile the two because I think there's a big difference between a decision how, were things done to restore power properly? How was it done? And then, prove that you actually spent this money in the way and back it up with, invoices, et cetera, things in the record. So help me reconcile that.
Thank you, Commissioner Cheeseman, because that's really the crux of our exceptions. And, most of the conversation this morning is focused on prudency. But in our view, we've skipped a step there because the first step is that burden of proof. It's 1622. It is incumbent upon the utility in any proceeding to produce the evidence that's necessary to verify the costs. Once those costs have been verified and the evidence is in the record, then the authority would move on to make that prudence determination. But in many cases, as we've pointed out, there just wasn't evidence. Now, I recognize that Eversource, for example, we were just talking about timesheets. Eversource may have implemented internal controls to ensure the filing of the most accurate timesheets possible. But when a timesheet comes in that's incomplete, that doesn't have that data in it, that timesheet just categorically cannot meet that burden of proof because we don't know if that cost is verifiable, what it is, just because of the missing information as an element of that piece of evidence. So I think, the logical way to approach this is, the company comes in, they make their request, they produce the evidence. Is that evidence complete? Yes. Move on to the prudence inquiry. Is that evidence incomplete or missing? Well, then they haven't met the burden of proof, and that's the end of PURA's inquiry on that aspect.
So you're saying that determination of prudence is solely based on the validity of 100% of the things that the company produces?
I'm saying it's a fact-based inquiry, which has to be based on evidence. So in those parts of the record where there's insufficient or incomplete evidence, that prevents the ability of a full factual review to make that legal determination as to prudency.
So 100% accuracy is essential to determining prudence? Is that what you're saying?
I'm not saying 100% accuracy because we'd never get there, right?
Right. Well, where do you draw the line? And given that we are operating, again, in a volatile environment, i.e. a storm, what is the appropriate place to decide this is the percentage of validity that we need to see? Is it 51%? Is it? I'm just curious as to how we draw that conclusion.
It's a great question because that's where we get back to the thing that flummoxes all of us at one point or another, and it's PURA's discretion. I mean, when PURA is the finder of fact in an administrative proceeding, they have to weigh the evidence and make that determination. It's not an easy determination. I don't envy it as to whether there's enough factual basis in a particular piece of evidence to make the necessary legal conclusions that must be drawn from it. So it's the preponderance of the evidence standard. Is it more likely than not?
But you would argue that based on what you found in the record, there is insufficient to allow us to form an opinion of prudence because of the lack of validity of the evidence presented.
I would submit that, and it's not so much that. Because at that point, under the burden of proof standard in 1622, the authority doesn't even need to get to the question of prudence. If the authority determines there's not enough evidence to reach that question, that's the end of it. Those costs, if they can't be verified or confirmed in any way, it shouldn't be the responsibility of ratepayers to assume those costs.
But it is our discretion to determine at what level we assess that validity in making our prudence determination.
That's correct. I mean, that discretion in any case, as always, this case or any other, is based on what is in the record, what is not. But it's ultimately a conclusion that the authority has to reach based on its own expertise and its staff knowledge.
Right. Thank you. Thank you, Mr. Chairman.
Thank you. So looping back just a little bit to your summary on page 2, the chairman alluded to the thought that a regulatory commission that was motivated by politics might be looking for a reason to knock down a request. That doesn't happen here. It won't. But is there also an economic rationale here? Because under the regulatory model, companies have a strong motivation, don't they, to include every last nickel in a filing, because that's their starting point. And we don't usually come here and say, let's add some money, although you made a good exception to the rule there, that with the example of the big storm. But isn't that also part of the, but I share the chairman's concern about, whether we benchmark disallowances, because I just don't think that's good practice. But is that part of the concern that not only, in sort of validating the numbers, that you're also dealing with a big pile of numbers because there's a strong motivation by the utility to put that forward.
Thank you, Commissioner Beecher. Yes, that is certainly a concern. And I think the benchmarking is helpful in this context, especially given the enormity of the request and the fact that we're looking at 43 storms, over a period of multiple years. Much of the data is stale. There was concessions that information was no longer verifiable due to the age of some of these storms. So if you look back to, some of the other dockets, which are smaller, both in terms of time range and the number of storms being evaluated, I think it becomes, really important and frankly, made the 3% disallowance proposed in the PFD, hard for us to understand how that is a fair and just outcome for customers.
Thank you. Thank you, Mr. Chairman.
Sure. Page 7 of your exceptions includes this statement. It does not matter how well Eversource designed the controls if they did not function correctly, and it was their function, not their design, on which Eversource relied to support its storm recovery request. How do you square that statement with the standard of prudence and the standard of, hindsight review? Because it sounds like what you're saying is, well, it doesn't matter what their intent was, what matters was the results. And isn't that like the opposite of what the legal standard is?
It is. That's not what we intended to say there. I think, not to bring them up again, because frankly, I'm sick of talking and hearing about them, but the timesheets, that's a prime example. I mean, there was an order to make changes there. The company put into effect changes to its policies and protocols regarding those. And then 3 years later in the record, we still see the same problems occurring again and again. Wouldn't the company at some point, a prudent company, have looked back and said, this isn't working. It's not doing what Pura wanted us to do. It's not ensuring the accuracy that we would like to see internally. Maybe some changes were warranted. So I think a situation where a company, as we would submit, just puts into place a protocol and says, one, done, good, and then just moves on. I think that can't be the standard because it doesn't allow room for internal self-improvement until a point where a regulator, which could potentially be years down the line, as in this case, says we might need to change that. But no, we weren't advocating for a hindsight analysis of prudency, obviously. Has been discussed many times in this room in recent years. We know that's not a thing. So
okay. I mean, because this is what this says. I mean, you're saying it, you're literally, the words say it's the function, not the design, that matters. It sounds like you're saying, though, it is the design that matters. It's just that there's a responsibility to continuously iterate that design in a way that is responsible. Is that
right?
Is that what you're saying?
Yeah, any company policy from a utility shouldn't be a one and done. Ultimately, the goal is to provide reasonable and affordable service to customers. And if some company policy is not effectuating that, it should be revisited.
Just to add to that, it's the implementation. You can design a perfect timesheet, but if you fail to give it out, it doesn't materialize into a benefit for customers. So while we are not trying to infuse a hindsight analysis, those decisions being made by management at the time have to include the implementation process of the procedures and controls that were established. It can't just be that they exist in a vacuum.
Okay.
What we're trying to say.
I had a similar question about PH8. I think I already know the answer, but PH8 sort of criticizes the PFD for applying a given the old college try standard with respect to timesheets. And my question was similar, like, I think I understand the crux of what OCC's point was there, but I had a similar question, like, but isn't it about like trying? Like, isn't prudence ultimately analysis of the sufficiency of an attempt? But would you provide the same answer that you just did in response to that question?
Probably, and I think this gets back to the point Commissioner Beecher was making earlier, was a company could do something that is completely prudent and then it just fails. But the actual decision itself might have been prudent and just circumstances that no one could have foreseen intervened. But I think something like timesheets, it's not that, that's not an atypical occurrence, is the filling out of a timesheet during a storm response. It's something that happens in every storm over time, again and again. And to the extent there are problems, it should be revisited. I mean, I can't think of a single job in my picaresque career where if I didn't fill out my timesheet, I would still get paid.
Yeah, I saw a reference, I think, to a similar statement in your exceptions of your brief. But like, but what we're analyzing isn't like whether, in that analogy, isn't whether like you get paid, it's whether your boss did a good job, right? Like, so that's where I get a little lost in that. I mean, I have the same issue, but we're not deciding whether the vendors got paid or not. I think what we're trying to decide is whether the choices Eversource made in leading up to the payment to the vendors were prudent, such that the costs should be recovered from ratepayers. It's kind of different, isn't it?
Right. I mean, you're deciding which costs that Eversource has already paid for, shall be paid by customers. And I think that's where, it's not just about, certainly we don't want to take away the pay of the hardworking line workers who are out fighting the storms. That's not what we're seeking here. But it's always a question of what amount of costs that shareholders absorb as opposed to ratepayers, and where there isn't a clear proof by a preponderance of the evidence that a cost was prudently incurred, we don't believe that ratepayers should have to pay that portion. That should be left to shareholders.
Okay, this is a similar question, and I think I might not even be worth asking because I imagine we'll have the same discussion. But on page 13, you criticize the PFD for acknowledging that Eversource's mileage reimbursement policy adherence is inadequate, but for nonetheless permitting the costs. And my question was, is it possible for a company's policy adherence to be inadequate, but for the resulting expenses to be prudent anyway? Meaning the result of reasonable management decisions in light of the context they were made? Like, is it possible for, it's the same question, I guess, like that. To me, like, inadequate adherence is ultimately like a results-based determination, right? Like, this wasn't good enough. What happened here wasn't good enough, which is, again, seems like the wrong standard to be applying. Like, the question isn't whether the results were good enough, it's whether the college try was sufficient, isn't it?
Well, I just want to loop this back to the sort of the two-part analysis I talked about further. I mean, to the extent there's missing information in the record, let's say the incomplete mileage, there's parts of that can't be verified. The company hasn't met its burden, and when we get to the actual mileage that can be verified, we can look at the policy and say, well, it could be improved, but when they put this into effect, it was prudent, it did make sense. But to the extent there's mileage, sought where there's incomplete information, that just shouldn't be the responsibility of customers. I think we would just get back to that same point I'd raised earlier in response to Commissioner Cheeseman's question.
Okay, and I do have a bunch of questions kind of getting to this point you keep raising about the specific evidentiary burden, and I wish I put them sooner in my list, but I don't want to go out of order because then I'll get lost. I want to move on to the concept of the burden shift, which is like the sort of a primary theme of your exceptions as I read them. So we generally discuss the concept that the PFD inappropriately shifts the burden to the state parties rather than the company. And there's a statement on page 15 that says, not extrapolating from the state parties' findings placed in the record through discovery effectively meant the state parties had to identify every incorrect cost. Despite the PFD stating the correct burden of proof, in practice, it consistently relieved Eversource of its burden and applied that burden to state parties. I struggle with this, I think, for the first part of that sentence, because it seems like what that says is, unless we accept the state parties' extrapolations, we're shifting the burden to the state parties. And I'm not sure I understood, I don't know if I followed that logic.
Where are you? Oh, okay.
You found it?
I did. Thank you.
I would read that I think our intent was to say, you know, given the enormity of the record and the recognition by the authority that it was impossible for any party to review every single piece of evidence, the only way to avoid sort of giving Eversource the benefit of the doubt, approving costs that haven't been proved, I guess the reverse of that would be to extrapolate a percentage of, you know, errors or imprudence due to, you know, lack of evidence in the record. So by not endorsing that practice, you've essentially, yeah, the PFD essentially says you've got to pick out every single absence of evidence in the record or lack of prudence in order for us to specifically disallow it. Does that look at my team? Maybe they can explain it better.
No, that's fair.
Yeah, I think, I mean, I definitely understand the argument. It reminds me, frankly, of not to pull on any strings, but it reminds me of the Aquarian rate case and like sort of the issues that came up there with respect to burden, right? Like, but the issue there, as I recall, was, and you know, I'm really not trying to start a fight here. I'm just sort of teeing this up. The issue there was the perspective that there wasn't enough evidence in the record for Aquarian to support its proposed plant addition. So the issue here, it seems, is that there's too much evidence in the record. Like, it seems to me that the problem we're faced with is we can't identify what costs are unsupported. Do you disagree with that perspective?
I think I'd frame it slightly differently, because you know, from our review of the too much evidence, we identified substantial gaps in that evidence. And that's what we're relying on to say that Eversource hasn't met its burden of proof.
Okay. But the PFD, not entirely, but largely, like, does make adjustments based on what was found, right? And I guess, like, the question is it appropriate for us to just assume without, like, what about, I sort of asked Eversource this question about, you know, whether it's legal for us to approve, to find prudence, like, based on essentially like assumptions. Is it legal for us to find imprudence based on assumptions that the same kind of errors that have been identified must be elsewhere? And not to cut you off, Attorney Minkowski, but I think this is a different question than the sufficiency of evidence question, because this isn't a finding that, well, the timesheets don't support, like, there's not enough evidence here. It's really like a different problem, which is like no one's got the time or resources to go check whether these same sorts of errors are somewhere else. So like, how do we, if we don't accept an extrapolation for reasons, for example, that we explained in the PFD, what are we supposed to do? I guess is the question.
I mean, the awful answer to that is to go through everything. Hence why I think EOE and OCC had proposed extrapolations in its briefing, just with the recognition that the amount of material was impossible for any party, including the company, to fully vet, you know, every receipt in the record. Just there's not enough time in a life to do that. But I think, you know, our concern was, you know, if there is some level of extrapolation that is permissible from the authority's standpoint, I think all of the parties would benefit, Eversource, OCC, EOE, from just knowing what that is, just so they can prepare accordingly for any proceeding where hopefully this never happens again, but there could be proceedings in the future where there are, you know, very voluminous records that are, like here, you know, often assembled in haste, you know, during storm conditions, and are not going to be perfect, and there will be error in them. And I think that's really what we're looking for. You know, we proposed an extrapolation, EOE did, trying to find a way to reasonably tackle what was a record of unprecedented size. And so that's an area where I think guidance from the authority moving forward would be helpful. I don't know what that standard is, but I do agree it would have to meet all the basic standards of administrative law. It would have to be reasoned in some way. It would have to be based in part in substantial evidence in the record. But it's just, that's a question that I don't know if anyone has an answer to, but it would be a question that would need to be answered if we find ourselves in this situation again. And as our exceptions point out, if there was a type of extrapolation that the authority would have or did indeed find to be insufficient, it would have been helpful to the parties to know that at some point in advance of the hearing prior to much of the discovery and briefing.
I did.
Just to add to that, I do want to point out that Eversource also relied on extrapolations in seeking to rely on the PwC audit and the rate of errors found in that context and extrapolating out, a disallowance number based on that sampling. So I don't think we're unique in trying to address the voluminous nature of the record through that. I also think there's clearly the authority or the PFD is concerned about extrapolation. There's also, I think, in my mind, a difference between extrapolation in terms of percentages and inferences. And I do think the authority should consider, even if it felt that, the parties didn't look at enough storms to make a fair extrapolation, I still think it's fair for the authority to look at the storms that were evaluated for inferences into how, likely or not it was that Eversource met its burden of proof with respect to the other storms.
So you think it's permissible under Title 16 for us to use an extrapolation with which we're comfortable and say this and the evidence supporting the extrapolation that's sufficient evidence for us to find to be a foundation for disallowance of other costs, like via the extrapolation methodology?
I do, and I think even 1619, I think it's EA4, which Eversource has relied on in this argument, does caveat the allowed recovery and the level of structure of rates with providing appropriate protection to the relevant public interests. It's not a universal 100% guarantee. There are, it infuses discretion within the authority to ensure that customers are protected, and that's what we're seeking here.
And the preponderance of the evidence standard, again, hearkening back to evidence class, it's 51%. It's more likely than not, right? So is it fair for us to say, I guess just connecting the burden, like the standard of sufficient evidence, and then what kind of evidence? Is it sufficient for us to look at evidence of particular costs in particular storms, look at a reasonably structured extrapolation, and then say it's more likely than not from our perspective, meaning just slightly over the line on balance, that there are probably similar disallowances that we can spread across this body of costs? Do you think we could do that?
I think so, and that's actually why we approached the extrapolation the way we did, where we reviewed entire storms from top to bottom with the goal of identifying trends that may have, continued across multiple events, with the recognition of, okay, if, this particular issue comes up in the storms we reviewed, there's probably a good chance it came up in the ones that we didn't have the time to review, versus some isolated, unique issue that was, only appeared in one storm or something like that.
Okay. I just want to ask this question before I forget, because I want to take it out of order, but you brought up Attorney Miniskowski, the idea of kind of PURA giving clarity. I saw on page 15 of the exceptions, OCC appears to argue that the PFD sort of failed to provide parties the opportunity to prepare intelligently, and it cites to that case, by not announcing the expected standard for extrapolations. And this is sort of like a procedural question, but at what point and in what manner were we supposed to do that before we knew that you planned to extrapolate, which we didn't know until you filed your brief?
Well, here's the thing. So our view of the record of our interrogatories was that if you read them, you could figure out what we were doing. Likewise, as we read EOE's interrogatories as they came out, it was clear to us what they were doing, which in part informed our own strategy, so we didn't double dip on particular storm events that were in the record here. I think that's something that in a future case could have been resolved via a procedural order. The authority has a tech meeting early on in a case and says, look, we're dealing with a huge amount of evidence here. We think we're going to approach it this way. Do people have concerns with this? You know, here's what we're proposing as a methodology that we'd like the parties to follow. Is there a legal objection? Is there a reason this is factually infeasible based on the type of materials that are in the record? And just put out a procedural order to guide the proceedings from that point forward. You know, that's not as common in PURA proceedings, at least in recent years, but I don't see a reason under the UAPA why something like that couldn't be done.
Yeah, I mean, I don't disagree that it's a good idea sort of moving forward now that we've sort of identified our concerns. I guess my question was more like, how are we supposed to know we had concerns? I guess we were supposed to glean from reading your interrogatories, oh, they're probably going to extrapolate and we should have a tech meeting.
That would have been my preferred gleaning, but
Okay.
we can't hindsight, you know, don't want to apply it to PURA either, so.
Okay.
I also think, you know, to the extent there's continuing concerns with extrapolation, you know, I mentioned inferences, but there are other ways for the authority to ensure that, you know, before it issues a final order that, you know, it really believes that customers should pay 97% of these costs. And that's to, you know, evaluate the record of the storms that between EOE and OCC have missed, and to actually, you know, identify whether or not Eversource has met its burden of proof. You know, it seems at this moment it seems to be a, you know, giving Eversource the benefit of the doubt there, but that may be, you know, a way to address our concerns while acknowledging yours.
Thank you, Mr. Chairman. So just quickly, can you offer a perspective on whether extrapolation as understood for by auditing firms is that sufficient to extrapolate findings of prudence or efficiency? Or, you know, I mean, obviously it informs it, but doesn't demonstrate it. There's still, so what about this issue of how can you and how would you extrapolate to prudence or efficiency, or do you need another set of tools in the toolbox?
Thank you, Commissioner Beecher. I agree, and I think we made a point in one of our briefs to, you know, ensure that the point was made that the audit that PwC did was for accuracy and, you know, catching errors. It was not and should not replace a prudency review. And for that reason, you know, it served its purpose, but we still had to evaluate whether or not the decisions made at the time were prudent and reasonable and, you know, to the benefit of customers. So I do think it's important that both prudency and efficiency be evaluated separately.
And I think we'd agree it continues to be a challenge with massive amounts of data, because even though you can shift from the, you know, the validity and reliability question, and then you're shifting to these other questions, you know, that presents a distinct set of challenges, because you can, you know, to what extent can you infer prudence on the basis of a sample, you know, across a management realm or something like that. So, I think we need to give this some thought too. Thank you.
How do you respond to Eversource's argument, which, again, I won't speak for them, my understanding of Eversource's argument that extrapolation requires like a factual finding, that we can't just accept extrapolations advanced in briefs, that there needed to be some sort of testimony or a factual basis for us to evaluate in order to accept an extrapolation?
I don't think there would need to be a factual basis for an extrapolation. I mean, if the authority creates rules all the time, right, in its decisions into how it's going to approach particular issues, it has the discretion to do that. And I think this is something that would fall within PURA's discretion, you know, to say in these circumstances, you know, when A, B, and C are met, this is when extrapolation would be appropriate with these safeguards. I think that's something PURA could announce in a decision and carry forward as necessary into future proceedings.
Okay, but I think, and again, I'll let Eversource follow up with any clarification if I'm getting their argument wrong, but I understand their argument to say, OCC can't just jump in at their brief and say, for instance, 20% of overall cost should be disallowed, and here's why we think that's true. Like OCC, I think from the perspective of the company, needed to like hire a witness who has some credentials and extrapolations and would be subject to cross-examination, and that there need to be that sort of factual basis in the record for us to kind of consider the proposal. Is that, I mean, just how do you, if, again, I might be misunderstanding the argument, but how do you respond to that?
Yeah, I think that's a bit extreme. For instance, the 20% that was in our brief, I mean, that came from testimony by, an Eversource witness that they estimated that about 20% of timesheets were wrong. And so we took that fact that was in evidence under oath and said, well, if the company knows 20% are wrong, then perhaps 20% is a fair number to use as a disallowance. I mean, I think so long as the recommendations that are being made have some basis in the evidentiary record, I think the requirements are satisfied. I mean, I could understand something like, how to do an ROE calculation. That makes sense. We have witnesses in here following very specific methodologies that they've developed themselves, and Pura has to determine whether those are in accord with recognized standards or not when reaching a highly technical conclusion like that. But in terms of how to approach a record, to have testimony on top of testimony as to how to approach the testimony, I think that would be an unnecessary procedural step.
Do you see your proposed extrapolations as essentially your positions? Like you've evaluated the record and your position is that based on the record evidence that Pura should apply the proposed treatment across the body of evidence?
I think given we feel that Eversource did not meet its burden of proof to demonstrate that each and every one of these costs is prudent, and given the company's concessions about estimating the accuracy of some of that verifiable information, that felt to be the fairest place to land.
Okay. I'm trying right now. It's 12:37. I'm trying to guess. Just like when I used to sit there, right? Still not good at figuring out how much time I have left. I would say I might have 10 or 15 more minutes of questions just for OCC. So again, I guess I'll leave it to you. Do you guys want to just push through to 1 o'clock, or do you want to take a break now?
No, let's just finish now. Sorry, Mr. Chairman. I think we should just finish now because that would provide a logical breaking point in the proceedings.
On page 14, you discussed the dock crew discussions in the PFD. And the PFD states that although the record raises questions about the issue, I mean, I'm paraphrasing, the record doesn't clearly demonstrate that that there is a higher cost using the dock crews. OCC says this is a burden shift, that this determination inappropriately shifts the burden away from the company. Is your argument that if Pura just disagrees with OCC, like specifically if we think that there's not a sufficient factual basis for your position, that that's a burden shift?
No, I don't think so. And I think, to be clear, this whole burden shift argument that we're making, I don't think it was some intentional thing. I don't think Pura took all of the evidence back and the briefing back and said, hey, let's make OCC disprove everything. I think in figuring out how to tackle an atypically large record that had holes in it, that had large portions of the record that just frankly had not been reviewed by any of the parties, that it inadvertently created this burden shift in certain parts of the proposed final decision, where Eversource presented a cost up front, and unless there was anything from one of the other parties to push back against that, it was taken as gospel and awarded recovery.
Okay, well, that kind of leads to my next question. Is I think like the commission has been doing this thing that I perceive as sort of different than maybe recent years, which is I feel like we're trying to make an attempt in our decisions and proposed final decisions to articulate like, hey, this is hard. We're struggling with this. This is an issue that we're not sure of, and we don't really know where to land. But ultimately, this is where we think we should go. I've just noticed in a lot of different proceedings, like that seems to be freaking people out. And I've heard arguments that like, well, since you're not sure, that means you're not allowed to rule in favor of the company. Is that Is that what OCC is suggesting here? And would it be more helpful if we just stopped doing that and just like hammered our fists on the table and said, this is the answer?
I don't think the authority should shy away from recognizing when there are difficult issues before the bench. You know, I think that helps all parties prepare in different ways for future proceedings, because we can take that back, the companies, OCC, EOE, AG, and say, you know, to what extent did our development of the record or our arguments or our testimony create a knot that Pura had to figure out how to untie? And how can we approach that in a way that's more efficient and more clear in the future? So I don't think that's something Pura should avoid doing. I mean, as I'm sure you know, Chairman, courts do that all the time when they're faced with difficult decisions usually. So they don't take it personally if they get overturned later, recognizing that an issue is new or difficult or there's not a clear answer in the law. I don't remember what the rest of your question was.
I'll just add to that. I fully agree. I think calling out the difficult choices and evaluations that the authority is required to make determinations on is certainly appropriate and transparent. We're the Office of Consumer Counsel. We represent ratepayers, customers. When there's a close call, we're always going to urge you to fall in the way of the customer. The authority has, jurisdiction to balance those interests. And from our perspective, the best way to protect customers from unjust costs is to make the determination that when it's not clear by a preponderance of the evidence that that Eversource has met its burden, that those costs not be passed on to customers.
I think to bring it back to the dock cruise, I think what's vexing was the PFD explicitly acknowledges, the record is not clear on this, and then awards Eversource the cost. So that's where, from our end as the consumer advocate, there's sort of a disconnect there in the logic of, all right, if this isn't clear in the record, then why is recovery being permitted? And I think that's where those burden shift concerns come in. So, because we take that back and say, okay, well, how could this have been approached differently? Should we have done more? But that's not the legal standard.
Yeah, well, I mean, it's sort of raising this interesting question for me, because I think like what also a new thing we're trying to do, I don't know if people have noticed, is that we're trying to explain, even when we don't make an adjustment, why we're not making an adjustment, which, was maybe less frequent before. But I guess I sort of struggle with like, how do we communicate, hey, OCC pitched us this idea, but we don't think, we disagree. We think that there isn't sufficient evidence in the record to support OCC's idea, so we're not accepting it. How do we say that without it feeling like we're shifting the burden? Like, because, I think what happened there was sort of, I think we recognize the concern. There's some ambiguity here. You're asking us to make an adjustment. We don't think there's a sufficient basis in the record for the adjustment, even if we recognize that the record is somewhat murky on this issue. Like, is that I just take from your exceptions, well, that means that's a burden shift. That means that it's your responsibility to find and support every different adjustment.
Well, I think if we proposed something in a hypothetical brief and Pura didn't buy it, I think it's more helpful for Pura to say, we don't agree with this, you didn't back it up, or we don't think this makes sense. That's more helpful to us, honestly, because it helps us refine our arguments moving forward. It also makes for a clearer decision, just from a reader perspective, whoever's reading it, whether a company, another state party, a court on review, the clearer it is why Pura did what it did, the better the decision.
So I'm just following on from that and looking at this page 14. This is, once the PFD found insufficient evidence in the record to approve the request of recovery, it was an error for the PFD to then approve Eversource's request minus only the specific amounts identified by the state parties. This removed the burden of proof from Eversource to make the case and shifted to state parties. So looking at this particular case, you identified certain mistakes. Should it then be the assumption of the authority that everything is wrong in that? Where is that line? I mean, yes, you've identified certain errors, but is it then your contention that and Eversource is presenting their testimony, they're adopting it, they're swearing it under oath, that we had simply extrapolate an amount throughout that? We can't make up a number. I mean, I suppose my question is where do we then draw the line? Again, we can't make an arbitrary and capricious decision. Well, they found these errors and it's X percent, so we are going to, help me with this.
We're certainly not seeking 100% disallowance, but the PFD repeatedly acknowledged close calls, and given the lack of evidence in the record, it would be those, situations that, we would advocate should go to the benefit of protecting customers from those costs.
This is also where I just bring it back again to the preponderance of the evidence standard that we were discussing earlier. On those close calls where it's Pura looks at it and says, what do we do here? That's the evidentiary standard that if there were review by a court, the court is going to look at to make sure that Pura applied. And so as long as that evidentiary standard is being applied to Pura's decision-making, that's the expectation from the case law. So I think, whether in this case or any other case, that's sort of the lodestar in how to find guidance to how to resolve some of these more difficult evidentiary questions.
Okay, thank you. Thank you, Mr. Chair.
I've gotten to the part where I had questions about like the sufficiency of the evidence itself. So on page 34 of your exceptions, you discuss this issue. There's a sentence in there that says the authority should reject Eversource's request to recover amounts not supported by invoices. So we talked about this a little bit before, but does that mean we categorically must have invoices in order for Eversource to have met its burden?
I think so, yes. I mean, when you seek recovery, you need to have some documentation of those costs. If there's not an invoice to back up a cost for recovery or a receipt or something, I don't know how the authority can approve that under the substantial evidence standard.
Okay.
Because any review will say, okay, you approved this cost. What was the approval based on? And if there's nothing there, that's just a lack of evidence in the record. And as you know, Chairman, that's the sort of thing that doesn't survive review.
Yeah. On page 34, you reference the company's response to EOE 432 as an example of an area where
there is no page 34, Chairman.
Oh.
It's just going for
Hold on, I'll find where I am.
Oh.
Thank you, Attorney White. You're always keeping me honest.
Is it in the brief, Attorney McCormick?
Oh, maybe it's in our brief.
Chair, is it in the original brief, OCC's original brief?
It could be. Hold just a second. I guess it must be. I guess while I was, doing all this, I somehow started looking at your brief and got confused at what I was looking at.
Oh, yeah, it is the brief.
We're sure it was late at night, so no.
Okay, it was.
Your
It was
excuse.
late last night, to be specific. So page 34 of your brief then, and sorry to switch to the brief, but there's an argument on page 34 of your brief about sort of the sufficiency of evidence, and you're pointing to the company's response to EOE 432, and I won't expect, you don't have to pull up that response right now. I'll sort of explain to you. I looked at it, and it's the kind of response where EOE asked Eversource to provide, quote, documentation detailing the activity performed and detailed hours charged per individual. And the company filed an attachment that was an attachment, as far as I could tell, that was prepared by the company. So it wasn't like external invoices, but it was an attachment that showed descriptions of work performed, applicable hourly rates. It had a bunch of data there. So I guess my question, getting back to what I just asked you, Attorney Minikowski, is that can we not trust the company's testimony or its testimony adopting its own exhibits as a basis for a finding? Like in that circumstance, did we still need external receipts or evidence generated by someone other than the company to substantiate a finding?
Yes, and it's not because you can't trust them. It's just because the evidentiary standards are such that there needs to be substantial evidence in the record, and simply a bald statement. And we have case law that says that, just the statement by a corporate officer or a company witness saying, here's what the dollar amount was, Pura doesn't have to take that because it's not enough. I mean, there needs to be something to undergird that assertion, whether it's timesheets or receipts or invoices or what have you, depending on what the expense is. But I think just plain testimony without any other verification of what makes up those costs, I think it would be improper for Pura to take that, simply because there's no way to verify it. I mean, you could have a witness who inadvertently says the wrong number, no one catches it, and now the company is getting recovery for that number, and no one is any the wiser because there's no way to verify it in the record.
Yeah. So I looked at that case. There's that 1971 CNG case, which is there's
Right.
no sacrosanctity about the testimony of a company officer. That's one. There's the infamous, there's that other case with the bald statements, evidentiary hair quote, which is horrible. Then there's the Gold Star case that says we aren't required to believe any expert, but this is sort of what I'm getting to. All those cases, as I read them, say Pura doesn't have to believe a company officer. It seems that like what OCC is saying, though, is that we can't, that if we believe a company officer, we are violating an evidentiary standard and we can't make a finding of substantial evidence based solely on what Eversource tells us.
I think it depends on what the evidentiary question before Pura is. If it's how does the company approach X situation that comes up, and someone from the company with substantial knowledge of that testifies as to what the protocols and procedures and how the company handles something, that's probably sufficient. But when the question is, you have a cost here for $100,000. What makes up that $100,000? Where did that come from? I think there needs to be something more than just a statement of, oh, well, it was all vegetation management. Okay, well, where are the receipts? We need to be able to add this up and make sure it's the right number, because we're not, what the authority is doing there is not just determining the credibility and the validity of the evidence, but making sure the numbers are right, to make sure that the amount of recovery that's granted is the actual dollar amount that's appropriate and not some overstated or understated amount based on ambiguities in the record.
Okay. So if we, in your example, even if we had, well, I'll just use the example again of EOE 432, which I'm sure, which I told you didn't have to look at, but it looks like Attorney White has it. The attachment to that. So that, as you're probably looking at, and it's also redacted, so it's probably a terrible example, but that attachment does show sort of like individual line item costs. It shows lots of information about like, here's the cost rate that was applied to this line item. Here's the date that it happened. It's information that presumably the company is sort of like pulling from its own accounting system, but nonetheless, it's the company's information. So I guess what I'm asking is, if we accept that without looking at the invoices received from the external vendors, does our acceptance of that not survive judicial review?
I don't know if it does, because I think there is a question there of whether there was any way for the authority to validate it at that point. That's not to say that, a company witness or a company staff member, can't be trusted to compile information. They certainly can. But this is a question of recovery. I mean, it's not an abstract number. It's let's make sure the dollar amount is right. And, in that case, Eversource was seemingly aware that it needed that additional information because in its interrogatory response, it had noted that it was reaching out to that particular vendor to obtain that information. So I think when we come to cost recovery, it's we need the receipts. I mean, it's like any other bill you would pay. You would want to make sure that what you were being charged was what was the right amount.
Just a quick follow-up. And this may have already really been answered, but isn't there a standard in regulatory practice that audited financial records, by a certified auditor, are generally a starting point for in many cases, a starting point for the regulatory auditor, recognizing also that we'll have on-site auditors go in and take their own look, but isn't there a general acceptance of that certified document?
Yeah, that's a great question, Commissioner Beecher, because I think this actually gets into the rules of evidence, which don't apply here. But there's certain evidence that carries greater weight than others. So, a series of financials that have undergone an independent audit and a certification process like that is something that Pura could probably take with greater weight and less concern, instead of just a representation of, oh, here's what the dollar amount was. In that case, Pura would have to look towards what is the best evidence there to prove that dollar amount, which in some case might be receipts or invoices or what have you. So obviously there's a there's a spectrum here of reliability of different types of evidence, and it really just depends on what we're talking about in a given moment to resolve a particular factual issue.
Thank you. That's helpful. Thank you, Chairman.
I don't mean this as like a zinger or a gotcha or anything, but how do you reconcile everything that you've said here with OCC's position supporting a $175 million adjustment based on a statement from Mr. Sullivan, a statement from a utility witness about the 80-20 split? Like, why can we believe him and just take that statement, oh, there must be only 80% of timesheets must be accurate, and make a gigantic adjustment based on that without the OCC is proposing you don't need to look at the timesheets. In fact, we're extrapolating because you can't. I'm just not sure I track, like, if the standard is we're not allowed to allow a cost unless we have the receipt, how can we disallow a cost because we don't have the receipts? I mean, how do we get to that number on the basis of believing a utility executive?
Why did I hire you again? Just kidding. No, but that's a good question, because I think our recommendation for the 80-20 split wasn't just the testimony of Mr. Sullivan alone. If we had just said, all right, Mr. Sullivan said 20%, I think there would be probably more of an issue there. But it's in combination with the other evidence in the record. You know, there was these recurring issues with timesheets throughout. You know, the record demonstrated there were many timesheets that were incomplete, that the field resource coordinators in many part knew that the timesheets in certain instances weren't being filled out correctly in accord with the protocols. And so for a situation like that, it's not just the testimony in isolation, it's in the larger picture of the entirety of the evidence of the record. And that, you know, we have the testimony of a relatively highly placed company officer saying, you know, his understanding was that potentially 20% were wrong. And we felt comfortable going with that because we ourselves could see in the record, and the other parties can see in the record, and the authority can see that, yeah, these issues with the timesheets are evident when you start going through them in the actual evidence that's there. And so it's not just the testimony itself, it's that the representation made in the testimony could itself be independently backed up by the other documentary evidence in the record.
But we don't need all the documentary evidence to support your proposal. But I feel like what you were just saying before is,
well, that gets,
we need to see every invoice. And if we're missing an invoice, then that's going to be
well, that gets back to the burden issue. You know, on those issues where Eversource didn't produce an invoice, or there's missing invoices, or there's an invoice that's so incomplete, the actual total in it can't be determined with veracity. You know, that's an issue that gets to the burden of proof, you know, where it's incumbent upon the company to produce the records that are necessary for the authority to verify costs. In those instances where the company can't, either, you know, because of an external error or a record-keeping error, or they just couldn't find something, you know, years down the line, you know, that's not something where the ratepayers should assume the risk. And that's sort of what gets back to the philosophical core of our office's position on this. You know, in those instances where evidence cannot be mustered and brought into the record for whatever reason, it's just simply not the case that ratepayers should assume that the resulting risk of that should be placed squarely on the company, and would hopefully incent them to do better in future proceedings and change policies as needed, or institute better internal record-keeping procedures.
Okay. My last question on this, and I think it's my last question for OCC. Getting to the timesheet issue, you know, sorry if this is duplicative of sort of what I've already asked, but like my view of sort of what's in the record is there are these incomplete timesheets that OCC has pointed out, but there's also testimony from witnesses explaining, yeah, the timesheets are incorrect, but we validated them. Like we called these vendors and checked, and we worked it all out. And ultimately, even if the timesheets are incorrect, we've made adjustments, and what you're being charged is accurate. And I know that OCC and EOE have found instances where that doesn't appear to have taken place. But are we allowed to credit that, like, similar to what you were just discussing, like the combination of evidence? Are we allowed to, like, look at an incomplete timesheet and then hear testimony from a witness that if we find, oh, that sounds truthful, we're applying that a lot of weight. Are we allowed to combine those two things and say, I think these are prudent costs? Or does there still need to be some sort of additional evidence as a matter of law, not as a matter of discretion?
Right. Yeah, I think Pura could do that depending on what the facts of the situation were. Let's say we have an incomplete document and then there's a witness who provides compelling testimony about how the company filled in those gaps and arrived at a number. That could be creditable testimony when the authority weighs it. Conversely, the opposite could happen. There could be a gap in an invoice or a timesheet. The company provides testimony on how that missing part was resolved. The authority doesn't find that testimony itself compelling, and there would need to be some other documentation of the record. Okay, you called the vendor and worked out the issue, but did they send you an updated invoice? Did they provide you with numbers from their own record keeping that you can use to verify what the amount would have been? I think it's just a question of in each factual determination of the authority and the other parties, following the evidentiary trail where it leads. Sometimes that trail is short, sometimes it's long and winding, and sometimes it doesn't go anywhere and we can't figure out what happened. So, I think this just gets back to sort of that fundamental administrative law principle of, every fact that's determined and found by the authority is going to require a different analysis of different types of evidence in the record. In an ideal world, everything would be crystal clear. We'd get a record in the docket, would have everything everyone needed to answer their questions. But as we know, that's often not the case, particularly in situations like this where I think in large part, a lot of the costs we were looking at had aged. They were years and years old, and it's difficult to recall what happened in a particular storm 5 years ago.
When I used to be a real lawyer in courts, oftentimes a defense to an objection would be it goes to the weight, not the admissibility, meaning, this is admissible evidence. You might not, it might be garbage, but it's not less sufficient. It can't be excluded from the record for the reason opposing counsel is proposing. Doesn't that standard apply here? Like, isn't the objection from OCC, shouldn't the objection from OCC be to the weight as opposed to the admissibility, meaning you don't want us to believe company testimony, but we can, and we can apply whatever weight we want to the company testimony, even if from your perspective, we shouldn't. I guess I'm just still challenging, where's this necessity for additional weight come from? Because to me, it's either it's in or out. And if it's in, we can apply whatever weight we want to it. Am I wrong on that?
It's in, but once, as you know, the authority has a very low threshold for what is considered relevant evidence. It's pretty much everything, unless it's clearly irrelevant or needlessly duplicative. But once it's in the record, and the authority is weighing it, there's that additional administrative law standard of any finding of fact has to be bolstered by substantial evidence in the record. And so the authority has to be certain that any finding of fact it does make in any proceeding, including this one, is bolstered by substantial evidence. There has to be enough evidence in the record that the authority knows that the fact it is finding is more likely than not. And it's those instances where it falls below that. And, this is the role of other parties, OCC and otherwise, to argue, hey, here's a contested fact in the case. We don't think the company has met its burden here. We don't think Pura can infer a positive fact in the company's favor from what is in the record. Conversely, there may be issues where we say, yeah, this is crystal clear from the record. There's enough there that no one would seriously question whether this was in dispute or not. So like I was, going back to what I was saying before, it's really an issue by issue inquiry where the authority has to weigh the evidence in light of its discretion, the substantial evidence standard, and the preponderance of the evidence.
Okay, just a quick follow-up. Attorney Minkowski, you've mentioned the issue of staleness a couple of times, I believe, in your filings. What is the legal basis for the authority to consider the age of evidence? Is there statute of limitations on evidence?
No, and this is where we get into the issue of administrative law, where the formal rules of evidence don't apply to these proceedings. I think in a case like this, where we're going back many years, and I'm sure we'll all be dealing with this in Eversource's rate proceeding as well. We're going to have invoices that may have been churned out 7 years ago, and maybe company personnel who were involved in procurements or management of projects may not be around. They may not recall exactly. And I think that's where the actual in-person witness testimony that we have is important. There can be a receipt. There might be a question about what that receipt reflects or what that spend was. To the extent that a company witness can testify compellingly about that, even many years down the road, then Pura would be safe to credit that. But to the extent someone looks at it and says, well, I just don't remember, I can't recall, then perhaps there should be a question there, well, we may not be able to resolve this issue simply because there's no way to verify it given the passage of time.
Thank you. And wouldn't we, last question, promise. And wouldn't we also then have to consider that information technology and management systems have evolved over that time period?
Yes, yeah.
Okay, thank you.
All right. I think that's all the questions we have. Does OCC want to make an argument, like a prepared argument at all?
Yeah, no one's eating lunch here today. No, we'll wait to do that till round 2 so that we stay consistent with Eversource and everyone's on the same page. Thank you, Chairman.
Okay, sure. So we'll break for lunch. Just for everyone's expectations, I think we can do a round 2 because I'm out of question. After I'm done with you guys, I'll be out of questions. So I think the second round, I imagine, will go much faster because it can be each party's opportunity to sort of respond to what happened before. So we'll plan to try for a round 2, and then, as I've said, at the conclusion of round 2, we'll stop with Eversource having one last say. So why don't we come back at would 1:45, I think would be safe. Does that work for everyone? Okay, thank you.
My computer dies, I'm in charge of
He's just keeping us all on our toes.
Yes.
Oh, right now? I'll walk out.
Go ahead.
Going to the garbage. Thank you, ma'am.
Oh, shoot. Forgot my. I brought my, my laptop is left in my, but I agree with that. What? Have fun. Very nice. Yeah. Take the. Songs clearing up. Yeah.
Tomorrow's supposed to be really bad again. It's supposed, things.
Oh, that's cool.
Yes.
Yeah, Justin's awesome. You can include my song.
Perfect timing. It's easy when I open my heavy bag. I go, what the heck is in there? I feel a pain. So, Brittany. It's nice to meet you, or meet you in person. Yes.
Because it's hard to.
Tom, it is.
Oh, yeah. Yes.
Yeah.
And Brandon, I have that.
Okay, I know Tom Klein.
Yeah.
John will be honest. It's not.
Okay, we are back. I got an update from Mr. Bumpin that perhaps he has scared facilities away from doing the fire drill today, so let's hope. If we get a fire drill, it's Mr. Bumpin's fault at this point, so. Does anyone have any administrative issues before we get back to it?
I do, Chairman.
Sure.
Thank you. So previously you had asked a question about the revenue. We've looked that up. It is in our brief, our initial brief at footnote 64, and it comes out to 98 million, I believe was the adjustment proposed in there. So if the authority refers to that portion of our brief, that should have all the detail necessary.
Okay, thank you. Anybody else? All right. Oh, we're going to move on to EOE. And I think Attorney Lopez has anticipated my question. Would you, well, I think EOE didn't even actually request argument, but if you would like to make one.
Well, if I may, Chairman Wheel, so there were a couple comments that we have that, and in our written exceptions, we said, obviously, we refer back to everything in our brief. But there is one specific area that we didn't provide in written exceptions that I would like to expound on in commentary. And you know, I understood your preference, but I do wonder, and this is just a suggestion. So I don't know how much the Attorney General's office will have, and just in the sense of maybe to be efficient and consolidate, I could provide my comments, take questions, and then instead of a come back to EOE, you know, as a full round robin, you've kind of hit one side. We'll say all the things, answer all the questions, and then move. You can go back. So I with maybe that latitude, and maybe some of the comments that I provide could. I won't presume that they will answer all of your questions, but maybe they could answer some of them.
Sure, if you want to start with comments, that works for us.
All right, that sounds great. Thank you. So good afternoon, commissioners. I really appreciate the considerable effort reflected in the PFD. We agree with many of its conclusions, particularly the denial of retrospective carrying charges, the exclusion of ineligible events, and numerous prudence adjustments. Ultimately, and I'm sure you would have asked questions about this, and you will still, one of the central legal issues is whether Eversource met its statutory burden to prove that the requested storm costs were prudently incurred. And it's my contention, EOE's contention, the company must do more than show that they spent money. They must demonstrate with evidence that they spent money prudently. And we would suggest that the record demonstrates in multiple areas the company didn't meet that burden. And so we talked a lot about burden shifting. The burden of proof doesn't shift, right? I think everyone agrees that Eversource restored power after significant storms. That is not the issue before the authority. The question under the statutes is 1619, 1619E, and 1622, it's narrower. Did Eversource prove these costs were prudently and efficiently incurred? So 1622 places the burden squarely on the company, not on EOE, not on OCC, not on the authority. And we believe the proposed final decision correctly states that principle. However, and we understand it's a proposed final decision, but the practical application we felt from the proposed final was EOE did not sample enough. We didn't review enough. And that's not the legal standard. The legal standard is whether Eversource proved prudence by a preponderance of the evidence. And so the authority itself recognized that unidentified and erroneous charges likely exist outside of what we had already determined. The authority also recognized that there are concerns with improper billing, and those concerns were pervasive. One of those findings, once those findings are made, the company hasn't carried its burden. And so the inability of regulatory staff to review 30,000 invoices can't be a substitute for proof by the applicant. And so unfortunately, I think otherwise the precedent becomes simple. And I know, I'm not, this is unprecedented in many ways, but the precedent would become simple, right? Wait years before filing, produce hundreds of thousands of pages that can't be entirely reviewed, compress the schedule, right? We understand that the company got essentially the schedule they wanted, and I want to note that there was no statutory deadline for this proceeding, but we're here now at the behest of the company. So that's what we're doing, and then they recover virtually everything that regulators lack time to verify. And so I think that incentive that could be produced is inconsistent with Connecticut law. So I presume you're going to ask quite a bit about extrapolation. So just from my perspective and EOE's perspective, extrapolation is the logical consequence of this record. EOE's review identified problems throughout the application, so not isolated errors. And so and I'm sure you're going to ask some specifics, but examples include unsupported pre-staging costs, unsupported materials, vegetation management billing deficiencies, dock crew costs, standby labor and equipment, unused generators, mileage, excessive vendor billing, improper storm eligibility. And I wanted to throw this in there. It included janitorial services and incremental storm costs. And no one can explain to me how carpet cleaning is necessary to storm recovery and is an incremental expense. I don't understand that. And there was also inadequate documentation supporting contractor invoices. So the authority correctly, and I think the proposed final decision did this, it correctly recognized that sampling is appropriate in a case of this magnitude. So the disagreement that EOE has with the proposed final as written is not whether extrapolation is permissible. The disagreement is whether EOE's methodology was representative. So Eversource relied heavily on manual records rather than searchable data systems, which required EOE and OCC for that matter, but EOE performed a forensic sampling review. So we reviewed approximately 1,770 vendor invoices, more than 3 times the number reviewed by PricewaterhouseCoopers. And every confirmed error was accepted by the company. And so the higher error rate was not the result of selecting unusually problematic storms. It was the result of performing substantially deeper testing. So Consumer Counsel Coleman earlier mentioned, she talked about inferences. So if more intensive review consistently finds more confirmed errors, the reasonable inference is not that those 4 events were unique. And so we highly sampled 4 specific events. We did more than just that. So we do, and that's in our written exceptions. But the reasonable inference is that similar errors exist elsewhere where no one had sufficient time to conduct the same review. So even if the authority remains uncomfortable with EOE's exact extrapolation percentage, the answer should not, and EOE argues, it cannot be 0. So the authority could adopt a more conservative extrapolation using additional storm events potentially. I know Consumer Counsel alluded to potentially reviewing additional storms. But what should not happen is allowing recovery regardless of confirmed error patterns simply because every invoice couldn't be reviewed. And so we don't believe the company shouldn't benefit from maintaining records that are so voluminous and disorganized that complete review becomes impossible. The inability to examine every invoice can't relieve the company of its statutory burden. And so now I just briefly, if you'll allow me the indulgence, I know this wasn't in our specific written exceptions, but I wanted to speak about it. So improperly aggregated events. In our brief, we called them the multiple events. I want to speak specifically about one, which was, so in the proposed final decision disallowed several, but it allowed one, and I want to speak to the one that's MN23T heat wave event. And I think, interestingly, I thought this was one of the ones that we had the strongest evidence on our side for removal. So that heat wave is not a major storm event. It's an accounting construct. While I appreciate creative accounting, I don't appreciate it when it's at the detriment of ratepayers. And I think the company is seeking recovery for what it characterizes as a single 4-day heat event. But its own evidence demonstrates that this was not one continuous storm. Instead, it was a series of separate weather events that the company combined into one filing. First, Eversource's own weather report identifies multiple weather phenomenon, not one storm. The company describes 3 consecutive days of temperatures above 90 degrees, but it also acknowledges that 2 of the 4 days experienced separate thunderstorm development, followed by a cold front ending the heat event. In other words, the company's own meteorological staff or evidence describes changing weather conditions rather than a single catastrophic event. Second, the NOAA treated these as separate events. So NOAA records identified distinct weather events on the evenings of July 27th and 29th of 2023, rather than one uninterrupted emergency. So that independent weather evidence aligns with what the company itself experienced operationally. And maybe, and perhaps most importantly, is the company's customer restoration curve, which disproves its own position. If this were truly one storm, you'd expect to see one outage peak followed by one restoration effort. Instead, the restoration curve shows multiple distinct outage peaks occurring on different days. Those separate peaks correspond to the separate NOAA weather events, demonstrating customers were experiencing different outage events, not one long restoration for a single storm. The vendor records tell the same story. So EOE reviewed the line crew invoices for the event and found that contractor activity changed over time. Some vendors completed work and were released, while different vendors were mobilized later in that period, in the 4-day period. That pattern is consistent with responding to separate incidents, not maintaining one continuous emergency response. So why does this matter? Why is Tom Lopez bringing this up here now? So I think it's because the catastrophic storm framework never intended to allow utilities to aggregate routine operating conditions until they exceed the eligibility threshold. So if July 27th, 28th, 29th, and 30th of 2023 are evaluated as separate operational events reflected in the record, none of those individual events would exceed that $4 million threshold for major storm reserve treatment. This would remain ordinary operating expenses already contemplated in base rates, which, there's been a lot of theoretical discussion about rate cases and when things should be and where, and maybe this is why we've always done these in rate proceedings. But the broad concern here is precedent. If the authority permits aggregation here, which it should not, there's no meaningful limiting principle on the company, right? What's their incentive going to be moving forward? A utility could combine multiple days of heat, scattered thunderstorms, or routine weather into a single storm whenever doing so produces enough cost to qualify for reserve recovery. I'm just going to say I grew up in South Florida, born and raised. It's all like from May until October, it's over 90 degrees. There's an afternoon thunderstorm every afternoon. That's routine, right? I can't even imagine if Florida Power and Light could just aggregate that into, right, like, oh, we'll add the hurricanes and that, like, that's not what this is meant for. Obviously, these are supposed to be catastrophic events, and you're not supposed to create this separate framework to create a catastrophic event, right? Oh, we had enough things happened in a close enough time, and while there was a heat event, it wasn't the heat that caused the power outages, it was thunderstorms that caused power outages. We have the ESI to handle, impacts on, heat stress to the grid, but the bottom line is the framework exists to recover extraordinary costs of extraordinary events, not convert these ordinary summer operations into a catastrophic storm through accounting aggregation. So EOE requests that the authority find the MN23T event and all aggregated events noted in the EOE underlying brief that they don't constitute a single ERP level storm and exclude those costs from incremental storm recovery request. So we can talk, and maybe I'll save carrying charges. I think you might have questions for those. I'm not sure I have to speak about that, but the remaining issues all reflect the same principle. So for mileage, right, the authority recognized that documentation is insufficient and that supervisors could not adequately validate reimbursements. Yet recovery was still permitted because the sample was too small in the proposed final decision. So for unused generators, the company staged equipment that was never used without demonstrating necessity at the time the decision was made. That's, from our perspective, that's a prudence issue, not a hindsight issue. We're not judging after the fact. They just had extra, right? There was not some weather event or report that said they needed all of these things. There was not some use that they needed them for. For dock crews, and I'm sure you'll ask about this, the company never demonstrated why outside contractors were necessary for remediation performed days or weeks after storms instead of internal crews. So there is evidence that these were days or weeks after the fact. I'll probably go back based on questions. For the Frontier contract, right? The record contains testimony acknowledging the company paid lodging and meals. Company paid lodging and meals were not allocated under the settlement agreement, yet those costs remain in the recovery request. So while the facts may differ, the general legal principle does not. So briefly, EOE isn't asking the authority to reject storm recovery. That's not what we're asking. And I don't think, I presume from our brief that that's not what was indicated. We're asking the authority to, and we're not asking for the authority to disregard the substantial work reflected by the company, right? They clearly did work. They clearly, turned lights on after storms, right? But we're just asking the authority to apply the burden of proof consistently. You are the fact finder. I'm sure we'll get into questions about that. But we believe the statutes require the company to prove its costs, not for the state parties to disprove every dollar. And so I'll stop there and take all of your many questions, I presume. Thank you.
All right, thank you. I have a couple questions in response that just came up in response to your comments. So you talked about the danger, and I think I saw this in your exceptions and maybe also OCC's exceptions, that this notion that like the PFD sort of encourages this system, creates a playbook, I think I saw in someone's exceptions, for utilities to sort of just, all we have to do is file an extraordinary amount of documentation, and then we can kind of end up with a result where if we give so much documentation, no one can review it, then we will recover our money. I think I understood that concern. I guess my question, though, is how is it that under an extrapolation proposal, the regulator doesn't, I guess the utility doesn't face the danger of a regulator who can say, oh, you know what, there's too much evidence this time, we're super busy, we're just gonna find 4 or 5 errors and extrapolate across your entire body of evidence. I guess the more like precise question is, how do we know what case we can kind of use an extraordinary tool like extrapolation and when we can't?
Sure, thank you for that question. So I think here, certainly, I think that is at the discretion of the authority, right? Ultimately, if we're looking at 4 or 5 storms, well, we could probably review all 4 or 5 storms. And I think, one of the things that we spoke about and it's hard for me to recall at this point, whether it was our brief, our reply brief, our written exceptions, or where it was, right? The company did make a choice, right? The company, right? Their initial filing at right? So the initial request was, so we're talking about storms 18, 19, 20, 21, 22, 23. An initial filing came 6 years, full 6 years. Even if you say, it was December of 2023, it was, mid-December of 2023. So really a full 6 years. And then multiple storms were added after the fact as well, right? The company could have filed a rate case in 2019, 2020, 2021. I think there was maybe a gap there where there was a brief stay out based on a settlement agreement. But I think they could have come in again for rates in 2023 for effective rates in 2024. So, while we understand, and I've heard a bunch of things from the company, none of it entirely makes sense to me, other than that it was clearly a strategic decision, which is, I guess, the prerogative of the company. My concern is that, it allowed the record to build up. So I don't think the company should be the beneficiary of that and then to not allow extrapolation. So, I'm not saying that extrapolation is required in all cases. It might not be. That being said, I think the authority can use its discretion here to extrapolate error rates based on, and I'd like to think that we provided a roadmap and would be happy to answer more questions about that. I hope I answered your question.
Yeah, thank you. Getting to the MN23T011, I never know when to stop.
Yeah, I just went with MN23. There's a lot of other numbers.
I drew, I guess, like the inference, I don't remember whether EOE or OCC maybe spelled this out directly in their brief, but my understanding of like the arguments, particularly the EOE made with respect to the storms, some of which the PFD does accept, the arguments with respect to the storms being multiple events. Is the concern, or is it the position of EOE that there is an incentive for a company to stick multiple events together so that if they can exceed the $4 million threshold, all of those expenditures are eligible for recovery outside of base rates?
Right. Yes. That's and not to be overly succinct about it, but yes, that is the concern, right? I mean, I look at this and okay, so yeah, there was a declared heat wave, but a heat wave is not a storm. It's not a catastrophic event. There are things in base rates where they're making investments in their reliability infrastructure. That is in base rates. But where I have a problem, and I think it could be a growing problem if we're talking about climate change and weather patterns, right? Like I said, I grew up in South Florida. That was the summer was a common occurrence for thunderstorms, right? But those are clearly, the whole summer is a heat wave, But those are different thunderstorms that caused the power outage. So I think there is an incentive, right? If you know the threshold is $4 million, and you have 2 thunderstorms in a 5-day period, and they click over 4 million, and there's a strategy for whatever reason to not come in for a rate case, wouldn't it be in your interest? Again, I'm not saying that's what they did. I'm just saying I think anyone can make that reasonable inference that there's at least going to be an incentive there.
Okay. This question is not really before us in this proceeding, but I just want to ask it because I think speaking for all 5 commissioners, we've all discussed how we got to this place in this proceeding with this enormous amount of material. And we've had discussions about like whether the storm cost recovery framework that exists in Connecticut still makes sense in light of sort of what we've seen. I think Eversource has also asked itself those questions. Do you think, though, that part of that incentive problem is related to the fact that a catastrophic storm is defined by an expenditure amount?
It can be, yes, absolutely, right? I'm not sure, right? So, I mean, okay, so $4 million, right? Now what's okay, now I know that, right? That's my guidebook, that's my playbook. And that's, I appreciate this conversation. I think it's really valuable. I think that's part of the concern is I think about the precedential value for any of this, right? Is to say, well, wow, I have a great, okay, if I can get this, which are clearly 2 different events into one event, and I get that is incremental outside of base rates, what I'm not sure that is the best outcome, right, for rate making principles overall, right? Things carrying, right? There are many concerns, but there is nothing that requires a dollar threshold either, right? So maybe it's level of effort. Maybe it's something else entirely. Maybe it's a higher dollar threshold, right? And maybe it's a dollar threshold tagged to inflation. I'm not saying I have the right answer for the commissioners here in this moment about what the right answer is on that piece specifically, but I would suggest that the answer is no. I don't think it has to be a specific dollar amount.
Okay.
Sorry.
How do you, getting back to MN23T, how do you, Eversource, as I understand it, again, as I keep saying, I'll defer to them. They can let me know if I'm misunderstanding their argument. But I read one of their arguments, I think, in their reply brief that some of the arguments, maybe this was even in the exceptions, there's an argument Eversource has advanced about hindsight review. That's sort of saying, okay, maybe those events in retrospect, maybe it was 3 distinct thunderstorms, and maybe even the restoration curve looked like 3 separate events. But we didn't know that at the question isn't what actually happened. The question is, did we prudently incur these costs with the information we had at the time? So, the question I'm going to get at is, the PFD, as I understand it, sort of tries to approach maybe a similar concern by analyzing Eversource's preparation for events based on like their information ahead of time, as opposed to ultimately what happened, like whether the events in retrospect look like they should have been viewed as multiple events. How do you respond to that with respect to this particular storm?
Sure. So I mean, and I would call it storms, but I think that's right. So a heat wave itself, they're not right. So and I did see this in the final decision, and proposed final decision, and Governor Lamont did declare a heat wave event. The interesting thing is if there's a heat wave event, it doesn't necessarily and always mean that there will be a thunderstorm event attached to that, right? So I think while they may have done preparations, right? The note, right? So the meteorology reports, right? So hindsight, but I don't think we're looking at this hindsight. What how they looked at it, it's the evidence is in the record, right? They saw two different distinct events. They saw two different distinct events, and that's, I'm not sure I don't want to make any other broader conclusions about this, but I like I said, I think there's a certain accounting incentive.
Okay, thank you. I'm going to switch to questions about your exceptions.
Yes, please.
I can't find the page number on your exceptions, but your exceptions discuss how the PFD appears to have an inaccurate understanding of your proposed extrapolation methodology. Generally, and there's a quote in there noting that the PFD got it wrong when we said that EOE's review of 4 events resulted in, this is the one that said, resulted in $1.8 million in identified reductions. Your PFD, I mean, your exceptions clarify that it was actually only $903,000 in errors relating to external vendors. And then you say the difference between the total reported errors and the $903,541 is attributable to errors for other storm events and other non-vendor errors. I just got lost there. I was hoping you could explain to me, like,
Sure.
What is it that you're saying we did wrong, and what should we have done differently?
No, so I think, and I want to be clear about this, right? I'm not necessarily saying the authority did something wrong, but it appears that you may have misunderstood what we did. And so that's, so to clarify, so zooming out a little bit, right? A lot of the attack, and I think from the Eversource reply brief, which I think was their initial brief, they came in and said, well, EOE did the extrapolation inappropriately, but we didn't. So all the $2 million errors, it wasn't from sampling just 4 storms, right? So when we created our methodology, right, and when we were thinking about how to extrapolate events, approximately $2 million in errors, right? That wasn't just from 4 storms sampling. We found approximately $1 million in errors in completely different storms, not the 4 that we extensively reviewed top to bottom. So the reason, and I can talk about it now, and I hope this is helpful to you as you reach decisions. The reason that EOE went into 4 storms, right? We made a strategic decision, right? And that strategic decision was, how are we going to make an appropriate recommendation to the authority based on the amount of evidence in this record that we can't look at all of, right? I don't have, like, we can't use some AI tool to read this out and tell us where these things are, right? We're Chris and Alex and I are looking at all of these things, and really Chris, to determine where are these issues. So we've made the decision, EOE made the decision, we're going to approach this to extrapolate storms. So how do we do this? We're going to take a deep dive look at 4 storms, right? We have errors in other places, right? We know that there are errors in other places, confirmed errors in other places, but we, in a relatively truncated time period, right? We've got to look at these. We must look at these so that we can find something that is an appropriate roadmap for the authority to use in hopefully making a determination. Because I think no one, and again, I'm not going to put words in Eversource's mouth either, right? But I don't think anyone is saying, right? We found carpet cleaning costs. We looked at timesheets that were a mess, right? We had to ask multiple rounds of interrogatories just to get a straight response. And sometimes it didn't even answer the question. So how do we, EOE, how does OCC handle that? And then how does the authority handle that? And I'm not I'm also not suggesting there's an easy answer. That's not what I'm suggesting at all. What I'd suggest, though, is that providing some of that deeper review on those 4 storms was how we came up with that. So that's how we came up with those different numbers. We thought that when the authority was potentially reading our brief, that you presumed that all of the errors came from, and I think that was from the Eversource reply brief, that all the errors came from our deep dive into 4 storms. That is not the case. We found approximately $1 million in errors outside of those 4 cases. So that's another area that I think you can feel comfortable with. And if you'll allow me, I'm just anticipating other questions, right? We talked about PwC. PwC, right, we looked at more than PwC did, with all due respect to PricewaterhouseCoopers. We reviewed more in depth than PwC did. And, you know, I think, right, when we find $900,000 in confirmed errors, not even in the deep dive of 4 storms, right? We find almost $1 million of errors outside of that, which is more than the PwC extrapolation error, right? Which was 700-something thousand. And then we find over approximately $1 million in errors in the 4-storm deep dive. I think that could lead to questions about the validity of the PwC extrapolation, right? That it's likely insufficient. It didn't really do the review. And so, you know, as Commissioner Beecher, you know, asked earlier, right? I mean, okay, so you adopted their testimony that was subject to cross-examination, that's fine. But I mean, it was, you know, there were right? Like, you know, my dad worked at Arthur Young in the 1970s, right? Like that, you know, they're clients, right? So the ratepayer isn't the client, the company is the client.
If I may, Attorney Lopez, am I detecting a possible conflict of interest for PwC in terms of playing both an advisory and an auditing role in this case?
I don't want to go that far. I really don't.
Well, in particular, I want to correct myself actually, because their prior testimony was incorporated here, and it's something that the company has used in the past. It was commissioned for a prior docket, so I want to correct myself on that. But nonetheless, it is the same company providing perspective. Let's put it that way. And as we know, there's history about accounting companies in this business. Those of us who are old enough to remember. So again, I'm not flagging this in a big way, but I am. But I guess I'm just mentioning it because the whole idea of auditing is to give faith, right? To give confidence and you know, provide that independent professional review. So I see it. I detect just a possible little bit of tension there. And as you said, your findings are different.
Our findings are different.
Yeah. Okay. Thank you.
On page 5 of your exceptions, towards the bottom of the middle paragraph there, it says, in EOE's experience, an 8% sample size is an adequate sample size. And this kind of gets to a question that I asked OCC as well, regarding something Eversource, I think, raised today and also in their exceptions about whether, well, first of all, I guess my first question is like, can we evaluate, what can we do with this statement that in your experience, that's an adequate sample size? Like, is that something that's appropriate for us to consider EOE's experience?
Sure. I think, you know, we're all state employees within EOE. I'd like to think you can look at Chris's resume or whatever is on file with the agency, right? We are, you know, we are a party in this docket, but we are also part of the agency. It's just from my perspective, if you have, right, Chris is a utilities examiner, right? He's an accountant, he's CPA. He's got a bunch of letters. But I think, I don't know all of them, but what I would suggest is there are utilities examiners who work for authority staff and decisional staff upstairs. I think you can rely on their potential experience as accountants, utilities examiners in understanding broad approaches to extrapolation methodology. So I think to the extent, and maybe to follow on if I'd, oh yeah, so my esteemed colleague Alex is pointing me to footnote 7, where it says, right, our sample size exceeded PwC's sample size, right? Footnote 7 on bottom of page 5 of our written exceptions. PwC sampled a total of 545 outside contractor vendor invoices during its 3 separate reviews. And so we looked at 1770. So I think, right, like sample size in and of itself, right? I think it, you know, I am just a lawyer. So, you know, outside of AP statistics, my senior year of high school, my mathematics, you know, history major, words. And so, but sample size matters. And I think that is something that I really appreciate Alex pointing that out to me. I know we've said so much, but I do think that is something that you can rely on and evaluate. And to the extent that you may ask about, and I don't know if you would ask about this, right? But you did ask OCC based on Eversource's position that they're the only ones who provided evidence in this record. So they provided evidence, right? We are testing the credibility of that evidence, right? OCC has the position to test the credibility of the evidence. We can test the credibility of that evidence, and EOE, and then the authority, right? The commissioners have the ability to determine the credibility of that evidence based on the record that has been produced. So we're not, you know, I'd like to think that we made a lot of citations. I don't remember all of them. There's a lot, it is a massive record. My head is swirling. I've been thinking about this for a long time. There's interrogatory responses that are all over the place. So I think you can rely on our larger sample size than PwC. But I think I'll leave it at that. Thank you.
Thanks. I think like the nature of my question was,
sorry,
you know, I think the question that we have to determine in response, I think, to the argument Eversource is making is, you know, Eversource is suggesting that we would need to have, there need to be some factual basis for the extrapolations that both state parties are providing. And I think what flows from that is the opportunity to cross-examine and, ultimately the question is like, are these facts or are these arguments, right? Because I'm at least speaking for myself, if they're arguments, then they're not facts, then they're not, these are just positions that can be advanced by a party in a brief. But if they are facts and they're being offered as facts, you know, I think we need to wonder like whether we can accept them if they haven't been offered as evidence. And I think like, I don't want to like focus too much on this one note in your exceptions, but I think EOE, you know, referencing its own experience is a different thing than just saying, hey, here's our opinion. You know, we looked at all these facts and here's what we put together based on the brief. I think that's kind of bordering on, you know, you need to credit our experience, and you know, it's bordering on the putting on an expert witness who, you know, although as we don't follow the rules of evidence here, should be subject to impeachment, and the party should be able to evaluate their credentials beyond sort of just what is in like what Pura happens to know as a member of your agency. So I guess how do you respond to that? I guess I just want to be clear, like, is EOE offering this? Like, should we be relying on your experience in analyzing your extrapolations, or is this an argument you're making as a position in the case?
So let me, if you don't mind, Chairman Wheel, if I could maybe step this back just for a second, right? These are, so there are facts, right? The facts are the responses that we have from the company to the interrogatory, right? Confirmed responses, confirmed errors. So that's the company's evidence. Yes, we concede to these errors, right? Throughout the record. I think, one, I think you may rely on us, but I don't think so the question of whether or not our arguments are facts. So I think our arguments are supported by facts. That is, and it is record evidence. Everything we have done here is based on the record evidence. And I think you can rely on the experience of staff who are ultimately employed by this agency.
All right. And Attorney Lopez, and you referenced this before, that we as Pura have also, experienced staff who will draw conclusions. And one would presume from the PFD that those experienced staff drew the conclusion that your extrapolation shouldn't be relied upon. So how do we square that circle?
Sure. So I think I think there's a few things. One that's possible. I don't know. I would be surprised to know, and with all due respect, right? So that's possible, right? Maybe the experienced staff and they said, all right, this is a different conclusion. The record here was enormous. The record here was enormous. I think the time from when our brief was filed to proposed final decision was not a lot of time. Eversource had, our brief was 120 something pages on top of a reply brief. Eversource's reply brief was longer than their initial brief. So there's a lot of information flowing. And so, EOE has been asking interrogatories for, a while. And I think we have, I think it's totally right. The commission can come to a different decision, right? You have the discretion to review the evidence and come to a different decision. That's conceded, of course. I think where my position ultimately, and EOE's position ultimately lies, is that I think it's inappropriate to rely on the PwC extrapolation and feel confident that you have an appropriate number. We have provided an appropriate roadmap, I think, to come to an error rate that is advanced based on a solid review of the evidence. And I think, I think that is really kind of the key. So yes, the commission can come to a different conclusion. The staff decisional staff can disagree, of course, with our conclusions. But I do think that based on the evidence provided and the experience within our team, I think we've made an appropriate recommendation and guideline for the authority to follow. Please.
And in questioning OCC, there was an exchange about it should, God forbid, we ever be presented with something this huge, and I know we're going to be looking at a lot with the rate case. The suggestion that in a technical meeting, if we are looking at some sort of extrapolation, that we should talk to parties about, in their opinion, what might be an appropriate method to extrapolate from these vast quantities of data. which are going to be presented. Do you want to weigh in on that?
Yeah, thank you, Commissioner Cheeseman. I appreciate that. So I think, so that is one of the, I think maybe the challenge with the proposed final decision was, we took it as, well, you did something, but it wasn't enough. But we don't know what enough is. And I think I think that, so if we know what enough is, we would certainly like to meet the enough standard. Again, I think, and again, I'd go back to, right? If PWC's was enough as proposed in the proposed final decision, ours was certainly enough. And I think I think, that is just something to consider as you make your decisions.
Thank you. And I just quickly, from my point of view, it's not necessarily enough, but the how. How was the data selected? How did you draw your sample size? And I think for me anyway, that is what I would want to know going into it to true, that whatever you're presenting in terms of the sample size, it would truly be representative of the body as a whole. And I think that's something worth bearing in mind. Anyway, thank you, Mr. Chairman.
That flows directly into my next question, which is, I saw on your exceptions that you argue that the PFD, I think, misunderstood how you arrived at your sample size for the 4 storms. It's my understanding now from your exceptions that the reason you chose that sample size is precisely because you picked all the storms that are in the body of evidence that occurred after the Isaias decision, and the rationale for that was that those were the ones most likely to be thoroughly documented, is what you'd say. Am I understanding that correctly?
So it wasn't, so the 4 that we did a deep dive into, and I would say, right, it wasn't just after, right? So those 4 were all after, right? Those occurred after time than Isaias. And so really, right, what we had hoped, right, our whole thought process behind this was to give, it sounds funny, right, was to give the company the benefit of the doubt, right, that okay, so, there were some confusions about Isaias. Okay, so all those storms would have come in after order number 8 in the Isaias decision. And so again, we were just hoping that okay, there was an issue, we want timesheets. And I think this is another piece that I can speak about here, right? We never wanted perfect timesheets. We never expected perfect timesheets. We just wanted timesheets. 1, right? There weren't always timesheets. But then 2, right? We had timesheets that, I mean, they were a complete mess. And so, when you're billing 8 hours of travel between Waterbury and Hartford, right? It becomes that's concerning, right? And I think the other piece of this, and I don't want to confuse the issue, but it's one way to think about this more broadly, right? If I'm paying a contractor to do, right, we all agree we want our power restored after storms, right? And we want all reasonable, prudent, and diligent, efficient effort to make that occur. And I'm recalling the testimony, and it was always like, oh gosh, these guys are working hard, and they are working hard, right? They are working hard. But a lot of other jobs work very hard, and they still have to fill out timesheets. I think maybe the critical difference is a company subject to competitive market forces would probably push back on timesheets and not rely on getting reimbursed by the ratepayers automatically because they don't have a say. A private company is probably going to look at those a little bit more closely. And I mean, private company, an unregulated, competitive company is going to look at those bills more closely and be like, wait, Yes, I verified it. Oh, how did you verify it? I can't tell how many hours you worked. I can't tell how many, you drove that many hours? It took that long to get there? That we looked about at the arborist, right? I mean, there was vegetation management happening months after storms, right? How is that an incremental cost? Why isn't that included in base rates? And I know, right, this is all part of the challenge with this, is it's so massive. It's probably better suited for a rate case, but here we are. And I think we're all trying to do our best to kind of handle this, right? I'm not sure there's not a perfect way. But I'm hoping it's, this is a roadmap.
Thanks. You just said that, so if you didn't choose all storms that happened after the ESIS decision, how did you select the 4 specific storms? And why did you exclude any other storms that happened after the ESIS decision?
Sorry, so how did we select the 4 storms?
Yeah, I mean, my question was, it's my understanding from your exceptions, the PFD said it had a problem with the selection of your sample. And your exceptions explain, oh, here's how we selected the sample. It's because it was the storms we expected to have the most documentation because they were after ESIS. But I'm hearing you now say, well, we didn't pick all the storms though that we expected to have the most documentation.
Well, so I think we chose 4 recent storms, right? So the goal was to have that they were most likely to have the best documentation, right? And then I think ultimately, and I did say this, right? We wanted to give the company the benefit of the doubt, right? In light most favorable to the company, right? So we didn't go to ESIS.
Yeah. Well,
And
I just want to
understand. So please, yes.
Yeah, what I'm trying to get at though is I understand what the exceptions say, that you wanted to select storms that were subject to order number 8 from ESIS. But you didn't select every storm that was subject to motion number 8, is what I'm hearing you, order number 8, which is what I'm hearing
Correct.
you say now.
We didn't.
So how did you pick?
Every single one.
So what methodology did you use to pick the 4 that you picked?
Just a moment.
So to come up with our representative sample, we chose the 4 most recent storms. Sorry for my voice, I'm a little cough. The 4 most recent storms, and that was on purpose, a strategic decision because there's only who you see up here. But another part of it was we understood there might be some difficulties in implementing the orders from the ESIS decision. And we wanted to account for that and provide some latitude to the company to adjust for, implementing all of these decisions. And we thought that the 4 most recent, 3 storms and 1 pre-staging event, would give us the best documentation to account for the changes that they had to make.
Okay, so the idea was you're selecting the storms that in your mind probably would be most likely to have fully implemented the orders set forth in the ESIS decision.
Correct, with a thought towards our resources.
Yep, okay. Your exceptions also talk about how the PFD made comments about it, how it seemed like EOE picked the storms that had the highest error rates. From my understanding of your exceptions, though, I think you're explaining, well, they have the highest error rates because they're the ones we looked at. Am I understanding that correctly?
Yes, that's correct.
Okay. I think that's all I had on extrapolation. I have some generator questions. Footnote 19 on your exceptions notes the argument that EOE made in its initial brief about the prime power rentals vendor. And in your initial brief, you talked about how the website for that vendor advertises 24/7, 365-day availability. I have to say, I did notice that in your brief, and that the record site in your brief, the only record site in your brief to that fact is EOE 471, and I think you raised it again in your exceptions. EOE 471, though, that website is in the question, not the response, right? Like the response that was adopted by a witness under oath provided by the company doesn't have that website in it. So can we look at that? Like, is that website in the record by virtue of EOE asking about it?
Just bear with me for a moment. I think I would like to say, yes, it is in the record. That being said, I would like to see Eversource's response, so I'd so the company did not deny that the website is correct. The response is the generators were kept on property in preparation for use. I think, and maybe in some ways, this goes to like the responsiveness of the company's questions or their interrogatory responses in the first place, right? They're not being directly responsive to the question, right? Identify why the company deemed it necessary to stage extra generators when the vendor's website states that they are 24/7, 365. I can read the responses here.
No, I mean, I think,
And
again, it's,
I guess, and to the extent that I think you can rely on it, they didn't say that the website is inaccurate. That's one. And I think, but two, I would say that they didn't answer. I mean, as many questions, they didn't directly answer, and that's maybe part of the challenge overall.
I guess it's a very, like, my very specific, probably too specific legal question is like, if it seems to me that in order to credit this argument, we need to credit the factual determination that there were generators available 24/7, 365, and that Eversource instead chose to forego that option and just kind of get generators ahead of time. But I think we're missing the first part. I don't know, as a lawyer, how do we there's a link to a website, we can maybe look at it, but that website, the existence of that website and the confirmation that that service was even available, I don't know that we can infer from just a question that wasn't itself subject to cross-examination. Can we? I mean, don't we need to have, if we're going to find a fact, that fact needs to have been subject to cross, doesn't it?
I think you're generally correct. I think your legal position is correct. That being said, we asked it, so we asked a question, and I think if mind, right, we asked them about that specifically, and to respond to identify why the company deemed it necessary to stage extra generators when the vendor's website states that they are a 24/7, 365 emergency generator rental provider with 1 hour response time, complete setup and breakdown packages, and on-site management. And the company's response is the company may prepare to have generator resources on site ahead of a storm to avoid dealing with a potential shortage from the vendor. When a weather event impacts the service territory or surrounding area, there is a possibility that various vendors, residents, or companies may also need generators. The benefit of having generator resources on site is a guarantee that these resources are available to the company for use during restoration. I would have loved for them to say, yes, that's what their website says, and this is why we, in spite of what it says, this is why we made a determination. They chose not to answer the question. We had a short timeline in this docket to one, ask interrogatories, expound on interrogatories that were unanswered. We did that multiple times. That's why there's over 1,000 interrogatories in this docket, right? So if we could have gotten a straight answer to the straight question, that it certainly would be appreciated, but we've come to expect that we're not going to get a straight answer to a straight question.
Okay, and my next question was about their response, and this is similar to questions I was asking OCC. And it's more about the framing of your exceptions, because I read your exceptions to basically say it was an error for us to not make this adjustment. Can't we just believe the company in this interrogatory response? Don't we have the discretion to say, oh, that makes sense, even if these things are available 24/7? So is it erroneous or is it just like unfortunate from your perspective?
No, I
that we-
think, and I mean, I appreciate that clarity. Yes, I would like to argue that it's an error, but I would say that if it's a mistake. But and again, I think, yes, you have the discretion to make determinations about what is on the record. But I also think, and you know, part of this is also a hindsight review, right? So now this is it a hindsight review? I mean, I don't know how we, this is vexing, I think, for everyone, right? This is why I mean, ultimately, hopefully an event like this doesn't happen again, for everyone's sake. But so yes, while I would agree with that, and yes, I think it's not like legal error specifically. I would argue, and EOE argues that we think it would be inappropriate. We're not. This is, if they have this information, we can find this information relatively simply, and having a simple response would certainly be, I think, appreciated, and I think it would allow the regulator to appropriately evaluate these things. And I think that's the challenge we have, right? It's hard to evaluate all of this, not just from a volumetric standpoint, but even from what we have based on certain responses.
Thanks. Moving on to mileage, although they're kind of similar questions. Mileage is discussed on page 10 of your exceptions. It seems, this is similar to questions that I asked OCC, I think. It seems like what the exceptions are raising is like the parts of the PFD that appear to acknowledge that we struggled with this as sort of foundation. I read essentially your argument to say, hey, since you struggled with this, you're not allowed to weigh in favor of the company. Am I misreading that's your?
Well, I think one of the challenges is and I think part of the problem is where the burden does lie with the company. And so I think that's why, right? And maybe that's the key, right? If every piece of evidence can't be reviewed, right, then wouldn't, right? Then some type of extrapolation methodology would be appropriate. And I think certainly, right, we had to propound additional interrogatories to get responses to these things, right? So I think it's a reasonable assumption, and I want to be careful about mileage specifically, right? But I think, right, we had to ask multiple rounds of interview or interrogatories, so we can, the authority, and I think specifically, of course, I'm lost at the moment, but sorry, bear with me for just a moment.
I don't know if this helps, but there are phrases in the PFD like the authority questions how supervisor can validate and approve requests for reimbursement, or the authority agrees that Eversource's mileage reimbursement policy adherence is inadequate. Is that?
Yeah, I think that's right, and I think part of what we also don't know is that, right, do we have, is there? We don't even know if there is appropriate documentation in all of those other parts of the record. I think that's maybe a broader point. And I think, to just, if we had to pull teeth to get certain responses, to help verify costs in specific areas, and then we got confirmed errors from that, but only after multiple rounds of asking the same question over and over again. I think we can make a reasonable inference that in the remaining part of the record, that justification isn't in the record.
Okay. I had a question about vegetation management, which is on pages 13 through 15 of your exceptions. I understand the argument, and correct me if I'm sort of not correctly summarizing this, to be that PURA can't look at over or under recoveries for vegetation management expenses in the aggregate across multiple years. And instead, we can only consider each individual rate year, as you call them. The only reason I add that caveat is that some of these years aren't really rate years anymore because the multi-year rate plan was over after 2020. But we need to look at each individual year and evaluate only in that year whether the company underspent on the amount imputed in base rates for vegetation management. Is that the argument UE's making?
Yes.
I was struck by the argument on page 14 that because Eversource spent less on vegetation management in 2020 than was imputed in rates, this inappropriately, I'm quoting, inappropriately resulted in a higher calculated 2020 ROE than would have otherwise been derived. Can you explain why it's inappropriate for the company's ROE to increase if operating expenses decrease?
Sorry, could you ask that question again?
Sure. The quote says that basically that the over recovery on vegetation management, quote, inappropriately resulted in a higher calculated 2020 ROE than would have otherwise been derived. So, but isn't that the way it always works? Like if O&M or any other expense is less than what imputed rates are designed to reflect, ultimately that's going to be a net increase to net income and vice versa. Like, I mean, doesn't that happen every single year that nothing's ever perfect and sometimes the ROE constantly fluctuates? Is that inappropriate is the question.
You mind if Mr. Parent answers that one specific question?
Sure. I have other questions like also about the ROE effect argument here.
Chris Parent. I think what we're attempting to say here is by underspending on the vegetation costs in the year 2020 and overspending on the year 2021, the net effect between the 2 years kind of has a disproportionate effect. So the example further goes on to point out that in 2021, when we look at the filing in 760307 RE01, the differential between the 21's ROE versus the actual operating income was about 4 million before they would have pierced the ESM level. So by virtue of them underspending in the year 20, they result in a higher ROE than because they underspent. They result in a higher ROE, but by then using the money in 2021, that results in a lower ROE there, and the net effect kind of splits the baby a little bit here. So by underspending in 2020, what we're back to is that results in a bunch of incremental costs that were then passed through the storm regulatory asset. And if those weren't passed through, various storms may have been eliminated, but at the very least, the $2.7 million would have been.
Again, I'm probably being too specific here, but I'm still stuck on the ROE impact. Are you aware that deferrals are part of the total operating expense calculation for ROE? Like, so it's not as if, like if they defer an expense, it's actually still part of gets baked into the sauce for their ROE calculation anyway, right? Whether it's in base rates or deferred, right?
Yes, but you got to remember the effect of that would then carry forward to what would be allowed to be deferred when it comes to the 2020 storms. So the 2020 storms, essentially,
Okay.
they were able to pass through more into the deferral than they otherwise would have.
Okay, so you're saying that like an underspend that results in incremental deferral, it's connected to the argument about the incentive to get to the $4 million threshold.
Yeah, I think you said that accurately, yes.
Okay, I understand that now.
Mr. Chairman, if I could just follow up to make sure I'm understanding as well. So what you're suggesting is there's strategic opportunity under these rate-making mechanisms and these thresholds?
Strategic opportunity, I guess you could call it that. I would say it's an unintended loophole.
Mm-hmm. Okay, thank you.
So this vegetation management issue, as I recall, was first. It's another thing that was kind of birthed out of the 220808 decision, if I remember correctly, that PURA applied this treatment in 220808. In fact, I believe it was OCC that recommended it in that case. And as I understood the rationale of that decision, like the reason why the PURA applied this treatment, and by treatment I mean looking at the actual spend on vegetation management in a year and basically determining if there was some amount spent under what was imputed in base rates, the bucket kind of had to be filled up before it would spill over into the deferral, meaning like the deferral would be reduced by the delta between the actual spend and imputed spend. What is the rationale for that? I understood the rationale for that to basically just be a measurement to determine like what is incremental. Like what would you agree with that?
Yes.
Okay. If we took EOE's suggestion and kind of snapped the line at every rate year for only ultimately counted and only ultimately counted over recoveries and effectively ignored under recoveries in years where those happened, how does that not start butting up against the prohibition against single issue or retroactive rate making? Like, aren't we starting to get into a world where we're saying, I mean, this is what struck me about EOE's argument is that, well, now we're doing it rate year by rate year. Now we're just sort of breaking out vegetation management expense and reconciling to it suddenly. Or can we do that? Is that going a step too far beyond what 220808 even did?
So I'm definitely going to defer to the attorneys here, but I would maybe just preempt this and say, is it not incremental? What snaps the line to determine incremental? So with that, I'm going to hand it over to the attorneys.
Yeah, and I think, that's the one. Part of the challenge, and again, said before, is, we've never done a storm docket quite so large with quite so many years. Quite so large and with quite so many storms involved, so many years and storms. And again, right, this is, I think, a challenge when we're looking at this from the perspective of rates, right? It produces a different challenge that we're doing this outside of a rate proceeding, right? Because, just like anything, right, you press one button and then there's a consequence over here, right? And the courts have long recognized that these are complicated and we have to help resolve these, right? So, right, there's not just one factor involved, but because this is so complex, it's really difficult to determine all of the other potential impacts. I'll just say that broadly.
All right, last really nerdy question about this. I guess the question is like, does your argument here get into the depth of specificity that we should even consider this, that the rate year for Eversource doesn't match the calendar year? The rate year for Eversource begins in May, I think.
No, no, it's okay for the rate year to not match the calendar year. If that's the very specific question, that's not a problem. I think when you start moving things across years, right? There could, right, as Chris said, right, there's maybe an unintended loophole, right? I can, if I calculate, right, hey, this won't trigger an ESM, right? So, and I think this is, right, I think, yes, the company does have the burden, right? But we all, the ratepayer advocate is here in this room, right? I mean, but obviously the regulator is here to balance the interests of the ratepayer and the company. I think, the company has the burden in its application here, right? But like things that the ratepayer can't do is say, hey, if we calculated this in a different direction, we can, trigger the ESM so that we can get money back. There's not an equal opportunity for that, obviously, right? And so, the company is in control. The company is in the driver's seat. And I think, we're here to generally stand, I think, in the place of competition as regulator and just ensure all the interests are being considered.
Thanks. Just one more, and then Commissioner Beecher's waiting for me to shut up. You keep referencing the ESM, and I understand that conceptually, but do you know if like Eversource was ever even close to over-earning in any of the years where these storms were?
Yeah, I think, so in our reply brief,
I'm sorry, it's written exceptions.
oh geez, all right. If you mind, just 1 minute. We did say it. Okay, so on page 14, that's our written exceptions. Page 14 of written exceptions, using the company's filings from 76, I believe that's from 760307 RE01. EOE estimates that an additional operating revenue of approximately $4.1 million in 2021 would have allowed the company to achieve its authorized ROE. Any additional revenue or reduction in expenses would have resulted in the ESM triggering to a refund to ratepayers. So had the company not incurred the excess 3.8 million of 2021 vegetation management costs, it would have been within a rounding factor of its authorized ROE. So it's.
But that's another way of saying they still wouldn't have over-earned anyway. They just would have been super close.
Would have been close, right? And again, I think these are just issues to consider.
I don't even know if this will make sense at this point, but so, for any given expense, and so we'll take vegetation management, isn't the solution in a rate year model is to normalize the expense? Not work top down from earnings and loopholes and so on, but to basically look at that expense, normalize it according to trends. And there are stationary and non-stationary trends. So you have to kind of try to give it your best guess for the in the test year adjustments to arrive at a rate year. Isn't that really the solution? Are you saying that's somehow foregone here? Or?
No, I that is right. And I think that's, that's the best case scenario. And even, right, we do this with the rate adjustment mechanism annually, right? Right, like it's been a long time since their last rate case. It's like, and again, I keep going back to that, right? 2017, it's been almost a decade. And so I think, right, like we have to be thinking about all of these things in conjunction. It's a real challenge. And again, nothing, as far as I know, nothing legally stopped the company from filing for a rate proceeding much sooner. And I'm sounding like a broken record, but I think that is maybe just a key point. And again, right, like, a RAM has this, right, and there's, ESI and ESM and all of the, right, like there's so many different, there's trackers, there are a lot of tools in the toolbox, but I think, just from a broad perspective, yeah, you do want to normalize these as much as possible to avoid rate shock and challenges. And I think, unfortunately, we're just at a place where, by the company being out for quite some time, presents many challenges.
You kind of answered my question, which is this combination of a long stay out period, plus decoupling, plus earning sharing, plus adjustment mechanisms of various kinds, and plus dynamic conditions. And we just named one expense. There's, as we know, there's a myriad of expenses. And so when you lose that opportunity to normalize, would you agree we lose something?
I would agree with that sentiment generally, yes. And I think, this is, I do not envy your position, right? Clearly we've filed written exceptions. EOE disagrees with certain proposals from the proposed final decision. I want to be clear that we certainly recognize the challenge you're confronted with. and there's so much, right? It's hard to keep, right? You start focusing on this one area and then this other area goes out of balance. And then there's this other area and then another area goes out of balance. So I know I'm talking about this from kind of a 50,000 foot perspective, but I think keeping that perspective is valuable in this proceeding because I don't, EOE doesn't want to lose the forest through the trees. And I think that's, I think that's a challenge for all of us here.
Thank you.
You're welcome.
I wanted to ask about something that's not explicitly in your exceptions, but it's in your brief, and your exceptions sort of reference tell us whatever you say in your exceptions, please see the brief, which is excessive travel and standby time, which is in section 12 of the brief, starting at page 101. I wanted to ask your reaction to some of Eversource's reply briefs arguments in response to this section. So the Eversource reply brief on page 91, I think it's on page 91. Generally, it sounds like their critique is that the analysis here is based on hindsight. They say because you're using minimum theoretically possible travel times. Eversource explained that, I know they said this in some interrogatory responses, that things like weather, the size of convoys, check-in times, et cetera, tend to make travel times longer for line crews. Do you have a general response to that criticism of your travel time proposal?
Yeah, I mean, we can you can read our brief, right? We have very specific examples, but I'm gonna pick one at random. Grattan Line Construction, MS 23C. EOE believes that this work location is in the town of Voluntown and would result in a commute of approximately 96 miles or 1.5 hours to North, I think they say Billerica, Massachusetts, or less than 2 hours after applying the 1.3 factor. Given the lack of documentation to support the vendor's actual commute, EOE must assume that the vendor inappropriately billed for an additional 2 hours in excess of the vendor's actual commute. So, that's a confidential exhibit, right? But you can kind of do the math, right? And so you're looking at a 96-mile commute that is taking 4 hours. And I think right there are other. I mean, like we laid out all of these specific examples, but I think that's part of the challenge is I don't believe that's hindsight, right? Because here, I think about it. I have another job. It's in the Navy. I have to turn in my receipts, and this is I don't want to talk about DOD or DOW audits now. That's maybe another question. But they're asking me for, hey, why did you use your personal right when you're going on orders to Bahrain? Why did you use your personal vehicle from here to fly to Providence and I had to go back and say, well, that was at 4 a.m. Well, why didn't you use an Uber? I was like, because I live in Old Saybrook, Connecticut. There are no Ubers at 4 a.m. that is going to take me across state lines to Providence to get my first flight to Chicago, that then takes me to Doha, that then takes me to Manama, Bahrain, right? So, and they're right, like they are like, this is the military, right? This is active duty reserves. They're asking these specific levels of questions of people who I think also work pretty hard in the military, just like line crews and other things like that, that have to, do important and necessary jobs. And I think, but again, I look at this and, that's an easy one. And I think that was the other kind of piece of what we were looking at. These are kind of easy. I like, how do I know you work data? Or like, I don't know, right? Or how do I know you traveled this? Like, did it really take, just a quick question? And maybe it did. I mean, maybe they broke down on the way. Maybe there was another storm.
But yeah, I guess you're anticipating my question actually, and it's funny because my question was actually about the Voluntown to North. That's up by Lowell somewhere? Is that where
That's
that is?
weird.
Because you raised this in your brief and then Eversource responded. They said, well, it's because the weather was really icy that day. They also say that you were incorrect about the starting point. So how is that different from you telling the military, like, oh, I can't, here's the reason I didn't take an Uber. So like, hasn't Eversource done that? Like, haven't they answered the question about why?
In the reply brief. And I'd actually have to look to see what evidence they cited to that.
All right, I mean, I'm just using an example.
No,
I agree. I mean, like, but if they did have like an interrogatory response that said that, would that be okay?
Right, if there are, right, and again, the invoice should say that, right? I mean, that's part of the thing, right? When we're talking about verification, right? So that's where the verification would happen, right? So I think that's, and I guess that comes back to, again, the broader point, right? So why does the invoice not say that? Why is that not include? So they say that in their reply brief after the fact, in argument, that's fine. But if you look at the confidential invoice, that's not what it says.
Okay.
And I think that's maybe part of the, and the timesheet, right? So if you take those two things together, you should be able to, oh, there was an ice storm. That's why it took 4 hours.
Okay.
No question.
Well, I have a question that maybe kind of goes the other way. Your brief also critiques, another example is travel time. There's an instance of travel time from East Hampton, Connecticut to Deep River that took 2 hours. You note that those two towns are only 16 miles apart. Eversource, in their reply brief, argue that the critique is unfair, but in this instance, they actually do point to an interrogatory response where they explained the bridge was out and crews. This is the point I want to get to. What that interrogatory response says is that crews likely, this is a quote, likely traveled on Route 9 and Route 66 in both directions. The reply brief says the same thing. And the response in EOE 1817 also says the weather and roadway limitations at the time are unknown. So if we have that on the record, if the company is essentially saying, here's what we think probably happened, what weight do you think we can apply to that?
Well, so look, I think you have to evaluate it with what you have, right? So, and again, you are the fact finder, right? You get to determine the credibility of that evidence. And so I think what we have done is pointed out some of these concerns. I think, and again, right? The key piece is, and I think this is, broadly when we, just because they said it doesn't, I'm not saying that's not, I really want to be clear here, right? You can evaluate that evidence for whatever it's worth, right? And that's where we talk about the staleness of some of these things, right? And that's why you would want these processes to indicate, right? Like, how hard is it really to fill out these invoices and timesheets? Well, these are a bunch of guys who, they work hard jobs. Yeah, I get that they work hard jobs, but they also have supervisors. Hey, what? Oh, this took 5 hours. Oh yeah, let's just note it. And then Eversource, when they're reviewing these from the contractors, oh, that's weird. Why did it take 5 hours? Get it noted. That's a pushback on the contract. Hey, that seems interesting, right? Why did it take that long to get from this place to the other place? Why wouldn't you ask? And maybe that goes back to the point I was talking about, my timesheets earlier, right? Is someone's like, they keys someone in to ask at the time so that then they can appropriately fill out the timesheet. And I think, the storms don't, they're, I get these guys we're all busy. Everyone's busy. But is it really that much of an ask to verify some very basic and specific, and again, it's not perfect. And I want to be careful here to say, like, we're not suggesting that the information has to be perfect, but what we are suggesting is that these need a critical eye on them.
Okay. I'll pause.
Yeah, and I think that's the other piece, right? They're saying without knowing, in their response, they say without knowing details of exact routes driven. They have developed a rough estimate of a possible route. So and so if you can't know, right, that's why we press, right? Have you met the burden there?
Thank you. The last couple of questions I have are about the same topic, but more broadly about the extrapolation. So your travel and standby time arguments ultimately culminated in a $20 million recommended extrapolation, $20 million adjustment that's arrived at by extrapolation. Eversource, in the reply brief, argues that your extrapolation to the entire population of storms under review in this proceeding is fundamentally flawed. I had some questions about how you arrived at your extrapolation. So first I want to kind of walk through, and I won't take full credit for Steve Capozzi helped me with this walkthrough. So just give credit where credit's due. So just to make sure we understand sort of from reading your brief, sort of what you did. So first, you reviewed samples of the 5 storms, you have 5 particular storms to determine the percentage of travel, standby, and work time that was charged by specific vendors just within samples of those 5 storms. Is that right?
Oh, you're speaking specifically about travel?
Travel and standby.
Sorry. Sorry, just a moment.
Steve, I also said your name because if this is a misunderstanding, it's your fault, clearly, on the record. So.
This is in our underlying brief.
Yes. Yeah. I'm sorry. There's a.
It's okay.
I think it's around page 101, maybe 107. There's a table.
Yes, that's correct.
Okay. So you took the 5 storms, took sampling from those 5 storms, and from those samples, you derived these percentages that, like, within those samples, it was 55% travel, 33% standby, and 12% work, right? So that was step 1.
Correct.
Okay. Then you took a look at the total vendor costs for those same 5 storms, which was about $35 million. And you noted the non-work, what I am calling the non-work value, meaning the travel and standby is likely around $31 million. And the way you got there was you applied 12%. Either way, you either applied 88% to the 35 million or 12% to the 35 million to come up with 31 million presumed is attributable to travel and standby. Am I good with that so far?
Yes.
Okay. And here's the part where I get lost. So I think the next step is that you recommend a 2.5% reduction to vendor costs across the entire population of storms, which is about 700, the vendor cost population of storms, which is about 780 million. That's how you get to $20 million. Well, first, is that right? Is the $20 million just 780 million times 2.5%?
Yes, and we believe so. Just, it's a large piece of it. We're just having we didn't anticipate necessarily going all the way back to the.
Okay.
So
my question, just not to bury the lead, is where did the 2.5% come from? How did you come up with 2.5%? In order, like, that's the driver of the 20 million. That's where I was lost.
all right, just bear with us. Thank you. So maybe we could come back to this, just to
Sure.
get on this.
I mean, a little bit. I think I'm just gonna put a little objection on the record that this is very interesting that you're getting to cross-examine on the methodology, which is something we never got to do. And I'm not sure it is really appropriate for them to be figuring out their method on the stand here while we're doing oral argument after the record is closed. But it's just, I want to continue whatever dialogue you want. I'm just marking that for the record.
Yeah, that's fair. And I will sustain that objection just like I sustained EOEs that whatever statements we get here, they need to be substantiated by the record or we are going to ignore them. But yeah, I am just trying to, this is all in EOE's brief. I'm just trying to follow the logic of the brief. So we can pause. That was the last question I had for EOE though. So if you want to pause, we can start round 2 and then come back to you. Oh, but before we start round 2, we can move on to the Attorney General's office. That wasn't intentional. And then start round 2.
I think that's fair because while we could just answer one question, that is that. We'll just do and it'll be that one. So.
Okay.
Thank you.
All right. So we'll swing back around for that and we can turn to the Attorney General's office if you have a statement or I don't have prepared questions for you, but if you have a statement, we might have questions.
Great. Thank you, Chairman, and thank you, Commissioners. We would like to start by thanking the authority and for the staff for all of the work in this docket. And we would like to adopt and echo the arguments of OCC and EOE in their briefs, their written exceptions, and their answers to questions and statements today. Our office would like to take a minute to highlight a couple of points. First, we encourage the authority to hold consistent in its initial determination on the denial of over $340 million in retrospective carrying charges. Carrying charges on storm costs prior to a prudency determination have never been allowed by PURA, and the company's arguments on carrying charges look to be a cover for pitching a new recovery methodology to a new authority. We believe that the authority provided a thorough and well-reasoned explanation in the proposed final decision, and we urge you to keep this determination in the final decision. Second, we encourage the authority to take a second look at the base costs of storms and make further cuts consistent with the arguments offered by OCC and EOE. These areas include, but aren't limited to, timesheets, overstaffing above the ERP, and materials cuts. The 3% disallowance on the recovery is striking, especially in the context of what the authority usually grants. We believe further cuts along the lines of OCC and EOE suggestions are appropriate here. We thank the authority for the opportunity to present argument and thank the authority and staff for all the work on this docket.
Thank you very much. Thank you. So we can start round 2, starting back with Eversource.
Okay, we'll try to keep this moving along because it's starting to make my hair curl. So we need to figure this out and get home. Okay. So first of all, I just would like to address afternoon thunderstorms. I can't resist in Southwest Florida because if you see a wood pole in Southwest Florida, I'll give you $5. Those poles are cement. They withstand thunderstorms. They have a lot of undergrounding because they do not underground in ledge. They underground in like limestone and pumice or whatever it is. So equating the effect of afternoon thunderstorms in Southwest Florida to here is just no equivalent. I also will note in Florida, Florida Power and Light basically has instantaneous storm cost recovery, flows through like there's no tomorrow because it's made to respond to hurricanes. So I don't know that it exactly fits here. I think we're not going to respond to all these factual issues. There's lots of lessons for the company to be learned and how it's tracking, doing things, incurring costs. We're going to take it to heart. We agree with, more than you probably think in terms of, what we can do the next time. I think Commissioner Beecher has alluded to the systems are getting better. We're talking about storms between 2018 and 23. Everything's getting better every time we move forward. The second little thing I want to say is this idea that it's always been done in rate proceedings, looking at storm costs, is not accurate. And if you looked back in the past, 15 years, back to 2009, I would guess if you did the math, something like 80% of the storm costs have been looked outside of rate cases, not inside rate case. And I'm looking forward to the day in January when we have hearings for people to come in and say, oh yeah, I think the quote was here, this is such a massive record and undertaking here, it's suitable for a rate case. So I can't wait till January when we all are saying there's so much extra time to have been doing storms, which we actually did have 2.5 years here. This last piece was 6 months, but 6 months is like 75% of the rate case time, the statutory rate case time, which we have to do the rate case in. So this idea that everything would be better and easier if we were in a rate case, I don't really believe it. And I will also say on the record that I don't believe it was ever going to be done in the rate case. I believe as soon as that rate case was filed, and this is my own supposition, it was going to get bifurcated because the whole deal was just to get that rate case in the door. I don't really believe that Pura ever was going to do the storm cost case in the rate case. It's not fair to the parties. It's too much work. So I just want to say that. Okay, so then I just would like to address, before getting to extrapolation, I just want to, just for the record, to make sure we all have the same facts. The storms are from 2018 to 2023. We filed in December 23, which was about 3 years after ECES happened. We filed $634 million. Half of that was 2 storms. Half of that was ECES and Henri. So that was all $300 million. And we did not file the second tranche to a year later. We filed in December 24. We filed the storms from 22. That was about $200 million. That was only 2 years after the storms occurred. Then we filed in July of 25 with another $200 million with storms from 23. Again, only 2 years later. So to me, this idea that if everything had gone into a rate case, everything would be different, and we've prejudiced all the parties by not filing the rate case, we reject that, for the record. Okay, that's that. Then let's just talk for a minute about vegetation cost in 2020. 2020 was COVID, and it was ECES. So somewhere we've been looking for it. We put into the record what the spending was in every year from, I don't know, 2017 to 2025. The company spent more than what was in rates in every single year except for 2020. 2020 was COVID and ECES. ECES happened in August, which is like the tail end of the vegetation cycle, knocked the heck out of everybody. And then there was other storms that came out of that. So there was a 1-year anomaly. I would just like to put on the record that going back and saying that the company should lose something, and this was one of the legal claims that we actually made in relation to UI also for the same disallowance. That's retroactive rate making. You're essentially going back and saying there's 1 year where you spent less than the allowance and rates, so we're going to penalize you for that 1 year of underspending, even though every other year you were over, and we're not crediting you with the over. So when we think about a rate case and being able to normalize potentially, let's go ahead and normalize, because every other year was over. So that's why there should not be any disallowance there. Okay, done. Okay. Let's just talk quickly about benchmarking. Just again to reorient back to the facts. So if one were to go back and look at the prior storm allowances back to the large storms, which is kind of the only equivalent, right? 2011 and 12, there was, I think the company incurred somewhere north of 400 million. They ended up, I think, recovering something closer to 300 million for various reasons, some of which was they gave up $40 million in a settlement to get a merger, and so lots of things. If you actually go back and look at the different orders on storm cost recovery since 2009, which is really the modern day period, you're going to find out that the actual allowances that the company got was on the order of 95%. We've done the math, we've done the analysis, we've provided this analysis to, just 1 second, to many parties. And the only way, to get to that 95%, what you have to do is you have to have apples to apples instead of apples to oranges. In the old days, the way we filed storm cases is we had costs incurred, that we had costs included in the filing that got denied or disallowed. And now we don't put those in anymore. So when we take them out ahead of time, for instance, we used to put in we would claim in our claim that we should be getting recovery of the vegetation management costs that Frontier pays, and we would put them in our application. And then Pura was disallowing them, so we stopped putting them in. So when you compare the disallowances here to quote unquote benchmark, you got to take the Frontier piece of vegetation out because they used to be in the filings. They would get disallowed. Now we don't put it in. Same thing with certain non-incremental costs. We used to put costs in that Pura ended up saying they're not incremental. Now we don't put those in anymore. So when you look at it on an apples to apples basis, the company had been getting 95% recovery. And why? Because I think you said this earlier, Chairman Will, when you restore power and you're using crews to do it, and you've done a good job restoring power, it's really hard to come along and say the cost of those crews, which are the bulk of the filing, are somehow imprudent. So 95%, and we're talking here 97%. So nothing is off the benchmark.
So I'd like to just add information to be able to validate the statements that Attorney Kimball just made. And so, again, you heard comparisons where the OCC and others said, you're allowing 97% here of principal, and that's much higher than prior storms. And so what she's referring to are really two key decisions. The first is your decision in 130323, and I'm reading from page 36, that final decision. In that case, we had 462 million of storm costs. We agreed to reduce it by 40 million due to a settlement as a result of the NU-NSTAR merger. So then we started with $414 million. 15.2 million was amount you concluded we should try to collect from the telephone company, from Frontier. We've removed those Frontier dollars from this case at the outset. In addition, in that decision, you said 17.8 million should be taken from O&M and transferred to capital. We've already done that in this proceeding. We've normalized those out. So this docket is limited to basically recovery of expense. So we followed the examples you gave us in those dockets. So items you identify should be capital. They've been removed from this request. And so same analysis for the reference to the final decision in docket 181112. That was the April 2019 decision where we sought to recover about $200 million in storm costs. On page 28 of that final decision, what the authority says was we had to take additional amounts for transformers and appurtenances and recharacterize those as capital. So again, we followed the direction you gave us in those prior decisions, and we've characterized those as capital. So what Attorney Kimball is saying is that when you see those comparisons, we have to dig a little bit deeper and look at the facts. And when you normalize out the factors I mentioned, the decision you reached about 97% here is in line with the prior CLMP decisions. I'd also point out as well, when you look at the final decision in our 2014 rate case, 140506, there was no disallowance of additional storm costs we sought to recover. And when you look at the settlement in docket 171046, where we also sought recovery of storm costs, there was also no disallowance there. So we think that's important to look at things on an apples to apples basis.
All right, next issue. Let's just talk for a minute about PwC. I just want to make sure we're straight here. So the company's internal independent auditor is Deloitte. It's not PwC. So the company hired PwC purposely to keep it separate from their own internal auditor. Even within PwC, however, I just want to make sure we're clear on the Sean Riley report is separate. That was not prepared. We established that earlier today. It seems like yesterday. That was prepared separately to respond to that carrying charge issue. That report in Sean Riley has nothing to do with the independent audit. The independent audit was conducted by a separate partner, walled off, Dan McGill. If we look at there's an exhibit ES accounting, so ESACC-5, sub 2, page 1 is an attestation of independence by Dan McGill. So PwC, I know the allusion to Arthur Anderson, that doesn't exist anymore. There's so many rules and ethical things that apply now. We don't have an Enron issue, I can promise you that here. Okay, so let's get to the real issue here, which is the extrapolation. And I heard a bunch of things that I want to respond to. I have some things to respond directly. So we heard EOE say, it sounds like we didn't sample enough. It sounds like we didn't look at enough invoices. OCC says, should we have done more? I don't know, but that's not the legal standard. I think what's important to remember here is it's the method that's at issue, the method of how it was extrapolated. All the questions, Chairman Will, that you're asking, those are all the questions that we had a right to ask and that Pura should want to have asked and answered before it can consider it, because without that evidence, it cannot decide. And what I hear EOE and especially saying is that this is what I heard. If every bit of documentation cannot be reviewed, then we need to do extrapolation. And I would say if every bit of documentation cannot be reviewed, we first have to look at the company's controls and processes and all of these other things that go into actions and decisions of the utility, which is exactly what Pura did, and Pura made findings on that. OCC and EOE say extrapolation is the answer. If we say extrapolation is the answer, there's two sides to the coin here. We're saying evidence needs to be in the record. They're saying Pura can do it by its discretion. I would rename that as Pura can do it by its technical expertise, which it does have. And under the law, Pura does have the ability to make decisions and make judgment calls based using its technical expertise. That's why it's set up as a specialized agency with specialized expertise. However, I think if we just actually referred to some case law on some of this, we would find out that, in fact, there is case law in Connecticut about when an agency can use its technical expertise and when it should be looking for outside for expert testimony. And I'm going to refer to Feinson versus Conservation Commission. It's a 1980 case. It's 180 Connecticut 421, which is a Supreme Court case. And this was a case about looking at some pollution controls that the commission was looking at and whether or not they needed outside testimony. And basically they concluded there that there should have been some outside testimony, but I am not sure I would equate what they were doing to what Pura is doing. But what the court said there is if an administrative agency chooses to rely on its own judgment, it has a responsibility to reveal publicly its special knowledge and experience, to give notice of the material facts that are critical to its decision, so that a person adversely affected thereby has an opportunity for rebuttal at appropriate stage in the administrative proceedings. Now, one could say that if you had made a decision in the draft decision to extrapolate, that this would be that chance that we would have to rebut that. But I think what this says is at the appropriate stage of proceedings. And this is so factual and this is so significant that for the agency to just be able to rely on its own discretion here, I think is questionable. And I also would refer to another case, which is also a Connecticut Supreme Court case, Jaffe versus State Department of Health, where, again, they were looking at what is the proof that the commission needs to make its own decision. And they said the commission is an administrative body, and even where it acts in a quasi-judicial capacity, it's not limited by the strict rules of admissibility of evidence. However, it says, but the more liberal the practice in admitting testimony, the more imperative the obligation to preserve the essential rules of evidence are. In such cases, commissioners cannot act upon their own information. All parties must be fully apprised of the evidence submitted or to be considered and must be given opportunity to cross-examine witnesses, to inspect documents, and to offer evidence and explanation of rebuttal. In no other way can a party maintain its rights or make its defense. And so it goes on before there, and it's after that. And it says, without this requirement, then the commission could say that a manifest deficiency could always be explained on the theory that the commission had just used its own judgment. So there's a balance. There's not going to be a bright line here, but this is very factual, what they're trying to put in front in terms of the, now, in our reply brief, we had our resident expert here redo the math, Mr. Brendan O'Brien, who used to work for Deloitte, and we redid the math and showed that there was errors in some of their math, and it came out to a lower error rate and even lower than what PwC found. So should you be accepting that? That's not in the record. It's not facts in the record. I'm not sure that you would feel, Pura should feel comfortable saying, writing, oh, well, they argued this, they argued this other math. The whole fact that we're arguing about math outside of an evidentiary record is problematic. It needed to have evidence. It needed to have expert testimony. So when OCC asked what more could we have done, they could have put on an expert and put the evidence. And while they do not have, I totally agree, they do not have an obligation to put an expert witness on. But if they don't, under rules of court cases and of evidentiary rules, they run the risk of not getting their case, not getting the proposition that they're trying to prove accepted, because there is no evidence on which Pura can rely. So a couple other comments that were made. The records were disorganized. The records were not disorganized. In fact, they were so organized that EOE could do the examination it did and find what he did. So I would really think that I would want to dispute this idea that it was disorganized. Also, I heard OCC say the timesheets were one and done. We had a more obligation than one and done. The company's efforts to get the timesheets filled in were not one and done. That's not accurate characterization of the record. So let me just make sure I've covered everything. I would say one more issue is if there's all these dispute between what PwC did, we offered up witnesses to testify to the PwC method. We got no cross-examination on that. So if there's all these disparities between what they did and they did so much more, EOE did so much more than PwC did, why didn't we get cross-examined on that? Why didn't the witnesses get a chance to answer why, though, technically speaking, we had CPAs here. EOE says it should be believed because it has a CPA. We had CPAs. This is exactly why this kind of thing has to be on the record during the record. And I think going forward into the rate case, it concerns me, this idea that we can come in on reply briefs or come in on initial briefs and have these heavy-duty factual issues that we're saying, oh, you know what, Pura, you could have done it. You could have stopped the proceeding in the middle, and you could have somehow put out a notice that you're going to decide a rule that couldn't possibly be announced by Pura. It's very fact-specific. It's very situation specific. There's not going to be one extrapolation rule that applies to all cases. And to the idea, talk about burden shifting, the idea of throwing it over to Pura and saying you should have stopped the proceeding and do something is absolutely just unreasonable and improper. If a party has a point that they're trying to make, they need to consider putting the evidence in, or under the law, they take the risk of an adverse ruling, which is what has happened here.
I'd like to add just on one particular topic, and I want to say thank you for your indulgence today in letting us have these oral arguments, and I'm respectful of your time, but this is such an important issue. I want to make sure I supplement what Attorney Kimball said. The single largest disallowance being proposed by the OCC and EOE are based on extrapolation. If we look at footnote 32 of your draft decision, you say the authority estimates that EOE recommends approximately 75 million in extrapolated reductions, and OCC recommends upwards of 275 million in extrapolated reductions. And the exchange between Chair Wheel and EOE was very important today, because what you were hearing was the commission saying to EOE, what exactly was your extrapolation methodology? Well, there was no consultant that was hired. There was no witness who was offered. That's a factual issue in terms of what is the right methodology to be used to extrapolate conclusions based upon evidence in the record. And we've heard about it, as was said for the first time, really, in the brief after the record closed. And why is that important? Because if we look at case law, I'll give one citation. So it's 95 Connecticut Appellate 505 at page 517. Courts distinguish between arguments made by attorneys and their assistants in briefs as compared to evidence. So the fact that they're making extrapolation arguments and assertions in a brief is just that, it's argument, but it's not evidence. Why is that important? Because as the authority and your legal counsel know, General Statute 4-183J says the authority has to base its decisions upon substantial record evidence. You have no record evidence from a witness that said this is the appropriate extrapolation methodology to use, because EOE and OCC never hired consultants to be able to do that. It's also important to keep in mind that I want to turn back to the question of, well, how do we do this in the future? Well, I think one case that's instructive would be, let's actually go back maybe 15, 20 years ago to a case in front of the authority that involved an issue over how you use statistics and looking at data. And that was docket 07, 03, 07, 01, RE03. That was a case that involved whether or not the authority had sufficient confidence in data that was being used to award incentive payments to the company. And what did the parties do in that case? Well, the OCC, the final decision shows, hired an expert named Paul Chernick, who offered his opinion on things like margin of error analysis, calculation methodologies. He was subject to cross-examination. We hired a PhD on statistics. I believe it was Dr. Wright. And the authority hired a consultant called Christensen and Associates, who also offered their opinion. What that illustrates is when there are factual disputes, like what is the right way to look at statistics and to use those, that's a question of fact. And it needs to be sponsored by a consultant who offers an opinion who's subject to cross-examination. I also cite to that case because we took an appeal from the DPUC's decision. It went up to Judge Satter, and you can see the decision at 2010 Westlaw 797-137. It's a February 5th, 2010 decision. And what Judge Satter said was the fact that the agency relied upon analysis from a consultant who he had no right to cross-examination was reversible error. That's what you'd be doing here if you were to now conclude that legal arguments made by EOE and OCC in their briefs have the weight of evidence. Well, it's something we never had a chance to cross-examine because we saw it for the first time in this contested case in their legal briefs. Another important point, which I think is helpful, and the authority recognized this, when you looked at the evidence given by PricewaterhouseCoopers, you recognize that for their analysis, they actually cited two standards that show there was some rigor and principle to the way they interpreted the data. And the record shows in Exhibit ES-ACC 5, Supplement 2, at pages 42 to 43, the PwC followed the American Institute of Certified Public Accountants, or AICP, standard ATC Section 205. And Section 205.32 actually goes into detail about how they perform sampling for the work they did. That's what needed to be done by the EOE and the OCC if they wanted you to evaluate a methodology for extrapolation of data. They made a strategic decision to not do that, and they've deprived you of record evidence upon which you can rely to justify the extrapolations they're proposing. They made argument, that's not evidence. And the last point I want to make on the extrapolation issue is we think the draft got it right, and I'll point to one example. If you look at pages 109 to 112 of your draft decision, you're reacting to an argument by EOE that says, we found an error in the invoicing from MidCon, and therefore we propose a $47,000 disallowance. And you said, we'll look at that information, and we agree with that. But then the EOE said, we want to take it one step further. We think we should extrapolate from that a total disallowance of $1.2 million. And what you said there was, there's not sufficient information in the record to justify making that evidentiary leap. You looked at that one example and said, we agree there's an error, there should be a disallowance. But there is not record evidence that we had a chance to cross-examine that justifies making the evidentiary leap to then disallow a larger amount. So you got it right. When they offered evidence and you agreed with that evidence, you achieved a disallowance. But there was not evidence to justify making the leap to disallow larger amounts based on extrapolation. So Attorney Kimball and I are happy to take any further questions you have to help you deliberate over the various points raised by the parties.
I'll just have one last issue, very small. But I think Attorney Minikowski did actually, I agree with something he said that is kind of important more for potentially for Pura. But I do think he said earlier that does matter. I think a stronger decision that can protect itself in court is one that says, when I read the order, and when I read things like, yeah, we recognize that there was a problem with standby costs, whatever, I can see this and I hear Chairman Wheel trying to be very fair, people trying to be very fair. We considered both sides. But when the order tends to create a either-or situation and then says, but we're going this way, it's not so much a problem for the parties, I guess, depending on how the issue comes out, but I think it does make the order stronger, and I think Attorney Minikowski pointed this out, to just say, we disagree, and then provide the explanation as to why. I noticed this a little bit too in the Aquarion change of control, where we're trying to be very fair and acknowledge both sides, but I've seen in Massachusetts, where in Massachusetts, the cases go right to the Supreme Court, they skip the other, so you tend to get this like really heavy-duty judicial review right away. And there have been orders that have not been able to stand up from the commission, where the commission is kind of saying, hey, we had kind of like a difference of opinion internally, and it could have gone this way or that way. And it's really good guidance for everybody. We'll take it. We'll take the guidance so we can get better the next time. And I will say, after today, our game is going to have to come up quite a bit. This has been a very challenging and awesome experience, but it clearly means a lot what we say in these the briefs, and you're paying a lot of attention. I can see, I bet we all feel that we need to be much more precise and thorough on what we're saying. So thank you for that. I think that having the guidance come back at us and it firmly saying we agree with this or not, and here's why, we'll all take that, because it makes your orders stronger for the decisions that you've written. If just trying to respond to your question on that.
Thank you. I did have one question, and I recognize the time. I also have to go home.
Me too.
I guess, I've struggled with this. I've seen like different iterations of this argument before about like when evidence needs to be offered as opposed to a position being argued. And I get a little hung up on it, not to make this about me, but like I used to be a public defender in criminal court. This was rarely an issue because you couldn't have opinion testimony anyway. So like the question of like what evidence was, did you see the cop run by or not? Like that's the fact that we had to find. And the opinion was the argument at the end of the argument at the end of the trial, or what you put in your brief. Here, that in this room, that line gets constantly blurred because 90% of the testimony in here is opinion testimony that would be objectionable in any court without, sufficient qualification of the witness. But I just don't know, like, can't a party evaluate the facts in the record without kind of offering their own facts and say, hey, we looked at all this stuff, here's what we think you should do? Like, do they need to have a witness on the stand in order to do that? Like,
I completely agree with that. No, we do. Well, the company does it just as well. And this is considered to be a sophisticated parties that are participating. There's technical knowledge. So no, that doesn't mean you need to have a witness say for every single thing. The company does it all the time. We have to take the facts and we have to draw them together and make conclusions. And of course, OCC and EOE have every right to be advocating any number of things. I think what's different about the extrapolation, it's a method. It's more than just kind of gathering things together and drawing a conclusion. I think when we just heard Attorney Lopez, and I'm not going to respond to it. It is what it is. He says they could have done timesheets this way. Somebody could have written this down. Like, those are all legitimate arguments for him to be saying, we think a reasonable person, a reasonable utility manager would have asked or would have written it down. That's totally legit for him to have that opinion. We may not agree with it. It may be hard to sit here and listen when we know so many other facts, but that's his right as a party to do that. He can make judgments about what he saw in the record, and he can characterize them that way. I think what's different with the extrapolation is it's really twofold. It's a whole method with a whole lot of dollars attached to it. It's not just whether or not you're going to have a generator, whether or not somebody traveled from Voluntown to here. And have you ever been to Voluntown? Like, because it's almost in Rhode Island. but It's not like that. These are major cost disallowances, major decisions with multiple dimensions of things that can be off in a method. That certainly goes beyond a lawyer being able to, and I think if it was something the company was doing, taking its expert O'Brien and saying, hey, let's extrapolate from what they did, I would guess the first thing we would hear is there isn't any evidence supporting it. I think it's that. The other flip side of it is we put witnesses in. We had witnesses to support the audit that was done, and there was no cross-examination either. Like, there is some obligation to build the record in support of a claim that's disallowing tens of millions of dollars, and I think that's where the difference is.
Okay. Anyone else have questions for Eversource?
I'm feeling that pop a balloon because my question is off topic a little bit. So I'm just trying to wrap my head a little bit more on how you classify single events, kind of going back to the multiple day events. EOE presented in their briefs and their written exceptions. So June, I'm just going to use the most recent example because it's fresh in everybody's mind. June 30th to July 5th, the governor declared he activated extreme hot weather protocol. Would everything that happened that week be considered one event?
I think it is important to take into consideration that the determinations are fact specific, but I think that the record shows, and in particular, if we look at, for example, the storm being referred to, which was MN23T, right? When you have a period of prolonged heat, that in and of itself, the record shows, causes outages to the system. And then when you exacerbate that by significant thunderstorms, it is one continuous weather activity. And then when we have additional information like the governor declaring a serious event or other information, it validates the fact that we treat that as one continuous event. We're not mobilizing and we're not demobilizing our resources to respond. But Attorney Kimball, you can add to that.
I'm just going to differ just a little bit, the answer there. Okay. So actually in the rate case, we have actually put some stuff in on heat events because we're struggling with the same thing in Massachusetts. So not every heat event is going to be a catastrophic event. There's certain circumstances that kind of combine together to make it become. So I don't think the company's position is that every time you have hot weather over 4 or 5 days and the state, calls an emergency, that's necessarily going to be automatically an event. I don't believe that. And I think this is something we'll address in the rate case. As to last weekend, I don't think it would have been any event if there hadn't been this very violent thunderstorm that happened. I think the company was actually on a good road, had several days of hot weather with nothing going wrong, but when that thunderstorm hit, it was so violent. Of course, it caused significant damage. So in and of itself, that will, I'm guessing, because of the number of the crews that came in, I don't know this, but I'm guessing that will show up as a catastrophic storm, but not so much because of the heat, Vice Chairman.
I guess now Tom, you need to stop me if I'm getting into anything, but that's kind of just the line of the questioning because July 1st, right, there was a small thunderstorm, maybe 1,000 outages reported by the company. So I think that kind of differs.
Right.
That's the basis of the question is getting to EOE's question of like combining heat events. It's
right.
And a couple days go by, then something else happens.
I don't think that I will argue, but other people do not agree, and that's fine. That some events may look like combining, but they're not because it's all kind of, and there's more things going on the system that are all combining together. This past weekend, if it wasn't for that thunderstorm, I do not think you would be seeing any presentation of a significant event. I think it was the thunderstorm that is now triggered a very significant response and has met the threshold. But I think without that, you would not have seen it. And if your question is, will it include the days leading up to it? I don't know the answer to that because I don't know all the underlying how pieces fit together. But my guess is the answer to that is no.
Okay, thanks.
Thank you for your question, Vice Chairman, because I think this is really going to be important going forward. And so you're saying like, so an event could be embedded in a larger atmospheric event that's not classified as a storm, but that would define the boundaries of that storm event.
It is, I hope I'm not getting in trouble with my friends from electric operations, but it is the fact that the heat events promote thunderstorms. It
Right.
is the combination. I doubt that you would ever just see us come in with just heat and no thunderstorm. But when the thunderstorms are happening, and what happens is you have to look at the circumstances as a whole because it starts triggering enough outages that you have to get outside help. And that's really like, that's what we've been saying in Massachusetts also about what is a heat event. It's not every time there's 5 days of heat together. It is not. It's when the combination of things that happen, the way the heat happens, when it happens, where it happens, where the thunderstorms happen, when it starts coalescing into one set of circumstances that then drives the need for these excess resources.
Got it.
Yeah.
Extreme heat obviously puts other stressors on systems, but we're talking about
Right.
storm events. And then Attorney Pace, you mentioned quickly mobilizing, demobilizing. Is that like a definitive decision? Like somebody presses a button, we're mobilizing, somebody presses a button, we're demobilizing. And so then all of a sudden, an hour later, oops, mobilize again. Would that define two events if that happened?
I think in our view, it's an important factor you should look at when we come to you and present for your consideration an event that we think is catastrophic in the example Attorney Kimball talked about, which would be a prolonged heat wave coupled with thunderstorms coming in every day. I think if we speak to our professionals who are here in the audience, what they would say is it's very inefficient if we have to mobilize and demobilize. And the fact that we have continuous mobilization, continue activity, we're not opening and shutting the EOC, that's further indicia or evidence of the fact that we treated that from the way we run the business as one continuous event.
Okay, so, and you kind of answered my question that you think about efficiency in the context of that, but then don't you also take a risk that you decide, let's not demobilize because we heard there might be a second event or a continuation of this event, but then you've actually sort of maintained mobilization unnecessarily. That raises an issue as well, too.
Well, I think ultimately we recognize the standard's going to be, did we make reasonable judgments based on what we knew at the time we made those decisions? So we're always subject to your prudence standard. But when the team is running an event, that's what they're making their decisions based upon. And so they're not trying to prolong an event. What they're trying to do is to make sure that they can respond in a prompt way to address the outages they're experiencing. And I think from their experience, they can say it does happen where you have situations where you have that prolonged heat coupled with the thunderstorms. But again, their decisions are based upon what they're seeing in the forecasts. But Attorney Kimball, you can add to that.
I would think that OCC and EOE would agree, this is an area ripe for some more parameters for the reason you're saying.
And just one last, because I
Yeah.
realize we are going so long, but I mean, would it be helpful for us as, state agency to have an authoritative reference to, what constitutes an event, like the same struggles in like droughts. When does a drought begin and end, right? And there's a whole bunch of professionals that think about this stuff and they've got a bunch of metrics and, and I'm wondering if we need something like that can be sort of a benchmark or a reference point for
And I
us.
think if you look in our rate case testimony, you'll find that that's kind of along the lines of what we're proposing is some objective guideposts as to when there might be a field that's defined.
All right.
Yeah.
Thank you very much.
Okay, it's 4:10. We've just started round two, so gonna
You
move
told
it.
me one time you didn't care if this was going to go 10 hours.
Yeah, I'm starting to feel less like that. OCC, you want to take a second round?
All right, thank you. Thank you, Chairman. I'll be brief because there's a very hungry cat waiting for me at home. So I just wanted to respond briefly to some of the carrying cost arguments that we heard presented by Eversource Counsel this morning. The 2006, pardon me, The 2006 OCC against TPUC case, that's one of those cases that seems to just come up over and over again because it was a landmark case on the Supreme Court reviewing utility regulation. And I think in your colloquy with Attorney Kimball, Chairman Wheel, you got it right. In my read of that case, I do not read it to say, what Eversource is alleging it says here. There needs to be some reasonable assurance, some guarantee of future recovery for those costs to qualify for carrying charges. And then to follow up on that point, we talked about earlier today the UI's appeal of the 220808 rate case and the Superior Court's decision where it addressed that carrying cost issue. And that is good law. That's not changing. The appellate briefs in the further appeal of that case were filed in January. It's scheduled to be argued before the court the first term in September. And UI did not re-raise that issue for higher level judicial review. It's not going to come up again, even if that case goes to the Supreme Court. So that part of the Superior Court's ruling about how PURA treated carrying costs in that decision is good law. I mean, the PURA should feel confident in relying on that aspect of the Superior Court decision because that finding is not going to be disturbed on further level appellate review, which focuses on other issues that UI had raised in that case. And with that, I think I'll turn it over to Consumer Counsel Coleman.
Thank you. And I know it's late, so I'll just make a few concluding remarks first. Thank you to the Commission and authority staff for not just the robust discussion today, but the very thorough PFD. I want to thank my team for the enormous effort that has been undertaken here. I think we are all feeling the impact of the enormity of reviewing, 43 storm events over the course of 6 years that go back 8 years. And I think if we're all disagreeing on a lot today, but we can all probably agree none of us ever want to be in this position again. So I appreciate the PFD's acknowledgement that, in addition to what appropriate disallowances, there are some process, procedural documentation reforms, and know we'll have further opportunity to provide input on that through Eversource's rate case. I think the length of this oral argument reflects the significance of this case. There is a lot at stake here, as has been referenced throughout today's proceeding. In the face of climate change and these increasing storms and heat waves and winter storms, we're certainly going to be, we're in a position where storms are definitely going to be more frequent, and we've seen that trend, and that has made costs increase. But given, the frequency in storm costs the frequency in storms make cost increases inevitable. It makes it even more important that the responses to those storms and the costs are scrutinized appropriately, and that Eversource is held to a high standard with respect to cost containment, efficiencies, strategic spending. And I think, as has been discussed at length here, Eversource had the burden of proof to demonstrate its spending was prudently and efficiently incurred to benefit customers. We have demonstrated through the record produced by Eversource that there were many uneconomical and imprudent decisions. Even without extrapolations or admissions by the former company president, the record does not get us, in our view, to Eversource being entitled to 97% recovery of the underlying costs. We've focused a lot on timesheets here today, but timesheets are not the only issue. Our brief, EOE's brief, the other state parties' brief outline other significant issues, including staffing above ERP levels without documenting the justification, incurring unnecessary standby charges, excessive travel charges, like the 2 luxurious private jets that we provided a picture of in our brief to get vendors to and from Colorado to work 2 days while local workers sat idle, entering contracts with unreasonable terms like paid, double time pay and exaggerated travel time, compensating vendors at mileage rates higher than those permitted by the IRS. I do want to bring it back to the broad record here that Eversource has to be held accountable for the decisions it makes when it spends customers' money, even in the face of catastrophic storms. And I know we've heard in the media and elsewhere that, well, if Eversource doesn't get full recovery here, well, we'll never get our lights turned back on after the next storm. And I don't think that's fair. I think that's an untenable premise. Eversource has, the exclusive franchise here. It has a duty to serve to the best of its ability, and I'm confident it will, regardless of the outcome of this adjudicating these storms. So, we urge the authority to take another look at the evidence and the lack of evidence in the record, rather than giving Eversource the benefit of the doubt at the expense of customers. And we'll hope that, the final decision does reflect that burden, and ensuring that Eversource is proved by a preponderance of the evidence that every dollar it spent was prudent, and consider a bigger cut to reflect the fact that we don't think that's happened here. Finally, as Attorney Minikowski referenced, we do hope the PFD remains the same with respect to carrying charges. It has solid legal reasoning. Attorney Minikowski referenced a few of the relevant cases. The precedent is clear. Eversource is not entitled to recovery of retrospective carrying charges, since the authority did not explicitly authorize it. There is, we've talked a lot about the 220808 decision, but the 2018 storm decision from the prior PURA also very clearly found this was the state of Connecticut's regulatory practice. And we've also talked about the timeline of Eversource's filings and the fact that for a long time they reflected that reality as well. And aside from the legal standards, I think we have to think about it in terms of a fairness issue. Because of that timeline we've discussed, Eversource has reflected that they did not feel it was in their best interest to file a rate case, but that decision should not be to the detriment and the cost of customers. So if the authority's longstanding practice of not permitting carrying costs unless specifically authorized prior to the authority's longstanding practice of not permitting carrying costs unless specifically authorized prior to a prudency determination does protect customers, because the opposite, permitting carrying costs to accrue prior to that determination, would allow the company to control how big that interest bill gets, right? It would perpetuate this practice that has transpired over the past several years of a utility choosing when it's most strategic or beneficial for them to file, but that means those costs continue to accrue. And then according to, Eversource's theory, as I understand it, customers still have to pay that bill for that business judgment decision. And that's certainly not a fair and just outcome for customers. So we do hope the authority will continue to protect customers by upholding this standard in this decision and in the future. That will be incredibly important. So thank you. Thanks to all of the parties, to my team again, and we'll look forward to reviewing the final decision at the end of July.
Thank you. That end of July is so very soon. For those of us who have to write the final decision. I had one question, Attorney Minikowski, specific to the UI decision from Superior Court. It's the same question I asked Eversource, which is in acknowledgement that the Judge Budzik's decision itself, there's just sort of a section that kind of wraps all the deferral arguments that existed in that case, which were inclusive of the vegetation management issue, some other environmental remediation deferrals, but then also the carrying costs on storm issues. It doesn't actually even break those out in the decision. It just sort of says, with respect to deferrals, I find that, I'm paraphrasing, but I find that PURA got it right. But as I referenced before, I've read the brief the UI filed, and it does brief this very issue, the issue of recovering carrying charges from incurrence up to the point of prudence. Can we legally, obviously we can look at a court decision as guiding precedent. Can we consider what was briefed before that court in analyzing sort of what the court meant? Or do we just have to kind of take the somewhat vague portion of that decision for face value?
Thank you for the question. I actually think the appropriate thing to do there was where the court simply has a sort of conclusory statement like that that says, this is fine, I'm upholding it, is actually to look back at the Pura decision. Because that's ultimately what the court is doing there. It's saying what Pura did here, or what any administrative agency, regardless of the procedural posture, where the court doesn't fully spell out what it did and just said, we've reviewed the record, we've reviewed the arguments and the administrative decision below, and this is in accord with applicable law. What stands there is the reasoning in the agency's decision. So I think that would be appropriate to refer to in that case.
Okay, last question. I don't know if you heard Attorney Kimball had a response that was a different case. There was a slightly different set of, it wasn't exactly the same circumstance where like I think UI was actually booking its carrying charges. So there were some factual distinctions. What's your response to what I understood the suggestion to be, that we should take that into consideration in determining whether it's applicable at all to this case?
Yeah, is that case 100% on point to this one? No. There's some of the same themes running through it, but it's not a directly comparable case. Luckily, that's not the only case on this that exists. I mean, there's the various other cases that have been discussed here today, Aquarian and OCC2, that address the same issue. And in those cases, the Supreme Court gives some pretty clear and extensive guidance on how the authority should approach these types of costs. And despite the many rate case appeals and other administrative appeals in recent years, the court hasn't revisited those decisions, those early 2000s OCC against DPUC decisions. I know Eversource has brought up the footnote in Aquarian, but all of that footnote does is quote OCC2. It doesn't create any new law or announce a new standard. It simply reinvokes a standard that the court had announced, almost 2 decades prior and hasn't seen fit to revisit at this point.
Okay. Thank you. Anyone else? Okay. EOE is next, right? Yes.
Yes. Chairman, we'll have Mr. Parent respond, and then I would just like to make a few, not remarks, mostly just an administrative note that I think will be important for the record broadly, and then a few thank yous.
Thank you. So Chairman Wheel, you had asked the question with regards to the $20 million, and I apologize for not being immediately ready to answer that. So appreciate a few minutes to actually come back to the brief and kind of explain. Page 101 actually has a section, inefficient and excessive vendor billing. That's the section that references the 20 million. When you follow that section through, there's actually a number of different individual arguments that we're making where we provide specific examples. So section A, right underneath that on the very next page, it starts off with quite a few different examples that are tied to our belief of the excessive travel billing tied to what we observed in the record. When you fast forward your way through to page 108, we summarize the subtotal of all of the excessive amounts that we believed we observed in the sample that was involved. And that generally did include the more recent storm events. It's what EOE had specifically sampled. And then we were also continuously reviewing the records. So some of these do include OCC responses. So the next section is a kind of a furtherance of excessive billing that was tied to bringing on crews for the right of first refusal for non-storm events. We just provided some details there. The third section is one regarding excessive billing for standby, where we also then list off a number of instances where, again, we're citing to the record for more informational purposes. Once we then take each of those, once we kind of put that aside, we also posed a number of interrogatories to the company where we asked the company to provide an analysis with regards to the amount of hours that were spent on travel, standby, and work. And that's what you're seeing on table under section D on page 114. So just using that analysis, and we admit that that analysis is limited, very much limited to only a few storm events. At the top of page 115, you see ratios tied to travel, standby, and work. And what it shows is about 89% of those specific storm events are tied to what I'll call it as efforts not tied to actual remediation effort. So the table 35 is taking the total costs from EOE 838 attachment 1 And what we're then saying is when you look at the totality of all of these things, we are recommending a $20 million reduction. It's not based specifically on the 2.5%. It's based on adding up all of the observations and knowing that that is also based on a sampling. So if you were to solely take the tables 34 and 35 on their own and assume 89% of the 35 million just for those events where there was non-productive time. I'm not sure if the company would agree with that term, but I'll say travel, time not associated with work. That would equate to, I think it's about $31 million. We know that some of that is necessary hours. So what we were trying to do is come up with something that is a reasonable proxy. And we came up with a 20 million. There is very subjective. There's a lot of subjectivity in that, and that also doesn't apply to all of the other events. So the 2.5 is really a byproduct. It's an output. It's not necessarily the factor used. Thank you.
And just an administrative note. So I think most people in this room know that on July 23rd will be my final day as the EOE director. July 24th, I will begin as the agency legal director for PURA. So with that said, for both the company and the commissioners, I will not be speaking to the commissioners or decisional staff. I'm just wanting to note that for the record clearly about this proceeding. All right, so yeah, so thank you. And so with that, I also wanted to just note my thanks to Chris and Alex for their really just tireless work on this proceeding. I think, just looking at what has been propounded over the last, several months and briefs, reply briefs, written exceptions, my hat's off. My hat's off to them. And then I just wanted to say, because, and finally, just a broader thank you to EOE and then the people who have worked for me. 4 years ago, I was, got sick, and people like Attorney Wyman and Attorney White really, yeah, so that's all.
All right. Thank you to EOE. Any questions? Okay. Attorney General's office.
I think you've heard everything you need to from our office. Thank you to everyone for their hard work on this docket.
All right. Thank you very much. And like I said a couple times at the beginning, our regulations give the petitioner the right to open and close all of our proceedings. So Eversource, you have the last word and you can use it however you like.
I think the good news is I'm going to be very brief because I know you've had a very long day, and thank you for your patience and your work through this. So I want to start on behalf of all my clients and on behalf of Attorney Kimball for thanking all 5 commissioners and your staff for the very hard work that you had to spend on this docket. It was not an easy undertaking. I know it's very difficult to be a decision maker and have to sift through the competing viewpoints. And we hope that today's discussion was helpful in your deliberations. I also want to thank the other parties for their hard work. I recognize we don't always disagree, but they worked very hard in the docket. I want to thank them for their contributions. I think it helps you make a more informed decision. I do want to go back to something which is important, because we've heard people talk about the fact that we never had enough time in this docket. But I'm just going to push back on that very quickly to say 83% of our costs were filed 1.5 years ago, which is basically a rate case and a half. And so also we had 1,738 data responses. So we think there is a very substantial record in this docket. While we respectfully disagree with the disallowance of the carrying charges of $397 million, we want to thank the authority for recognizing that the single largest disallowance being proposed by EOE and OCC is based upon improper analysis. That's legal argument, it's extrapolation, it's not record evidence, and you properly reached the conclusion based on the law that you should not rely upon that. So I want to thank you for the opportunity today. I hope it's been helpful. We appreciate it.
All right.
With that one. Have a good weekend.
Yeah, everyone also have a, I even forgot it was Friday. Have a great weekend. I'm just pulling up as we do this every time for some reason, to pull up the next docket events. The very last one, as I'm sure everyone knows, we are on schedule to issue a final decision on July 29th for the regular meeting vote. So we won't see you again, and you'll see us on the YouTube on that date. Thank you very much to everybody.
I'd also just like to thank our court reporter for the long haul today.